senior most respectable judges, but in the end, just 3 judges block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. So you kindly note the question and you address it at an.
And I will go even further than that,
And also a supplementary question connected to this. Earlier, the justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. If this argument is accepted, then the earlier traditional model would be acceptable to you, that one person can actually control the outcomes of the cases by constitution of benches, and this probably was the mischief that the Parliament wanted to address.
If I may add, there is a judgment of this court and the judicial pronouncement on that as to what procedure would be followed by the Chief Justice to invoke jurisdiction of this court under Article 183. And it says where a bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of public importance affecting fundamental rights, they may recommend to the Honorable Chief Justice that a bench be constituted. And the Honorable Chief Justice, after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would recall reasons why he thinks he disagrees with the recommendations, or thereafter he can proceed. And so there is a judicial pronouncement on that already in place.
In fact,
Sir, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what the supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power.
Yeah.
But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the 3-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this, so this is not a question of composition of benches. That is power universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? Question is maybe noted.
And
you don't have to answer.
No, I'm not answering.
Carry on.
I'm not answering.
The Honorable Chief Justice said you carry on with your submissions. Just note the question.
This thing, I may add one thing to it. It also deprives me of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I am being condemned. I am not being heard.
Who is
the
that?
party is not being heard.
Who is when you're using the word I? Who is the I here?
Litigant. The litigant. Because
एक सेकंड सर तहम्मुल the litigant, that leads me to another question. Are your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at Section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
Well, let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner and I'm saying this thing that we brought this petition
In
the interest.
You got the answer, Now please proceed. I've got the answer.
In the interest that the law should take its course. The constitution must be upheld. And I am also saying that I'm sure with such eliminaries sitting there, the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please.
We
are not going to platitudes.
I will not make a political speech.
Khwaja Sahab,
I'll refrain from that.
Let's proceed with
Khwaja
that.
Sahab,
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I think your Lordship has possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court.
It does not.
Instead of
Khwaja Sahab,
Section 3 is a totally different thing. It takes away the powers of this honorable court.
It does not.
Instead of
Khwaja Sahab,
Is
Khwaja
it
Sahab,
your
let us
argument?
clarify.
Is it your
It
argument
takes
that
away the
Section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's right.
I've been trying.
2 and 3 have to be read independently and separate.
Now, please.
And that too an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
In fact, to be very
excuse
honest,
me.
I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I will say that the Chief Justice powers will be whittled down, as if this law goes through, the powers will be whittled down, but we will explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is of course 2000.
फिर आप आंसर करने बैठ
I will continue. Let me
आप
continue.
नोट कर लें या बाद में कर लें
Let me continue then.
Mr. Khwaja, I will add it.
Then is a question.
Mr. Khwaja,
Yes, sir.
right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been.
I
This is the moot question.
The answer to that is that it's noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is the Chief Justice and so many other
Fajr
judges.
sahab will be sitting here till 12 o'clock.
I know that, sir.
So आप जरा अपना
let's
argument करें.
go.
अभी तो हम section
Let's
3 पे पहुंचे.
let me, on section 3, I will only say this thing, that this certainly is, the parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition, I've not even heard, and 3 judges or 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point. Therefore, to that extent, section 3 is present. Now, next is 4, interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object? First say, I object to this provision, or you endorse it?
I will say this thing, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7, why not 6?
Please.
I object to this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, section 4? Say something, we should note it.
On this, I will only say this thing, that putting a clause that the bed should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges.
Well noted.
Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5.
As I
Then there's a
understand,
question of appeal, and which is a very relevant point.
Ajay Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not, sir. I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the Parliament. About how the benches are to be
आगे बढ़ते हैं.
I will dwell on that.
In a nutshell, you are suggesting
Sahab, I have a question.
that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your
No,
suggestion.
sir, I'm saying this thing that under the 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the Parliament.
Okay, now let's proceed. We'll ask.
I'll argue on that.
लेकिन
That
अगर
is
आप
the point which needs consideration. 5 is appeal. Yes, Mani sir.
Sir, on section 4.
On 4.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendment? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
भैया साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
भाई बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी, कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुनिए, ये सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए कि जब सुप्रीम कोर्ट एक
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं।
ठीक है, अदरवाइज तो आप आपकी मुश्किल काम हो जाएगा।
मैं आई एम क्वाइट आई हैव अ वेरी
नहीं, आगे बढ़ते हैं।
I have worked with all of you, sir,
नहीं,
and
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
If I may,
कोई
sir.
problem नहीं है। I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
Not through ordinary
नहीं,
legislation.
आप नोट कर लें, जवाब ना दें।
Not through ordinary
Mr.
legislation.
If I will really request my colleagues that they are making, including myself, are making your life impossible.
I'm
No, please, no, you are very fine.
I'm
No.
learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं, आगे बढ़ते हैं. Let me say this thing.
Mr. Khwaja,
Khaja Sahab, section 5 से आगे पढ़ लीजिए.
another question with regard to appeal. आप देखें, हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2 member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? बहुत अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 है, आर्टिकल 183 84(3). तो ये क्या दोनों में
Sir, it
ये
is
गलत है तो फिर वो भी गलत
it is noted. We'll answer this thing, that what Parliament can do and what Parliament can do many things. Why my Lord has said so, but there is a procedure provided. We'll answer that.
भाई साहब अभी जवाब की जरूरत नहीं है, आप
I will not answer it.
पहले एक्ट को खत्म
Section 5 से आप आगे बढ़ लीजिए ख्वाजा साहब.
Khwaja Sahab,
You have collected 100 questions.
Just here. The law reforms ordinance of
I don't think how you will
1972,
answer.
this is the question to you, regulated right of appeal
101.
within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clog is there only in respect of the Supreme Court. Law reforms ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clog was only in relation to Supreme Court. Question: is therefore the law reforms ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clog.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person of this act, provided that the appeal under this section shall be filed within 30 days of the commencement of this act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're saying I'm not going to do it.
Well,
You have challenged the law, you have to do, you have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
As far as section 5 is concerned,
Is it good? Is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184.3, then why is this not they included in clause 2? Whereby my 184.3 application will be disposed of.
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes I am, no I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations, tell us unconstitutional about it.
Then let me explain it to them, because if I start explaining it at this stage, it will take your time. But I will say this thing, that this section 5 should have also, this right of appeal should also have been given in section 2.
Should is different from ultra vires a constitution.
It ought to have been given.
What then you go and move a bill in parliament. We are saying, are you opposed to section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे
You have done this.
नहीं ये नहीं आप जवाब दीजिए ना आपने पिटिशन लाए this is not fair.
इसमें to make it more simple, you don't want your client to have a right of appeal.
No, sir,
You first say it's unconstitutional, it's constitutional. You're not saying anything. You just यहाँ कोई discussion होता है. Sorry, not on. This is your job in office.
My lord, may I say this thing that we divided the.
Please answer the question: is this constitutional or unconstitutional? I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है?
Unconstitutional.
Well, it's my personal opinion is this, that this section 5 goes beyond the powers which were there with the parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my lord, if an appeal is to be provided it's a substantive right, there has to be a constitutional amendment to provide an appeal under section 184(3).
ठीक है,
Because
okay.
that, and this appeal to this act, an ordinary law cannot provide.
I
this
can't
kind of-
seem to reconcile your, which I appear to me to be contradictory submissions.
I will simply say
Please
that-
let me finish.
that this-
Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here, the Parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the appeal be given, but the manner in which it has been given.
Man,
is
take it,
wrong.
please take it.
And
No, no.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not strike it down because of manner. You have to show us ultra vires the
It is
Constitution.
unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184(3) is a substantive provision of the Constitution. If a
You
right
are
of
happy
appeal-
with no appeal.
Well, Lord, if a right of appeal has to be given, there has to be a constitutional amendment.
ठीक, okay, point
This
taken,
is-
move ahead.
ठीक है जी? ये बात नहीं पाई।
I just have a question to you with regard to section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you is, has two parts. So the first part is, this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of a legislative competence conferred by Article 191, in relation to practice and procedure, confer a right of appeal? Because if I may, and this is the, I apologize, my question has three parts. Because if I may touch upon what my learned colleague, Mr. Justice Mansoor Ali Shah, said recently, that this is recently, meaning in the hearing of the case, that anything that this law, the Supreme Court can itself do in exercise of rule-making power. Question therefore is, can Supreme Court confer a right of appeal in exercise of rule-making power against a judicial order under 184(3)? If the answer is no, then it seems to me logically that Parliament also can't do it, because the two things are parallel. Therefore, question, is it therefore unconstitutional?
Unconstitutional.
You don't
This
have
is
to,
why.
you don't have to give an answer. Just note it down.
If the right of appeal had to be
आगे
given,
बढ़ें,
it should
आगे
have been
बढ़िए,
given
आगे।
through an amendment.
Note it down.
Yes, next is right to appoint.
आप चाहें तो आप हमें लिखकर तहरीरी तौर पे भी जवाब दे दीजिएगा, ठीक है? अगर आप आगे अपना आर्ग्यूमेंट चलाते रहें, जी, आगे बढ़ते हैं।
to be very,
छह को पढ़िए, छह को।
Six है जी, right to appoint counsel of choice for filing a review application under Article 188 of the Constitution. A party shall have the right to appoint counsel of its choice. I don't object. I personally don't object.
पर्सनली की बात कोई नहीं है आपके।
I'm not objecting to this because I feel that.
Okay, it's okay. चलिए, let's get on with it. Section 6 is okay.
Okay. Application for fixation of urgent matters, when application pleading urgency or seeking interment filed in a cause, appeal or matter shall be fixed for it. My objection on this is again this, that this is a function of the Supreme Court itself, because this relates to the
Please
procedure.
tell us, is it ultra vires the Constitution?
It's ultra vires.
Thank you.
I just have a question to you on this, on section 7. Now, section 7 really relates to what has been treated as the nitty-gritty of procedural law. I mean, this is really going, say, in a civil court, into the very depths of CPC, or the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side. The question therefore is this: the legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt, is the power to destroy. Does this not effectively destroy the independence of the judiciary?
This was my very first point which I
Kaiser,
said, that the
is
functions
it-
of the
is
Supreme
it-
Court have been virtually been taken over.
Is this not contrary to the fundamental principle of the Constitution, trichotomy of
Trichotomy of
powers?
powers.
So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra-virus.
इसमें ख्वाजा साहब,
Yes, sir.
I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at aspect of independence of judiciary, that is, freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of
Just note kar
the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So, when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
Sir, we will certainly answer your lordship.
So, but please, one question
I may-
also.
Since
noted.
we have just
Raja
one
Sahab.
section, can we just finish reading it?
Raja Sahab, if I may have a supplemental on
Yes,
what
ma'am.
my
Please,
learned
please.
colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence
working
of
of
the
the parliament.
judiciary, that the solution is to put the power in the hands of Parliament? Would
That
that
will-
not violate separation of powers?
Yeah, it will-
Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and, for the practice and procedure of the court. There is no end to it. Is if at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar. Is this really the solution? That you say, okay, here's a problem internally to the. Would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean,
My- with the-
where would
Saab,
that
ek second.
lead us?
Khwaja Sahab,
with due respect, my
That
lord,
is a
to
question.
my lord.
ख्वाजा साहब, ये एक बात सुनिएगा, इधर एक क्वेश्चन.
आप इसको खत्म तो कर लेना सेक्शन को आप सॉरी टू से
आर्टिकल 8 खत्म कर लो.
आप पढ़ ही नहीं रहे
मैं
हैं.
पढ़ने का अभी पढ़ लेता हूँ सर. ये सवाल बड़े पर्टिनेंट
आप हर चीज आप नोट कर लेना.
नोट कर भी दिया मैंने सर. कर ये कहा मैंने शुरू में ये कहा था.
आप शुरू में क्या कह रहे हैं? आप
मैंने
आखिरी
शुरू में-
सेक्शन पढ़
सर,
लें.
मैंने शुरू में ये कहा था आपने शायद इस्लाम और जो ये आप कह रहे हैं इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है उसमें किसी और का दखल नहीं होना चाहिए.
देखिए,
ये
section 8
अगर
पढ़
ये
लीजिए आप पहले।
दखल अंदाजी होगी
जी,
तो
जी।
फिर ये सुप्रीम कोर्ट नहीं रहेगा.
एक बात और नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है टू द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the council of his own choice.
No,
When the law is totally ultra vires,
Sir, noted.
then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm out of the country or not well, you do allow in review.
You are declaring
another
right of
counsel.
appeal ultra vires and right of review intra vires.
No, madam, what I'm saying
Yes,
is
according to your own
that
arguments.
the question is that you cannot provide a right of appeal.
But you can
Under
provide the right of
wait a minute,
review.
sir, but under 184.3, if 184.3 right of appeal is given in accordance
आप
with
मेरे ख्याल में,
with the constitution, then as far
ख्वाहिद साहब फिर आप अपने लिए
Okay,
मुश्किल आप जरा सुन तो
we'll-
लीजिए ना
we'll
आप ये सवाल
Okay,
जो
sir.
है जरा
We'll
सुन
answer that
आप
question.
सुन तो लीजिए ना
well, सुन लीजिए।
ये जो सवाल है इनको इतने इजीली ब्रश असाइड ना कीजिए
नहीं, मैं नहीं करता।
जरा सुनिए प्लीज आप गौर और फिक्र से हम नहीं चाहते हैं कि आप फिलबदी कोई जवाब दे दें जो फिर आपके लिए मुश्किल हो हम इसीलिए आपको कह रहे हैं हर सवाल नोट कर लीजिए आराम से जवाब दे दीजिए आप खुद अपने लिए मुश्किलात खड़ी कर रहे हैं हर सवाल के लिए जवाब देने लगते हैं हम तो सिर्फ आपसे सवाल पूछिए नोट कर लीजिएगा आगे चल करके ठीक है हम देखें हम एक दूसरे से इधर बहस करने नहीं बैठे हैं हम आपके सुनने का आपने चैलेंज किया है एक कानून को कि ये गैर आईनी है ये बहुत फर्क होता है कि एक कहने के लिए कि मुझे ये कानून पसंद नहीं है जरा आप प्लीज ना खामोश रहिए 2 मिनट हम भी आपको सुन लेते हैं खामोशी से आप भी थोड़ा सा तहम्मुल का इजहार कर लें तो ये बहुत से कानून है शायद मुझे भी नहीं ज़ाती तौर पे पसंद हो मगर मैंने हल्फ उठाया है कि मैं आइन और कानून पे अमल करूंगा ताकि अनलेस कि मैं उसको स्ट्राइक डाउन कर लूं कानून को वो एक अलग बात है कि ये अल्ट्रा वायरीज द कॉन्स्टिट्यूशन है तो आपने कहा माय पर्सनल ओपिनियन डजंट मैटर तो आपकी भी पर्सनल ओपिनियन की कोई हैसियत नहीं है आपको आईनी जवाब हर देना है कि ये इश्क आपने एक बहस में एक आर्टिकल आइन का आपने रेफर नहीं किया कि ये किस आर्टिकल के तसादुम में है दूसरी बात आपने जो बिल्कुल नजरअंदाज कर रखी है ये हमने स्यूमोटो केस नहीं लिया अगर हमारे हकूक पे इतना जबरदस्त वार पार्लियामेंट ने किया होता तो हमने बहुत सारे केसेस में हमने खुद भी उठा लिए केसेस को ये तो आप हमारे तरह से वो डिफेंडर तौर पे रूनुमा हुए हैं और कहा ये जंग मेरी है ठीक है ये सिर्फ प्रोसीजर मैटर है किसमें किसी की राइट गायब नहीं हो रही किसी की राइट एक राइट कन्फर हो रही है किसी की राइट छीनी नहीं जा रही है तो बराए करम आर्टिकल 184(3) के दायरे में रहकर आपने जिसका आपने एक लफ्ज नहीं जिक्र किया है वो कहता है एनी मैटर ऑफ पब्लिक इंपॉर्टेंस चलें जी पब्लिक इंपॉर्टेंस तो एक वो है डिबेटेबल क्वेश्चन हम ये कहूँगा आप कहेंगे वो है मगर फॉर द इन्फोर्समेंट ऑफ फंडामेंटल राइट्स ठीक है ये इसके प्रीएम्बल में उन्होंने फंडामेंटल राइट्स का तस्करा कर दिया है जिसको आपने बस नजरअंदाज कर दिया ठीक है ये बहुत अच्छी बात है कि आप मेरे हकूक के लिए जंग लड़ रहे हैं मगर ये मेरे हकूक और आपके हकूक की नहीं बात है ये आइन की बात है और लोगों के हकूक की बात है ये आर्टिकल 10(a) का हवाला देता है आर्टिकल 25 का देता है तो आप खड़े हो राय आप कॉलम लिखिए अखबार में हमें सिर्फ और सिर्फ आइनी बहस कीजिए कि ये 184(3) का जो हम जो पावर आज इस्तेमाल कर रहे हैं वो 104 ये हम अपेलेट पावर नहीं इस्तेमाल कर रहे हैं ना कोई हाई कोर्ट ने कोई फैसला किया है जो हम बैठे हुए हैं एज ऑफ राइट अपील सुन रहे हैं पिटीशन फॉर लीव टू अपील सुन रहे हैं हम ओरिजिनल जुरिसडिक्शन में बैठ गए उसकी बहुत महदूद चीज़ें मुझे बहुत सी चीज़ें कानून में शायद नापसंद हो मैं ये नहीं कह सकता हूँ कि जी इसको ऐसा नहीं करना चाहिए था तो आप बराए करम आपने एक सीकिंग इन्फोर्समेंट ऑफ फंडामेंटल राइट से तो आपने कुछ बहस ही नहीं की अभी जरा आप प्लीज और हर बात को आप नोट कीजिए अगर आप
मैं नोट
तो बस आप हर चीज को जवाब देने लगते हैं बगैर सोचिए हर बात की बहुत अहमियत होती है मेरे कोलीग्स की जो सवाल हैं वो बड़े अच्छे सवाल हैं जरा गौर और फिक्र चाहते हैं और फिर जवाब देते हैं अगर आप जल्दी से करेंगे फिर आपको दोबारा मौका नहीं देंगे फिर कहेंगे अब मुझे अच्छा जवाब आ गया तब आप प्लीज 184(3) के तकाजे भी पूरे कर लें
आपके बिल्कुल 184(3) के तकाजे
मेरा एक सवाल भी नोट कीजिए केपी ऑन द बॉर्डर प्लीज आप क्या सोचते हैं दिस एक्ट हैज बीन पास्ड इन द पब्लिक इंटरेस्ट क्योंकि सेक्शन 5 सबसेक्शन 2 सेज ऑन द कॉन्ट्ररी it appears that to do away with some of the decisions which were passed in the previous years under Article 184(3) of the Constitution, क्योंकि commencement उनकी कर दी है और इसमें कोई limitation भी नहीं है, तो ये public interest में pass हुए या personal interest में हुए?
Yes, your point is noted, sir. I will not answer now, I'll answer it later.
Mr. Khwaja, another question.
Sure.
Please एक और note कर लें. We have two provisions in the Constitution. One is Article 191, which relates to Supreme Court, and the other is 202 of the Constitution, which relates to High Court. Same अल्फाज है, वहाँ पे Supreme Court, यहाँ पे High Court. Subject to the Constitution and law. Law तो बनाती है Parliament. तो आपके आर्गूमेंट से हम ये समझें कि पार्लियामेंट को आप लॉ मेकिंग में महदूद करना चाहते हैं कि आप ये तो कर सकते हैं, ये नहीं कर सकते, ये रूल्स में सुप्रीम कोर्ट खुद करेगी, खुद करेगी.
सर मैं इसका आंसर दूंगा, बिल्कुल दूंगा, क्योंकि जब सब्जेक्ट टू कॉन्स्टिट्यूशन आ जाएगा और जो लॉ आएगा वो आपको कॉन्स्टिट्यूशन के साथ देखना पड़ेगा.
बात ये भी कि क्या लॉ के तहत क्या कर सकते हैं पार्लियामेंट, क्या नहीं कर सकते.
क्या नहीं कर सकते, ये इसका जवाब देंगे जी आपको. इसीलिए तो
another question, where a rule has been framed under constitutional power granted to this court.
Yes, sir.
This is with reference to section 6 that you just read. You would notice that Order 26 of the Supreme Court rules does provide for all eventualities in which a review can be filed procedurally. The question is where the Supreme Court, in exercise of constitutional powers granted by the Constitution framed rules, the Parliament can legislate and override those rules or amend those rules. That's the question. Noted. Please answer when you are answering.
Additionally, through already law or through the point is taken, sir, by already with me, and I will answer that. And I have my own views on this, that the Parliament cannot do this thing by an ordinary.
हुजूर आपके व्यूज को छोड़ दीजिए ना, आईनी तकाजे पूरे कर लेना.
Number 7 is application for fixation of urgent matters.
ये तो हो गया.
Application pleading urgency or seeking interim relief.
अच्छा, मैं आपको एक मफरूजा पे छोड़ देता हूँ. आपने दरखास्त दी, बहुत अहम केस है, अर्जेंट केस है, मैं नहीं लगाता हूँ, मेरी मर्जी. सिर्फ जवाब दे दीजिए, मेरी मर्जी. मैं 10 साल उस केस को नहीं लगाऊं, मेरी मर्जी.
मैंने इसमें कुछ नहीं कहा.
मैं आपसे सवाल पूछ रहा हूँ जी. इन्होंने मेरी मर्जी ले ली, शायद मैं खुश नहीं हूँ उस बात से. मेरी मर्जी में ना लगाऊं केस, एक बहुत अहम केस है, इसमें उन्होंने लिख दिया 14 दिन में आप उसका, भाई सिर्फ उसको लगा दें, कोई फैसला तो ना करें. तो मैं कहूँगा मेरी मर्जी. मैं जो ये टैक्स पेयर पैसे दे रहे हैं इस अदालत को, जो हमारा बजट है, मेरी मर्जी पे चलेगा. इस पे सवाल का जवाब दीजिए. मैं नहीं लगाता हूँ. आपका ये केस फाइल किया, ठीक है, मैं नहीं लगाता इसको. आप क्या कर लोगे? कुछ भी नहीं कर सकते हैं. आपके हाथ पैर कटे हुए हैं. इन्होंने हम पे भी, मेरे कोलीग ने एक बात की इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस की. मैं 2 बातों का इजाफा भी करना चाहता हूँ, और वो है, और वो आइन से पहले भी हमारे पास था, वो हमें ऊपर वाले को हिसाब देना है. ठीक है, अकाउंटेबिलिटी एंड ट्रांसपेरेंसी. आप हमें टोटली अनअकाउंटेबल बनाना चाहते हैं चीफ जस्टिस को. मैं तो बहुत खुश हूँगा, क्योंकि ये कानून अगर सस्टेन हो जाता है तो मेरे पार तो कम हो गए बाकी चीज़ों को छोड़ करके. ठीक है, इस कानून को उड़ा दें, मैं ताकतवर बन जाता हूँ. ये भी है, मैं अकाउंटेबल हूँ. ये भी एक सवाल है. आपका आइन जो शुरू होता है वो सुप्रीम कोर्ट की इंडिपेंडेंस से नहीं शुरू होता है, वो अल्लाह ताला के बाबरकत नाम से शुरू होता है. ठीक है, और हम सब everyone to exercise powers as a sacred trust. आइन में आर्टिकल 227 भी दी गई है कि शरई असूलों पे अगर आपके कोई भी कानून तसादुम करे तो वो प्रिवेल करेंगे. तो बराए करम एक इंडिपेंडेंस ऑफ द जुडिशरी से ये मतलब नहीं कि अगर इंडिपेंडेंस ऑफ जुडिशरी से मैं किसी का दरवाज़ा बंद कर रहा हूँ तो वो तो मैं बिल्कुल मुझे इस्तेमाल नहीं करना चाहिए. आप ये पिटिशन लाते, सपोज मैं चीफ जस्टिस होता, मैं इसको लगाते ही नहीं, तो हम ये बेकेस ही नहीं सुनते. कभी 10 साल पड़ा रहता, मैं मजबूत रहता चीफ जस्टिस के तौर पे. आप खुश थे उस बात से. तो बराए करम आप ये जो बार बार बात कहते हैं ना, मेरी मर्जी, मेरी नहीं है. जब मैं चीफ जस्टिस हूँ تو برائے کرم ہم وکیلوں کو بہت ہی قدر کرتے ہیں، مگر میرا کا لفظ نہ استعمال کیجئے. انگریزی میں کہتے ہیں می مائی سیلف اینڈ آئی آر دا 3 موسٹ یوزلیس ورڈز ان دا انگلش لینگویج. اس کا میں اردو میں ترجمہ نہیں کر سکتا ہوں، بہتر کر سکیں گے. براہ کرم آئین کا حوالے دے دیجئے کسی چیز کے متعلق کہ یہ آئین کے تصادم ہے، وہ آئین سے تصادم رکھتا ہے، یہ شک کہ آئین سے تصادم. ابھی تک میں نے آپ سے وہ ایک لفظ نہیں سنا ہے اس پہ. شکریہ.
میں نے تو 3-4 جگہ کہہ دیا ہے کہ جہاں پہ 184(3) میں آپ اپیل کا رائٹ دے رہے ہیں تھرو دس آرڈنری لا، یہ ہو نہیں سکتا بیکاز دس کین اونلی بی ڈن بائی اے کانسٹیٹیوشنل امینڈمنٹ.
یہ لفظ لکھا ہے اگریوڈ پرسن. ٹھیک ہے. اب دیکھیے، اب ایک مفہوم تو یہ نکلتا ہے 184(3) کا کہ آپ ایسے معاملوں میں نہ الجھائیں اپنے آپ کو جو انفرادی نوعیت کے ہوں.
اگریڈ سر.
ذرا اگریڈ، آپ سے اگری کریں یا نہ کریں، میں ذرا بات کر لوں. انفرادی نوعیت کے، اگر ہم انفرادی نوعیت کے کیسز فیصلہ کرنے لگیں تو وہ بیچارہ کہاں جائے گا؟ میں آپ کو مثال دے دیتا ہوں. ریکوڈک کا کیس چلا، دونوں کیس فیصلہ ہو گئے تو میں اس پہ بات کر سکتا ہوں. ریکوڈک کا آ گیا، ٹھیک ہے، سپریم کورٹ نے 184(3) میں اگریمنٹ اڑا دیا. ملک کو، سپریم کورٹ کو نہیں، ملک کو $6.5 بلین کی ڈز لگی. ہم نے کون سا جورسڈکشن استعمال کیا؟ ہم نے ایڈوائزری جورسڈکشن استعمال کیا. اگر یہ ہمارے پاس یہ جورسڈکشن ہوتا، میں نہیں کہہ رہا ہوں فیصلے اچھے تھے برے تھے، میں صرف اس پہ تبصرہ کر رہا ہوں، ٹھیک ہے. اگر ہمارے پاس جورسڈکشن ہوتا ہم وہ جورسڈکشن استعمال کر رہے تھے. اب ہم نے ایڈوائزری جورسڈکشن سے معاملوں کو ٹھیک رکھنے کی کوشش کی، ٹھیک ہے. آپ کہتے ہیں نہیں، ملک کو $6.5 بلین کی ڈز لگ جائے تو لگ جائے. انڈیپینڈنس آپ کی چیف جسٹس کی ساخت پہ کمی نہ آئے. جی مجھے ایسے پاورز اپنے لیے تو نہیں چاہیے. میں اب وضاحت کر دوں، اگر آپ مجھے دینا چاہتے ہیں میں پھر بھی نہیں لینا پسند فرماؤں گا. آپ پلیز آئین کے تقاضے پورے کریں.
میں یہ میرا مقصد ہی نہیں ہے. آپ میں یہ آنسر کر دوں گا. یہ بالکل 184(3) کے جو کنڈیشنز ہیں وہ بھی میں آپ کے سامنے پوری کر دوں گا. اور وہ 2 کنڈیشنز ہیں، پبلک امپورٹنس اینڈ فنڈامنٹل رائٹس. فنڈامنٹل رائٹس میں رائٹلی سائڈ سے independence of the judiciary is a fundamental right.
Can we go back to my question before you get into the merits of all these arguments? The question is again, if the law is to be sustained, what is the effect of Section 5, which gives a right of appeal, given that a full bench is going to hear the case and decide the matter? Then that full right of appeal is no longer there. It's redundant. It doesn't exist. So what is you have read the law now. اس کے اوپر آپ بتا دیں کہ
اور اس میں اسی کے ساتھ ایک سوال خواجہ صاحب ادھر ہوں جی، ذرا 5 منٹ لگتے ہیں آپ کو مجھے دیکھتے ہیں.
نہیں سر، میں
آپ سے صرف اسی سوال چلتے ہیں کہ اس 4 میں لکھا ہے کہ 5 یا 5 سے زیادہ ججز کا بینچ بنا سکتے ہیں نا، تو فل کورٹ بھی بنا سکتے ہیں نا 4 میں. تو پھر 4 کو 5 کو اکٹھا پڑھیں تو اگر فل کورٹ بن گیا تو پھر اس کیس میں اپیل نہیں ہوگی. بس آپ اس کا بھی جواب دیجیے.
بلکہ تو اس میں ایڈ آن کوشچن ہوگا کہ ڈز دیٹ ناٹ مین کہ ہم پھر ونس اگین خود ہی ڈیسائیڈ کر لیں گے جہاں ہم نہیں چاہیں گے کہ اپیل کوئی ہو کسی کیس کا تو فل بینچ بٹھا دیں گے. ڈز دیٹ اگین ناٹ اماؤنٹ ٹو اے پاور being exercised by the court itself? So the control factor that there is a right of appeal, which is a substantive right, how can we just say that that right cannot be exercised? It's a substantive right.
ایک question اور بھی اسی میں ایڈ کر لیتے ہیں اس طرف. فاجی صاحب, to your right. ہم یہ بھی دیکھیں گے through this petition there is an order of this court. The act has been suspended. Whether in presence of that order full court can be constituted or not. یہ بھی ذرا دیکھیں. Court can be constituted or not.
آپ جواب دینا پسند فرمائیں گے یا ہم shall we proceed to the next council؟ پھر آپ سوچ کر کے آپ جواب دے دیجئے. ٹھیک ہے, ٹھیک ہے, آپ آئیے. کون آرگیو کرے گا نیکسٹ؟ اچھا, آپ اپنا کس پٹیشن میں ذرا بتا دیں.
تینوں میں خواجہ صاحب کے ساتھ.
جی,
تینوں میں خواجہ صاحب کے ساتھ.
To write of two counsel is not allowed unless you are separate petitioners.
7 میں 6 ہم بیٹھے ہیں, ایک میں آپ 7 میری حاضری ہو گئی.
جی چلیے بتائیے.
Followed the proposition is, the proposition requires to be refocused. There is, the fundamental question is whether the parliament has the jurisdiction and the power to promulgate this act or not.
No, that is not the fundamental question. With utmost respect, the primary question is whether 184.3 can be invoked. First, you overcome that hurdle, then you argue that. So you have filed a petition not in the normal jurisdiction. You have come in original jurisdiction of the Supreme Court, which is not a right. You have to comply with certain provisions of the Constitution.
Well, Lord, there are number of judgments.
I'm not interested in judgments. I'm talking about arguments.
I am making submission, my Lord. The Supreme Court at various point of time has held that any clog on the powers of the Supreme Court or the functioning of the Supreme Court constitutes.
मैं फिर आपको बात समझाया नहीं सका. For instance, let's take income tax ordinance. ठीक है, उसको आप बिल्कुल स्ट्राइक डाउन कर सकते हैं और उसको चैलेंज भी कर सकते हैं आर्टिकल 199 में हाई कोर्ट के पास. ठीक है, हम क्यों जुरिस्डिक्शन एक्सरसाइज करें 184.3 की? ये शायद आपके हिसाब से ये कानून दुनिया का बदतरीन कानून हो सकता है. ठीक, मगर बुनियादी सवाल 184 का दरवाजा जब आप खोलेंगे तो उसमें दो चीजें हैं. मैटर ऑफ पब्लिक इंपॉर्टेंस, सीकिंग इन्फोर्समेंट ऑफ फंडामेंटल राइट्स. बता दीजिए कि चलिए पहले वालों को जरा ग्रे एरिया, दूसरे वाले में तो बता सकते हैं ना फंडामेंटल राइट. पार्लियामेंट अच्छा कानून बनाए, बुरा कानून बनाए, ये हम पार्लियामेंट्री डिबेट इधर नहीं करेंगे. आप 184.3 में हो सकता है कल को हाई कोर्ट में आप ये पिटिशन लगाते, वो अलाउ कर देते आपकी पिटिशन, फिर आप हमारे पास एपेलेट जुरिस्डिक्शन में आते, हमारे पास बहुत खुले होते. अब आपने बहुत नैरो इंतखाब किया है, 184.3 का इंतखाब किया है.
My Lord, there are number of judgments of the Supreme Court.
जजमेंट्स हावी नहीं होते हैं आइन पे. अच्छा, 189 पढ़ लें जरा. ये आप लोगों के जरा गलत फहमी क्यों है? 189, एक सेकंड 189 पढ़ लेते हैं साथ में. जरा पढ़िए 189. जी.
Any decision of the Supreme Court shall, to the extent that it decides the question of law or is based upon or enunciates a principal law, be binding on all other courts in Pakistan.
लफ्ज है all other courts, not the Supreme Court.
Yes.
तो ये हमारे ऊपर हमारे प्रेसिडेंट्स ना साइड कीजिए. अब आपसे आईनी सवाल पूछा जा रहा है on all other courts, which means high courts and
unless your lordship allows me to make a submission.
other courts की बात कर रहा हूँ.
No, I will not be able.
ठीक है, आपको सवाल दे दिया, आप जवाब दीजिए जैसे भी आप करना चाहें.
Please, Lordship.
If I may ask you,
Sir.
Mr. Siddiqui, if I may ask you a question.
Please, Lordship.
It seems to me that Article 189 deals with what is called vertical stare decisis. But there is also within the Supreme Court and in each High Court what is called horizontal stare decisis, the law of precedent. That is a judge-made law, that is case law. That is not provided in the Constitution. And surely the rules, are there not rules that regulate horizontal stare decisis? For example, the full court gives a judgment. If there were no horizontal stare decisis, a two-member bench of the Supreme Court would say, well, Article 189 doesn't apply, so we are not bound by the judgment of the full court. Would that be correct? Would that be a correct understanding?
That would be a fallacy. It will not be correct.
So if a three-member bench, a five-member bench gives a judgment, can a three-member bench say, or even a five-member bench say, sorry, we are not bound because Article 189 doesn't apply to us? Surely horizontal stare decisis does apply. It's a well-settled. What would you say to that?
But I would make a humble submission that the judgments of the superior courts, particularly of the Supreme Court, are a binding precedent on the subsequent courts constituted as a benches or a full court. And unless your lordship, in your lordship's wisdom, decide to overrule them, they have a binding value. And it goes to the very system of certainty within the judicial system. And to say that your lordship are not bound by the previous judgment would, with respect.
मेरे ख्याल में आप मेरा सवाल सर समझिए नहीं सही.
मैं आपको आ रही हूँ सर, मैं उधर आ रहा हूँ.
नहीं, मेरा सवाल दोबारा दोहरा देता हूँ, शायद आप समझ नहीं पाए. यकीनन
सर
5 मेंबर बेंच का जजमेंट 3 मेंबर बेंच पे बाइंडिंग है, यकीनन. अब हम आर्टिकल 189 की बुनियादी बात कर रहे हैं, अदर कोर्ट्स. अगर ये बात है तो ये अब फुल कोर्ट, इससे बड़ी तो फुल कोर्ट नहीं हो सकती है ना. ہمارے اوپر کوئی پریسیڈنٹ لاگو نہیں ہوگا. آپ سمجھ رہے ہیں, اگر یہی ایشو کسی لارجر بینچ نے فیصلہ کر لیا ہوتا وہ ہم پہ ہوگا, مگر ایز اے رول ادروائز ججز ڈسینٹ بھی نہیں کر سکیں گے نا, وہ تو بائنڈنگ ہے, ڈسینٹ بھی نہیں کر سکتے ہیں. تو اب آپ ذرا وضاحت میں یہ کر رہا ہوں, یہ نہیں ہے کہ 4 ممبر بینچ ڈسریگارڈ 2 ممبر بینچ ڈسریگارڈ کر دے گا 5 ممبر بینچ کے فیصلوں کو, بالکل یہ میری آپ اس کا مطلب بات سمجھ نہیں پائے ادر کورٹس. مگر ابھی تو وہ مفروضوں میں ہم نہیں جانا چاہتے ہیں, یہ جو موقع ہے اس پہ پورا کورٹ بیٹھا ہے, تو یہ کوئی پریسیڈنٹ جب آپ سائٹ کرنے لکھ لیں گے تو وہ پرنسپل نہیں اپلائی کرے گا جب تک آپ آرٹیکل 184(3) کا دروازہ نہیں کھول پائیں.
یہ امتیاز صاحب, اس کو میں ذرا سمپلیفائی کر دوں ایز آئی ہیو انڈرسٹوڈ. یہ پورا لا پڑھ لیا گیا ہے, اس میں صرف 2 چیزیں ہیں. ایک, پہلے چیف جسٹس کے پاس کلی اختیار تھا کہ ڈسکریشنری چوائسز کرے, ٹھیک ہے نا, اس کو پارلیمنٹ نے ڈائلیوٹ کر دیا, ریگولیٹ کر دیا. دیٹس آل دیٹ دا پارلیمنٹ ہیز ڈن, کہ انہوں نے 3 ججز کو اکٹھا کر دیا, کوئی باہر کا کوئی بھی نہیں آیا. اٹس اسٹل دا چیف جسٹس اینڈ دا 2 سینئر موسٹ ججز. اس میں تو کسی کا بھی فنڈامنٹل رائٹ افیکٹ نہیں ہو رہا, بلکہ جو انٹرنل یا انسٹیٹیوشنل انڈیپینڈنس ہے وہ مضبوط ہو رہی ہے. سیکنڈلی, ایک رائٹ آف اپیل اس کو پرووائڈ کیا جا رہا ہے جس کے پاس پہلے کوئی رائٹ نہیں تھا. ناؤ اس 2 چیزوں کے علاوہ اس پورے قانون میں کچھ نہیں ہے, تو کون سا فنڈامنٹل رائٹس آپ پٹیشنر کا وائلیٹ ہوا ہے جس پہ آپ 184(3) میں آئے ہیں؟ یہ تو اگر
your lordships have held,
سن لیں, اگر پارلیمنٹ نے چیف جسٹس کی اتھارٹیرینزم کو ختم کیا ہے, یہ تو آپ کو سراہنا چاہیے. یہ تو آپ کے بلکہ انڈیپینڈنس آف جوڈیشری کو سیکیور کرے گا. ہاؤ ڈز دس
respond to this, may I respond?
اور صدیقی صاحب اسی میں ایڈ کر دوں, سوال یہ ہے کہ اگر آپ کے مطابق چیف جسٹس کی انلمیٹڈ پاورز ہی انڈیپینڈنس آف جوڈیشری ہے, یہ بھی بتائیے گا, کیونکہ اگر جس طرح مائی لرنڈ کالیگ از جسٹ مینشنڈ کہ اگر وہ وٹل ڈاؤن کر رہے ہیں پاور چیف جسٹس کی, ایک کی جگہ 3 لوگ 4 لوگ مشاورت کے ساتھ چلیں گے تو ایک دم اس لیے کہ چیف جسٹس کی پاور کم ہو رہی ہے, انڈیپینڈنس جوڈیشری ایٹ اسٹیک ہو گئی ہے. یہ نہیں دیکھ رہے کہ انڈیپینڈنس جوڈیشری تو بڑھ گئی ہے, کہ ایک کنسنسس سے آگے چلنے کا انتظام ہو گیا ہے کہ آپ لوگ سوچیں کہ آگے کیسے چلنا ہے, کولیجیل طریقے سے چلنا ہے. ساری دنیا میں بہرحال یہ ہو رہا ہے, کہیں دنیا میں چیف جسٹس نہیں ماسٹر آف دا روسٹر ہے, کیونکہ اب سب جگہ کہیں جائیں تو بیلٹ ہوتا ہے سال کے شروع میں, کہیں ساری فل کورٹ بیٹھتا ہے تو پھر چلتا ہے. کوئی چیف جسٹس کے بعد منجمد نہیں ہے یہ پاورز چلانے کی. تو یہ ہو رہا ہے, تو انڈیپینڈنس تو اس سے بڑھ رہی ہے جوڈیشری کی. ایک چیز تو اس چیز کو ذرا دیکھیے کہ انڈیپینڈنس بالکل کنیکٹ مت کیجئے چیف جسٹس کی اومنی پوٹنٹ پاورز کے ساتھ, کہ جیسی چیف جسٹس کی پاور کو ہم چھیڑتے ہیں انڈیپینڈنس جوڈیشری خطرے میں پڑ جاتی ہے. ایسا کوئی سلسلہ نہیں ہے. اس کا بھی جواب ذرا دیجیے.
Mr. Siddiqui, the fundamental question here is, who can do this? Who can do this? That's what I'm saying. I mean, is it a function of the granted by the Constitution? Is it the function of this, the Supreme Court?
It is a function,
or is it the function of the Parliament? And if the Parliament exercises a function of the Supreme Court, then it is an intrusion in the independence of the judiciary, as I have understood, is your argument.
I am saying,
صدیقی صاحب ایک اس میں ذرا میں ایڈ کر دوں. 191 آپ پڑھتے ہیں نا, تو 191 میں لکھا ہے سبجیکٹ ٹو لا اینڈ دی کانسٹیٹیوشن پروسیجر بنا سکتے ہیں. تو 191 تو یہ انویزج کرتا ہے کہ قانون ہو سکتا ہے جو پریکٹس اینڈ پروسیجر کو ریگولیٹ کرے.
پارلیمنٹ کا تو نہیں ہو سکتا.
سن لیجیے, نہیں اور کہاں سے قانون لاتے ہیں آپ؟ ہم پارلیمنٹ سے لاتے ہیں پاکستان میں قانون.
ججمنٹ لا.
اچھا نہیں, لا کانسٹیٹیوشن اینڈ دی لا
کنونشن.
سن لیجیے. ٹو لا ان دی کانسٹیٹیوشن کہیں سے لا ایک ایگزسٹ کر سکتا ہے, آئین مانتا ہے کہ ایسا قانون ہو سکتا ہے جو کورٹ کے پروسیجر کو ریگولیٹ کرے. اب سوال آتا ہے وہ کمپٹنس کہاں سے آئے گی پارلیمنٹ؟ تو آپ ہم انٹری 55 میں چلے جاتے ہیں کہ ایسی پاور وہ دے سکتا ہے کہ نہیں. اب اس کو ذرا اوور آل اسکیم میں دیکھیے کہ ہمارے پاس یہ جو سیکشن 7 پڑھا جا رہا تھا یہ وغیرہ, ہمارے پاس ارجنٹ لگتے ہیں کتنے، لگتے ہی نہیں کیسز. یہ عام روزانہ کی ایک شکایت ہے کہ ارجنٹ کیس سپریم کورٹ میں لگتا ہی نہیں ہے. چیف جسٹس صاحب نہیں لگاتے کوئی کیس. چیف جسٹس اپنی مرضی کا ایک بینچ بنا کے کوئی کیس کر دیتے ہیں. اچھا فل کورٹ نہیں بیٹھتا. عوام کے کیسز ہیں، عوام کا ایک پورا فورم ہے پارلیمنٹ، وہ عوام کہہ رہی ہے اور وہ پارلیمنٹ کہہ رہا ہے کہ بھی اپنے سسٹم کو ٹھیک کریں، اور آپ کا سسٹم 14 دن میں ایک ارجنٹ لگائے. یہ بات غلط ہو گئی. ہمیں کرنا ہے ہم سو جائیں، ہم نہ بنائیں کیس، ہم کوئی کیس نہ لگائیں، ہم اپنی مرضی کے بینچز بنائیں، یہ ٹھیک ہے. پارلیمنٹ جو اسی عوام کے جن کے مقدمے سننے ہم بیٹھے ہیں وہ کہتا ہے کہ یہ سسٹم بنا دیا ہے پروسیجر، 14 دن میں ارجنٹ کیس لگاؤ، تو ہماری پاور پہ اور انڈیپینڈنس پہ قدغن آ گیا ہے. اس لیے کہ ہم 17 ان الیکٹڈ آدمی جس طرح مرضی عوام کے کیسز فیصلہ کریں، لیکن عوام جو پارلیمنٹ کے تھرو ہمیں بتائے وہ ہمارے راستے میں راستہ آ گیا. 55 انٹری، سارا سوال انٹری 55 کا ہے. انٹری 55 میں سپلیمنٹل پاورز دے سکتے ہیں، اس میں بتائیے کہ کیا غلطی ہے. صرف اتنا سا سوال ہے.
If your lordship allow me a breather,
صدیقی صاحب ایک سوال.
I will answer all these
چلے
questions.
بسم اللہ کیجئے.
صدیقی صاحب سانس
My lord, I would answer all these
سانس
questions.
لینے سے پہلے ایک سوال اور نوٹ کر لیں. دیکھیں کانسٹیٹیوشن نے کہا ہے،
کھڑی نہ نہ جائے.
کانسٹیٹیوشن نے کہا ہے کہ انڈیپینڈنس آف دی سپریم کورٹ. Nowhere it is mentioned that the supremacy or independence of the chief justice.
I would answer this question.
سر مجھے لگتا ہے سارے میرے کولیگ میرے خلاف ہو گئے ہیں.
Question پورا نہیں ہوا. تو Constitution says independence of the Supreme Court. جبکہ رولز کے تحت چیف جسٹس کو پاور دیا.
چینج کر دیں سر، رول کو چینج کیجیے.
سن لینا سر، رول کے تحت. اب رول کیا ہوں گے؟ اگر آپ 191 پڑھیں گے آپ وہ رول بنائیں گے جو کانسٹیٹیوشن اور قانون کے تابع ہے. ایسا نہیں ہے کہ رول
اسٹرگل سر یہ ہو رہی ہے مائی لارڈ کہ کہہ یہ رہے ہیں کہ ہمارا ایکسپیرینس بہت برا ہوا ہے پچھلے ادوار میں.
اچھا اس کی
I don't want to comment on that.
اس کی
It is not my stature. It is not my function.
اس کی
I
کہیں
want the lordship
اور
to be
ممالک
seeing
میں
something out of the sky.
بات سنیں پلیز. اس کی کہیں مثالیں موجود ہیں کسی اور ملک میں؟ کوئی ایسی مثالیں موجود ہیں؟
میں اس طرف آؤں گا اگر آپ مجھے دیں. What the theme appears to be.
میں اپنے کولیگ سے ریکویسٹ کرتا ہوں کہ آپ کو اجازت دے دیں اور آغاز کیجئے.
The theme appears. I just a sentence.
Just one question. آپ صرف اتنا بتا دیجیے. Why 184(3? Why not 199 before the High Court? کون سا فنڈامنٹل رائٹ جو ہے
your lordships in a number of judgment have held.
ججمنٹ تو بالکل صحیح ہوتی ہیں سر. دیکھیے
آپ کو بتاتا رہا
کورٹ کے سامنے
آپ بتا رہا ہوں.
یہ کون سا فنڈامنٹل رائٹ
I have a right to be dealt in accordance with the constitution and the law. It is my fundamental right.
Agreed.
And if I find that there is a deviation from the constitutional scheme, it is a question of violation of my fundamental right. And it is.
You tell us which one.
which
You can't just say it is. You tell us which one, we'll note it.
یہ آپ مانتے ہیں بیکاز آف جو پیچھے پاس میں 2 ڈیکیڈز میں ہوا ہے اس طرح کی ریفارمز آنی چاہیے تھیں.
100%.
100.
I am a victim of it.
ایک سیکنڈ نا اب یہ اب لیٹ اس جسٹ اس کو چھوٹا کر دیتے. اب آپ کہتے ہیں قانون بہت اچھا بنا ہے لیکن پارلیمنٹ کے پاس اختیار نہیں تھا. ہم ان الیکٹڈ ججز جو ہیں 15 ہم بیٹھ کے یہی چیز کر لیں تو ٹھیک ہوگا. تو پھر تو آپ سمپلی آرٹیکل 191 کے لینگویج پہ آ جائیں, صرف اسی کی انٹرپریٹیشن آپ کو درکار ہے. اس سے معنی یہ ہوا دیر از نو فنڈامنٹل رائٹ. آپ کہتے ہیں قانون بہت اچھا ہے, آپ خود افیکٹی ہیں, یہی چیزیں ہونی چاہیے تھی تو ہم خود کر دیتے.
صدیقی صاحب یہ سوال لکھ کر رہے ہیں آپ؟ پتہ نہیں, ہم تو بولی جا رہے ہیں, آپ ہاں کری جا رہے ہیں.
ساتھی کھڑے یہ کوئی کام نہیں کریں گے.
میں سوچ رہا ہوں کہ آرٹیکل 10A آرٹیکل 4
ایسے نہیں کہیے, پڑھیے ایک پڑھیے اور بتائیے.
I will first read article 4. I will first read article 4.
For your starter, actually it is for your starter. آپ یہ whole of the act کو ultra vires کہتے ہیں یا کہ there is any exception?
I find the entire act to be ultra vires the constitution because I feel this domain is not available to the parliament and the entire tenure of the section is unlawful. And I will show it to your lordship.
ٹھیک ہے چلیں.
Mr. Siddiqui.
His Lordship, Article 4.
Mr. Siddiqui.
Article 4.
Please, Lordship, I have another question.
Please explain whether any person of a society could lead a respectable life where the courts are not allowed to function independently?
No.
Is it not a violation of fundamental rights?
Yes. And that has been held by your Lordships. It is not it is judgments of your Lordship of 10 judges, 14 judges. And I just will never.
سوال تو ہمارے سامنے یہ کہ یہ جو قانون ہے یہ تو اور ٹرانسپیرنٹ کر رہے ہیں ہمارے سسٹم کو اور عام آدمی کی زندگی آسان کر
سر دیکھیں میں ایک آپ کو میں اور وضاحت کر دوں. ہم بہت ججمنٹ اورینٹڈ بن گئے. میں نے جو حلف اٹھایا ہے نا, میں نے یہ حلف نہیں اٹھایا. سر سن تو لیجیے نا پلیز, کہ میں ججمنٹس آف دا سپریم کورٹ کا پابند ہوں. آپ اس سے مخاطب ہو جائیں نا کہ میں ججمنٹس آف دا سپریم کورٹ کے تابع ہوں. میں نے حلف اٹھایا میں آئین اور قانون کے تابع ہوں. پلیز میں اپنے حلف کی وائلیشن نہیں کروں گا کہ جی ججمنٹ کو آئین کو تو چھوڑ دیجئے, آئین تو ہم پڑھیں گے نہیں, ججمنٹ پڑھیں گے بیٹھ کر. آپ ذرا سن لیجئے نا, اس ملک میں کئی بار مارشل لاء بھی لگے ہیں, میں ان ججمنٹ کے تابع نہیں ہوں. آپ سن لیجئے وضاحت سے, ہو سکتا ہے کوئی اور ہوں, میں نہیں ہوں. ٹھیک ہے, آپ 100 ججمنٹ مجھے پلیس کریں, میں ایک بھی نہیں پڑھوں گا. میں کہوں گا آئین پڑھیے. اگر آئین کے وہ ان اکارڈنس وتھ ہے, یہاں تو یہ چیزیں نہ کریں. ریممبر دی ہسٹری آف پاکستان. ہم لوگ بیٹھ کے لمبے لمبے آرگیومنٹس کر رہے ہیں. 57,000 کیسز ایکومولیٹ ہو گئے ہیں. تو اگر ایک بہتری پارلیمنٹ سمجھتی ہے, ایک بہتری لائی ہے, آپ فوکس ہی نہیں کر رہے ہیں انفورسمنٹ آف فنڈامنٹل رائٹ پہ. وہ خواجہ صاحب چلے گئے, انہوں نے ایک فنڈامنٹل رائٹ کا تذکرہ نہیں کیا. آپ سے ہم پوچھ رہے ہیں کہ 184(3) پہ آ جائیے, پھر 191 پہ آ جائیے, پھر آرگیومنٹس کریے. بہت برا قانون ہے مگر اس کے دائرے میں لائیے.
I proceed?
جی پلیز.
Article 4. I read, my lord.
فرمائیے.
To enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person of the time being within Pakistan. In particular, no action detrimental to life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. B. No person shall be prevented from or hindered in doing which is not prohibited by law. And C. No person shall be compelled to do that which the law does not require him to do. Now let us go on to the...
Not go on to do, develop an argument.
Well, allow me.
No, why you read Article 4?
Your Lordship had asked me to argue the case according to the way that I want to proceed.
Yes, so please
allow me.
What is the violation of Article 4? What is the violation of Article 4?
My lord,
it is mentioned in the preamble of the Act.
I am making a submission to your Lordships.
کیا صاحب ذرا پلیز ایک چیز کلیئر کر دیں. آپ مانتے ہیں کہ یہ بہترین قانون یہی ہونا چاہیے, لیکن آپ کہتے ہیں کہ پارلیمنٹ کا اختیار نہیں تھا 191 میں. یہی پروپوزیشن. اب اس کو جس طرح مائی لارڈ کہہ رہے ہیں ایکسپلین کر دیں. 191 پڑھ لیں, اس میں اگر سبجیکٹ ٹو کانسٹیٹیوشن اینڈ لا ہے اور سپریم کورٹ میں ہے, شیل نہیں ہے. اٹ از ناٹ دا رائٹ آف دا سپریم کورٹ. اب اتنا بتا دیں کہ جو سبجیکٹ لا ہے, کیا وہ رولز, ان کا سٹیٹس اس پارلیمنٹ ریپرزینٹیو باڈی سے ہائر ہے یا لوور ہے. That's the only.
Thank you, my lord. I am indebted to my lord. This is the proposition.
ایک آرٹیکل 4 آپ کہہ رہے ہیں, دوسرا کون سا آرٹیکل ہے وہ پڑھ لیجئے نا سارے آرٹیکل کے اوپر آ جائیں نا پھر آپ.
آرٹیکل 10A.
آرٹیکل 10
پڑھیے.
Article 10, sorry, my lord. 9.
ایسے نہیں نمبرز نہ دیں, بتائیں نا.
No person shall be deprived of life or liberty save in accordance with law.
آپ کی کون سی لائف لبرٹی لے لی اس لاء نے؟
سر ہمارے چیف جسٹس کی پاورز کلپ کر رہے ہیں.
وہ میں جانوں اور یہی آپ کا کیا تعلق ہے؟
No sir, that is my perception. If your lordship may be inclined to, I am going to persuade your lordship this is not a constitutional.
تو بہت ہی نوبل آرگومنٹ ہے.
آپ نے بڑا زبردست بحث کی کہ ہمارے چیف جسٹس کی پاور لے رہے ہیں تو انڈیپینڈنس آف جوڈیشری اور آرٹیکل 9 افیکٹ ہو گیا ہے.
Yes, the deviation is that a procedure other than the rules of the
جیسے میں
Supreme Court.
وضاحت کرنا چاہتا ہوں میں نے آپ کو اپنا وکیل نہیں کیا تھا شکریہ لوگ یہ نہ سمجھ بیٹھے کہ آپ نے میری وکالت کر
But I have to assist you the way the law in this country is developed.
چلتے آگے نا
صدیقی صاحب ایک چیف جسٹس آپ کے نہیں ہیں اس قوم کے ہیں اور قوم کے نمائندے پارلیمنٹ میں بیٹھے ہیں انہوں نے کہا کہ چیف جسٹس کو ایسے ہونا چاہیے سپریم کورٹ کو ایسے ہونا چاہیے آپ نے بتایا
آئین کو بھی دیکھ لینا پہلے
آئین تو
آئین کے دیکھے بغیر
آئین تو کہتے ہیں سپریم کورٹ کرے گا سب کچھ
سر دس از واٹ آئی ایم سیئنگ
تو آپ تو کہتے ہیں چیف جسٹس
نو نو آئی سے
آپ ابھی تک یہ ڈفرنس نہیں کلیئر
نو آئی ایم مجھے آپ الاؤ کریں گے پروسیڈ کرنے تو کروں
سب انفورسمنٹ آف رائٹس کون سی انفورسمنٹ کرنا
9 کے بعد
10 میں کیا ہے
10 میں کون سا نو یہ تو
No person who is arrested shall be detained.
اس بات سے ہماری
سر مجھے آپ پلیز
نہیں یہ نہیں آپ کہ میں صبح سے سکھ 1 سے سکھ 260 تک پڑھوں گا نہیں سوری یہ جو ہمارا ٹائم ہے نا اس پبلک منی ٹھیک ہے آپ یہ نہیں کہیں گے میں جو مرضی آرگیو کروں آپ اس کی ہمیں ریلیونس سوری ایسے نہیں آرگیومنٹس ہوں گے
صاحب جب آپ مان گئے ہیں کہ یہ بہترین قانون ہے چیف جسٹس کے اختیار جو کلی تھے وہ نہیں ہونے چاہیے تھے دیور ان کا استعمال صحیح نہیں ہوا اب اس کے بیونڈ آپ جائیں آپ صرف اب یہ کہہ رہے ہیں کہ یہ پارلیمنٹ کا اختیار نہیں تھا وہ بتا دیجئے گا
میں نہیں مان رہا کہ یہ بہت اچھا قانون ہے میں کیا یہ اس کا خیال بہت اچھا ہوگا
آپ چاہتے ہیں
قانون
آپ چاہتے ہیں کہ چیف جسٹس کے پاس کلی اختیار ہو
میں نہیں چاہتا آپ نے دیا رولز کے اندر
نہیں اوہو آپ اس کو چھوڑ دیجئے گا نا ہم نے
چھوڑ دی سر آپ نے رولز
کیا آپ کے نزدیک ایک شخص کے پاس انفیٹڈ انبریڈلڈ ان اکاؤنٹیبل انٹریملڈ پاور ہونی چاہیے یہاں پہ the power has been given to the chief justice and to senior most judges
یہ بہت اچھی بات ہے سر جو آپ کر رہے ہیں بٹ کانسٹیٹیوشن چیف جسٹس صاحب کو بہت پاور دے رہا ہے لیٹ اس ہیو اے لک ایٹ آرٹیکل 10 آرٹیکل 10 تو دیکھ لیجیے
ایک سیکنڈ ذرا اس کا فارمیٹ ٹھیک کر لیتے ہیں بحث کا صرف ہمیں پہلا سوال ہم پوچھ رہے ہیں کہ 184 میں آنے سے پہلے فنڈامنٹل رائٹس واضح کر دیں کون سا وائلیٹ ہو
Your lordship held that when a law is made or election is taken which violates the constitutional scheme it is a violation of fundamental right.
تو اسکیم میں کون سی پروویژن بتائیں نا
سر میں آپ مجھے الاؤ کریں
گے تو اجازت بتائیے
the law the constitution requires under the constitution and I will read the relevant article to some breather by your lordships that in the context of the trichotomy of powers the parliament will make its own rules the executive will make its own rules the Supreme Court will make its own rules for functioning and those rules have a constitutional force and they are of a higher pedestal than the ordinary law. This
جب آپ نے ہم نے جو آپ سے شروع کیا تھا حقوق کی بات اب وہ آپ نے ترک کر دی آپ
میں تو آپ جواب دیں
نہیں جواب نہ دیجئے پلیز آپ آرگیو کیجئے ہم آپ کی آسانی پیدا کر رہے ہیں بعد میں جواب دے دیجئے گا کیونکہ آپ دیکھیں میں بھی وکیل رہ چکا ہوں جب 6-7 سوال آتے ہیں بڑا مشکل ہوتا ہے ٹھیک ہے اب آپ نے پہلے جواب دے دیا تھا بالکل قانون صحیح ہے مگر جب مائی لارڈ نے سوال دوبارہ پوچھا اب آپ نے ٹھہر جائیے نا جیسے وٹنس کہتا ہے نا اگین سیز جس کو ڈسکارڈ کر دیا جاتا ہے تو ہم آپ کو بچانے کی کوشش کر رہے ہیں کہ آپ سن لیجئے آرگیو آپ کیجئے آپ کا کیس ہے مگر بتائیں بنیادی حقوق کون سا سلب ہو گیا یہ بتا دیں بس
اگر آپ اگر کو اپلیکیبل کرنے کے لیے پہلے ہمیں بتا دیں کہ کون سے فنڈامنٹل رائٹ کو انفورس کرنا چاہتے ہیں جو انفرنج ہوئے ہیں پہلے اس پہ آئیے تاکہ وائی ناٹ 199 یہی پاور ہائی کورٹ کے پاس ہے وہاں کیوں نہیں گئے
I am asking your lordship to recognize my fundamental right given in article 9, 10, 10A. سر میں نے پڑھا آپ کے سامنے
بس یہی آرگیومنٹ ہے آپ کا
سر میں پڑھ رہا ہوں آگے
نہیں آپ بتا ہی نہیں رہے کوئی پروپوزیشن ہی نہیں ڈیولپ کر رہے ہیں آپ
My proposition مجھے آپ my proposition is that the legislature is bound by the scheme of the constitution and the constitution requires that The
اچھا اب ہم نے فیصلہ کیا آپ سے سوال نہیں کریں گے.
The Constitution requires that the legislature will make its own rules. The Constitution requires
Petition, یہ آپ نے ابھی بات کی میں نے نوٹ کر لیا.
3 different organs of the state ہیں. They will function independent of one another. One will not make encroachment on the other.
اور یہاں تک پہنچنے میں ہم نے بنیادی باتیں تو پتہ ہے نا, آگے بڑھیے نا.
It is my fundamental right to ensure and protect that this constitutional encroachment is not made by the parliament.
ٹھیک سمجھ گئے. اگلا پوائنٹ.
And there are judgments on the issue which says that these are issues of fundamental violation of fundamental right, deviation from the constitution, and if it affects a large community of people, then it is a question of public importance. اور ججمنٹ ہیں آپ نوٹ کر لیں. میں صرف ججمنٹ پڑھنے میں چاہوں گا, this is so fundamental a question. There are numerous judgments.
یہ اس بات کا تعین کرنا
جی
آپ کے پاس اختیار ہے. جیسے منصور شاہ صاحب نے ذکر کیا کہ یہ اختیار ایکسپریس ہوتا ہے, یا تو ہم ریفرینڈم کرا لیں جہاں ہر مارشل اور ڈکٹیٹر کو 98.6% ووٹ ہمیشہ ملتے ہیں.
اچھا
سن لیجیے نا ذرا پلیز, تسلی رکھ لیں.
جی سر, نہیں سن رہا.
یا ہمیں کیا پتا لوگوں کو کیا چاہیے, اس کی عکاسی ان کے نمائندے, الیکٹڈ نمائندے کرتے ہیں. ٹھیک ہے, جس کو الیکٹ کریں ان کی مرضی ہے, وہ اس کی عکاسی کرتے ہیں. ہم یہاں تو کوئی پول اگر ہم ادھر کھڑ کر میں پوچھ لوں سب سے کاز ان فیور آف دس لا ہے, آپ کو کون حق دیتا ہے یہ کرنے کا؟ آپ کو یہ دیتا ہے کہ انفورسمنٹ آف فنڈامنٹل رائٹس کی بات کریں. آپ وہ بات ہی نہیں کر رہے ہیں. آپ نے بس 8 9 10 بس کوئی آرگیومنٹ ڈیولپ کیجئے. حضور ایسے نہیں ہوا آرگیومنٹ.
Your lordships have had.
امتیاز صاحب ایک دفعہ پھر ایک چیز کلیئر کر دیں. اگر یہ قانون صرف چیف جسٹس کے اختیار کو ڈائلیوٹ کرتا ہے, آپ سمجھتے ہیں کہ یہ اچھی چیز ہے؟
آبجیکٹیو اچھا ہے, پروسیجر انکانسٹیٹیوشنل ہے.
ایک سیکنڈ, اس کا مطلب ہے اس سے آپ کے اور پبلک کے فنڈامنٹل رائٹس انفورس ہو رہے ہیں. سیکنڈلی, اگر رائٹ آف اپیل دیا جا رہا ہے وہ بھی بہت اچھی بات ہے, اس سے وائلیٹ نہیں ہو رہا ہے, اس سے انفورس ہو رہے. تو اب
آئین کو مد نظر رکھیں گے کہ نہیں؟
سن تو لینا. اب آپ کا صرف کوشچن یہ رہ گیا ہے کہ جی یہ بہت اچھی چیزیں ہیں, آپ ان الیکٹڈ ججز کر لیں, لیکن وہ پارلیمنٹ نہیں کر سکتی تھی. بھلے آپ ریفیوز بھی کریں وہ پھر بھی بے بس ہے. چلے ہم آپ کی یہ بھی بات
بے بس نہیں ہے.
ایک سیکنڈ اب آپ بتا دیجئے کانسٹیٹیوشن میں ایگزیکٹلی 191 پڑھ لیجئے گا, اس کا مطلب ہے نو فنڈامنٹل رائٹ.
مجھے ابھی تک آپ نے نہ آرٹیکلز دیے ہیں نہ مجھے سبمیشن کرنے دیے.
بتائیے پلیز بتائیے.
آرٹیکل
4 9 10 10A
فنڈامنٹل رائٹ جو ہے اس کو ہم انفورس کرنا چاہتے ہیں. سر وہ پڑھیے پلیز.
سر میں نے آپ کو کہا ہے کہ when due process is not followed in making a legislation by the parliament, forget about the objective. And if I am able to demonstrate to your lordships that a constitutional deviation has taken place, then the question of fundamental right violation occurs. Whether it occurs in rem or in personam is the next question.
اب سمجھ آئی آپ کی بات. وہ یہ کہ قانون کا آبجیکٹو تو شاید عام آدمی کے لیے اچھا ہے, لیکن پروسیجر جو اڈاپٹ ہوا ہے یہ ہمیں بنانا چاہیے تھا, پارلیمنٹ نے کیوں بنا دیا, یہ سوال ہے.
اب آبجیکٹ
is not access to justice fundamental right now recognized as such?
Yes, it is.
Is not independence of judiciary an integral aspect of access to justice?
Indeed it is.
Therefore, is not independence of judiciary itself a fundamental right?
It is.
Is not independence of judiciary a salient feature of the Constitution?
It is.
Held by full court. Do you think every time the full court sits, that allows the Supreme Court, sitting as full court, to reset the entire constitutional scheme?
It would be unfortunate unless it is done with valid reasons.
بات ہی نہیں سن رہے ہیں, سوال ہی نہیں سن رہے ہیں, آپ جواب پھر وہی کر رہے ہیں.
In a system based on the common law UK tradition, Is it just the black and white language of the Constitution that is constitutional law, or is that embedded in constitutional law as developed by the case law? In relation to the US Constitution, it is said that 9/10 of US constitutional law is not written in the US Constitution. As sitting as a full court, each time a full court is constituted, is that like a tabula rasa, a blank slate, that we can write on it whatever we want and disregard settled law, fundamental rights? Is this within the power even of a full court? If we are to do that as a full court, disregarding previous precedents, then surely we have to have some weighty reasons to declare, for example, today that independence of judiciary is not a salient feature of the Constitution. That independence of judiciary is not a fundamental right. If it is not a fundamental right, out goes access to justice. It's not a question of speaking for myself, but putting it as a question to you of whether it is the Chief Justice or the 3-member committee. Who is Parliament to say it's a 3-member committee? Why shouldn't it be a 5-member committee? Why shouldn't it be a 7-member committee? If the answer is that the Supreme Court means the Chief Justice and all the courts, then Parliament should have made a law saying this committee shall constitute of the Chief Justice and all the judges of the Supreme Court. That is, they are the ones who will decide whatever is written in Section 2 and whatever is written in Section 3. Can Parliament pick and choose? Can Parliament say, no, judges is okay with us? 5 judges is too much. 1 judge is too little. These are aspects that go to the independence of the judiciary. Today, Parliament says not less than 5 judges to hear interpretation. Section Section 4. Tomorrow, Parliament says, "जी एक law बना देती है जी." I don't know. Family matters are to be heard by a bench of less than 7 judges. Is that part of the access to justice? Is that part of independence of judiciary?
It is.
Fundamental rights. अभी आप देखें अमेरिका में कितना वो बना हुआ है, वो जो है आपका राइट ऑफ अबॉर्शन, वो कहाँ लिखा है कॉन्स्टिट्यूशन में? लिखा है उनकी कॉन्स्टिट्यूशन? नहीं लिखा था, वो राइट दे दिया, पेनम्बरा में आ गया ना। उसके बाद उन्होंने कहा वो ओरिजिनलिज्म पे लोग जा रहे हैं कि जी बस आप देखिए उसके अल्फाज में लिखा है तो लिखा है, वरना नहीं लिखा, और वो भी जो 200 साल पहले की इंटरप्रिटेशन है। Is this the state of the law in Pakistan?
It is not.
Is this the state of the law in terms of even full court judgments? But as a full court, as the Supreme Court, as the defenders of the Constitution, the question is, are we to allow any erosion of independence of judiciary, access to justice, and would that not be the grossest violation of fundamental rights?
Need, my lord.
With respect, अगर देखें सिद्दीकी साहब, मुझे अभी तक आपके खूबसूरत दलाइल से मैं मुफीद नहीं हो पा रहा हूँ। आप जरा अपने दलाइल अपनी मर्जी से कर लें। आप सवाल नोट कर लीजिए, आप हर चीज पे कमेंट, आप अपना दलाइल तो देना चाह, फिर आप कल आप कहेंगे कि मेरे दलाइल ही नहीं सुने जा करके। आप चलें थोड़ा बढ़ा लें आगे बात को।
With great respect to my brother, independence judiciary is not just the external aspect. The most important is internal independence and institutional independence. अब आपने concede कर लिया कि this is a law which actually secures the internal and institutional independence. So, ओहो, एक सेकंड, अच्छा लॉ है। इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस क्या होता है? अगर एक चीफ जस्टिस के पास इख्तियार हो और वो इख्तियार इस्तेमाल हो सके to achieve certain outcomes in cases and by constituting benches, that is a complete erosion of independent judiciary. And this is an aspect which this court has never taken into consideration. So that is, दुनिया भर में, this is the most important aspect of independence of judiciary.
आपको पता है बाकी मुल्कों में क्या होता है? जुडिशल कैलेंडर स्टार्ट होने से पहले फुल कोर्ट बैठता है और वो बैलेट से बेंचेस बनते हैं, चीफ जस्टिस नहीं बनाता। और बाहर अगर आप ये बात करें कि चीफ जस्टिस बेंच बनाता है, तो वो शायद इस बात को एक्सेप्ट कर सकते हैं, या बैलेट होता है या रेफल। कंट्रीज लाइक नेपाल, ये स्टार्ट ऑफ द कैलेंडर ईयर पहले बैलेट होता है कि बेंचेस कैसे होंगी। चीफ जस्टिस का कोई इख्तियार नहीं कि केस आज आया है और कल मैं अपनी मर्जी का एक बेंच बना दूं इस केस को सुनने का, जिसको मर्जी मैं बिठा दूं। ये चीजें तो ये सारा कानून जो है ये वाजे कर रहे हैं इन चीजों को, इंडिपेंडेंस को तो बेहतर कर रहा है, स्ट्रॉन्ग कर रहा है।
आपने रूल्स बनाए हैं, उस रूल्स के अंदर बात की जा रही है। आपकी जजमेंट अपनी है।
जवाब दे रहे हैं, आप दलाइल नहीं देना चाहते हैं, आप जवाब ना दें, दलाइल दे दें।
आप इस तरह कीजिए कि आप अपने
अपने
दलाइल
एस्पेक्ट अभी जो आप बात कर रहे हैं,
आप अपने दलाइल मुकम्मल कर लें।
वर्ड आर्टिकल 191 में लॉ लिखा है, whereas for example in relation to the review jurisdiction उसमें act of parliament लिखा है। It seems to me that even now if you go literal text of the constitution, that there is presumably a difference between the two, and law is in a common law tradition like Pakistan is well understood to mean statute law and judgment or case law.
Yes.
Now, Article 199 sets apparently a hierarchy. First is constitution, fundamental right, independence of judiciary. Next is law. Now, if law means, there's a question to you, if law means statute law and case law, the two are then co-equal because both are incorporated in law. So the question that strikes me is that this whole principle, rule, whatever you want to call it, that the Chief Justice is the master of the roster, in fact is not in Order 11. It is given in judgments of the Supreme Court, in law. So the question therefore is, can Parliament, which is operating at the same level, law, co-equal, can Parliament make, in the context of Article 191, and this goes to Section 8 of this particular law, can it make a law overriding in relation to the practice and procedure of the court, judge-made law, which is at the same pedestal? Can they do that?
No, they cannot.
Seems to me that even if we literally look at Article 191, perhaps it is unconstitutional.
जैसा फिर अगर आपको कोई दलाइल नहीं देना है, और नहीं सुन लीजिए ना, आप तो हर के जवाब ही दे रहे हैं, तो आप अपनी पिटीशन तो आर्ग्यू नहीं कर रहे हैं, मुझे नहीं लग रहा है। आप कोई दलाइल, आप दलाइल देके खत्म कर रहे हैं, फिर आपसे सवाल पूछ लेंगे आखिर में, हमारे जहनों में होंगे, ठीक है, या हम अपने जजमेंट्स में लिख देंगे, हर जज अपनी राय लिख देगा अपनी मर्जी से। आप प्लीज अपने दलाइल दीजिए।
May I proceed on?
जी प्लीज।
सिर्फ I'll only make one observation. It is settled law by law that the Parliament has the power to make our judgments ineffective, and this is a precedent जो कि is embedded in our constitution.
If they are lawfully empowered, if the Parliament is lawfully empowered, not otherwise.
फिर आप बहस करने लगे।
But surely that
आप सुन तो लीजिए ना बात को, फिर आप नोट कर लें भाई, आप आर्ग्यूमेंट्स होते हैं, आप जज नहीं हैं, आप हर चीज का वैसे जवाब दे रहे हैं।
May I proceed?
प्लीज डू सो।
आपको इसके एक जरा supplemental
आप चलिए शुरू कीजिए, बिस्मिल्लाह कीजिए।
My learned brother asked you, surely that rule that Parliament can override judgments of the Supreme Court does not apply to a judgment which is interpreting constitutional setting or interpreting the Constitution or setting or establishing constitutional law. That only either can be done by constitutional amendment or if the court itself revisits that view. I thought that was also settled.
Yes.
तो देखिए साहब जरा एक क्वेश्चन है, आपका कहना ये है कि 3 members अगर बैठ के बेंचेस बनाएंगे एज पर दिस लॉ, तो ये इंडिपेंडेंस ऑफ जुडिशरी पर के खिलाफ है। तो क्या हम 17 जजेस बैठकर जब रूल बनाएंगे, हम कोई ऐसा रूल बना सकते हैं जो जुडिशरी की इंडिपेंडेंस को लेके एक शख्स के हवाले कर दे, या ऐसा रूल बनाएं जो कॉन्स्टिट्यूशन के, क्या हम ऐसा कर सकते हैं?
सर कर तो सकते हैं, आपने अगर एक बंदे को
अनलिमिटेड पावर्स है।
My lord, just one minute. May I request my brothers, इनको बहस तो करने दीजिए, हम सब सवाल बाद में कर लेंगे। आप प्लीज अपने हिसाब से अपने आर्गू कीजिए।
See, Mr. Siddiqui, if I may just add, It is not a question of ये law गलत है या ये law बुरा है या अच्छा है. The fundamental question here is of competence.
Yes.
Who is competent to make whatever it may be called the rules of the law if
ये तो आपने आर्ग्यू ही नहीं किया अभी तक.
competent?
तो मैं ये तो कह रहा हूँ,
आप हमें रोकें, आप क्या मुझे आर्गुमेंट सुन
सर,
लीजिए.
मैं तो कह रहा हूँ कि कॉम्पिटेंस नहीं है पार्लियामेंट.
आप बताएं ना, हमें शिक दें कायन की.
डायरेक्ट उसी पे आ जाए मेरे ख्याल में.
इसी पे आ जाए, यही सवाल है.
देखिए मैं आप देखिए, आप हमसे ज्यादा समझते हैं, वकील हैं, यकीन हम लोगों की अपनी अपनी राय हैं, ठीक है.
मुझे आप
जरा सुन लीजिए ना 2 मिनट जी. वो हम अपने, अगर हम एक दूसरे से इत्तेफाक नहीं करेंगे, अलग अलग राय लिख देंगे, ठीक है. मेरे हिसाब से मुनासिब नहीं है कि हम सवाल के तौर पे अपनी राय आपको दें और फिर कोई हम दूसरा जवाब दें. हम सिर्फ सवाल पूछ रहेंगे आपसे, आखिर में आप अपने दलाइल दे दीजिए, हम उसको नोट कर लेते हैं. हमें पसंद नहीं आए तो फिर हम सवाल, इतने पसंद आए शायद सवाल ही ना पूछें, नहीं पसंद आए 2-4 सवाल पूछ लेंगे. अब आप बिस्मिल्लाह कीजिए जी.
Lord, the concept of trichotomy of power is a concept well known to your lordships. The Constitution, what are those provisions which relate to the trichotomy of power, and let us have a look at them. With reference to the Supreme Court, have a look at Article 176, my lord.
जी.
Article 176.
जी पढ़िए.
My lord, Article 176 says, the Supreme Court shall consist of a Chief Justice, to be known as the Chief Justice of Pakistan, and so many other judges as may be determined by Act of Majlis Shura, Parliament, or until so determined as may be fixed by the President. What this article says is that one of the first steps in the appointment of the Chief Justice is the centrifugal force, is the linchpin, and once he's appointed and the rest of these members are not appointed, the Supreme Court will be there. And then the judges will be appointed.
Please चलिए ना, don't state the obvious, it's written there. देखिए, this is
आप-
really,
आप-
no,
यही तो
sorry
मुझे
to say,
अफसोस हो रहा है।
आपको पता है अवाम कितनी पैसे खर्च कर रही है.
सर,
हमने
मैं
ये आप
अवाम की खिदमत के
ऐसी
लिए-
बातें तो ना करें हजूर.
सर, आप मुझे आर्ग्यू, तो आप एक तरफ कहते हैं आर्ग्यू करें, दूसरी तरफ आप मुझे
आप कह रहे हैं ये आपने पढ़ लिया.
I am interpreting, I am just
Don't
giving
need
your
interpretation of the obvious. Supreme Court comprises of Chief Justice and Judges of the Supreme Court. Obvious.
No, it is not.
अच्छा, it's not.
It is not.
बताइए.
I am giving you, your lordship, a circumstance that let us assume, to understand the dynamic of Article 176, that assume there is a Chief Justice and there is no other judge. The question is, will the Supreme Court come into existence? The answer is
I
yes.
will not answer your question.
It
We are
will-
not
I
here.
am answering-
We
I
are
am
not here in a
answering.
theoretical realm. Please don't. No, now this is
will.
not fair. We are not here in a theoretical realm to
Let
discuss
us proceed
what
for-
may or may not
Let
happen.
us
We are
proceed-
faced with a particular law. You challenge that law. Argue that case.
Let us proceed further. Let us go to Article 87. Article 87 relates to the Parliament and the Senate. Each house shall have a separate secretariat. It is provided that nothing in this clause shall be construed as preventing the creation of posts common to both the houses. Sub-Article 2, Majlis Shura Parliament may by law regulate the recruitment and condition of service of persons appointed to the secretarial staff of either house. Until provision 3, until provision is made by Majlis Shura under clause 2, the Speaker or as the case may be, the Chairman may with the approval of the President make rules regulating the recruitment and conditions of service of person appointed to the Secretarial Staff of the National Assembly or Senate. So this is the rule-making power. Let's go to Article 67.
I will not allow it, and I might even start imposing costs. Let's go here, let's go there. What's the relevance of Article 187? Don't do
It
this.
shows-
Sorry,
it-
please
my
don't
lord,
do this.
it shows-
Please don't do this. Huh?
It shows that the parliament as a separate organ of the state
Profound.
has the power to make rules for its internal working. And this is the theme which is contained in Article 67.
नो ये रूल्स सिर्फ बनाएंगे किसके लिए? सेक्रेटेरिएट
हमने तो नहीं बनाए लिए।
अपॉइंटमेंट के लिए,
Constitution-
रिक्रूटमेंट के लिए और उसके लिए 3 चीजें लिखी हुई हैं सर।
सर, मैं आपको शो ये करना चाह रहा हूँ कि पार्लियामेंट का अलग सेट ऑफ रूल्स है, एग्जेक्टिव का अलग है, सुप्रीम कोर्ट का अलग है, और ये रूल्स जो हैं
आप
ये
सुप्रीम कोर्ट वाले पे आ जाइए ना, हम पार्लियामेंट के रूल्स जब वो चैलेंज करेंगे ना आप कि उन्होंने गलत बनाए वो देख लेंगे। अभी आप सुप्रीम कोर्ट पे आ जाइए बस।
सुप्रीम कोर्ट के रूल्स हैं आर्टिकल 191।
उसकी तशरीह कर दें, खत्म।
Subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the court. Now, the law is a word which is different from the act of the parliament. It may,
Law is different from Act of Parliament.
yes, it is. Law is
So
a
this
la-
is something I've never heard before.
Yes, sir. Let me allow me to assist you. Law encompasses a lot of other things than the act of the parliament. Law includes with it itself usage having the force of law. Refer to Article 8.
यहाँ तो
In
law
the
आ
same in the same sentence, the Parliament Ain has used Constitution, law, and rules.
Sir.
And please, I'm not going to expect this kind of argument for the Supreme Court. Sorry, this is not on.
I am
नहीं
giving
देखिए
your
आप
lord-
ऐसे
no, I'm
arguments ना
giving your
कीजिए।
lordship extraordinarily good argument. If your lordship is inclined to ridicule me like that, I will not pay, I will withdraw from the case. I don't,
इम्तियाज साहब,
I don't allow this.
Please,
Imtiaz
that's your
साहब,
choice.
Your
इम्तियाज
lordship
साहब,
has constantly
इम्तियाज साहब,
thwarted my arguments again and again. Have a patience to hear my arguments.
तो ये बताएं ये जो बेचारे लोग जेल में पड़े हुए हैं ना,
तो
एक
बेचारे छोड़ दे सर।
छोड़ेंगे नहीं हम
मैं
छोड़ेंगे।
बचा रहा हूँ, मैं ऐसे ही हूँ।
हाँ नहीं,
मैं भी
उनके
नीचे से
cases
ट्रैक के
कौन
ऊपर
फैसला करेगा? एक चीज होती है अमेरिकन आइन में, वो लोग करते हैं क्या होता है, फिलिबस्टरिंग, कि जी चलते रहो। अगर आप समझ ही रहे हैं कि इस तरह से
मैं ऐसा कर ही नहीं रहा।
अब आप
अभी आपने मुझे
अब आप
point-
बोलने आपको हम सुनते हैं मगर आप हमारी बात को सुनना पसंद नहीं फरमाते हैं।
सर,
तो
मैं आपकी
देखिए-
बात आधे घंटे से सुन रहा हूँ सर।
अच्छा, चलें।
If I've got you correctly, if I've got you correctly, you're saying that law is not only the act of the parliament, because there are rules of 1980. If there were no rules, fine, they could have enacted that law. Because they have the rules of 1980, so that's why they were not empowered to pass
My lord,
any law which was contrary to it.
I would not go to that extent. Assume there are no rules. The question is whether the parliament can frame this law or not is a question which probably is not free from doubt. I would still say the parliament can't do it. Rules are imperative. If your lordship would look at Article 8,
आप फिर ये
if your
कह रहे
lordship
हैं-
would look at, if your lordship would look at Article
एक
8.
सेकंड, इम्तियाज साहब,
Sir.
ये सिंपल हो गया है। आप ये कह रहे हैं कि इस आर्टिकल में एक्सप्रेशन लॉ जो इस्तेमाल हुआ है, दिस एक्सक्लूड्स एन इनेक्टमेंट ऑफ द पार्लियामेंट।
No, my lord, I'm not saying this at all. I say law has a larger composition than the act of the parliament.
We are, at this moment, we are only concerned with an act of the parliament.
Your lordship has asked me a question, what is the scope of the word law?
Yes,
And I'm trying to assist your lordships.
In this case, it's
this
not
the law or
relevant
not?
because the law has already come.
My lord,
Question, आपने सिर्फ
I am saying that this law,
सब अपनी
to,
आसान
your lordship's assumption is that since the word law has been used in Article 191, therefore the parliament can make
फिर
this
आप
law.
उसमें जाने-
I am trying to show to your lordship, it is not the case.
See, I'll take you back to my original question,
Please, Lordship.
where under a constitutional power, this court has framed rules. Do they stand on a higher footing than ordinary legislation?
Yes, my lord, there are judgments to that effect rendered by your lordships.
Can I ask a question as well? When the Constitution makes a distinction in different articles using the Act of Parliament and using the word law. So how do you see that distinction? So for example, in 191, they could have said subject to the Constitution and Act of Parliament, but instead of saying that, they've used the word subject to the Constitution and the law. There are other provisions of the Constitution which don't use the word law, but use the word Act of Parliament. So there is a clear difference between an Act of Parliament and the word law. So what do you understand by the word law? Because this provision of making rules is subject to the Constitution and the law.
Well,
The framers of the Constitution were conscious of the distinction between an act of the Parliament and the law. While they envisaged that law includes judge-made law and other variations of the law, Act of Parliament was specifically used in a particular sense. And they can't be used interchangeably.
And whether this enactment, Act of Parliament, cannot be considered as law?
My
Is
Lord,
it not a law?
in ordinary parlance, there may be impression.
No, I'm talking specifically
But
about this.
within
Whether
the context of Article 199,
this is not law.
it is the Constitution and law. It would mean law in a broader context. And what are those? Laws which are protected under Article 270AA. Usage or customary practice having the force of law in terms of Article 8, and judge-made law, the judicial precedents which your lordships have given time to time to the people of Pakistan to show to them what law is.
I got your point. You say that every usage, custom can be considered as law, but cannot be considered as act of the parliament.
Yes.
Whereas act of the can be considered as act of the parliament as well as law.
Yes.
So then it is not a law.
I am saying the context in which the word law has been used in the phraseology of Article 191 manifests that this is not an ordinary act of parliament. It means the law which has been rendered from time to time in the form of judgments of the Superior Court.
Do you think, or are you arguing that it is the exclusive power of this court under Article 191 to make rules?
Absolutely.
And those rules, once that power has been exercised, whether by specifically making rules or through law that is judge-made law, ordinary legislation cannot override that because there is no legislative competence to do that in terms of item 51.
That is precisely my argument. I will go a step further.
Vicky, before you do that, that's very interesting. I was just recalling the equivalent provision in the Indian Constitution is Article 145 relating to the rules of the Supreme Court. Now this has very interesting language. It is subject to the provisions of any law made by Parliament.
Yes.
The Supreme Court may from time to time with the approval of the President make rules, etc. So here, in relation to law, they are clarifying it is statute law or made by Parliament. Whereas in our case, it is just law. So the rules, the law includes any decision of the court which sets out the practice and procedure of the court. And to that extent, statute law cannot override it, cannot supplant it, cannot whittle it down until the court itself revisits that law on the judicial side. It cannot even be done by the full court sitting on the administrative side.
Can't
go back because there is a certain equivalence between what the court can do on the administrative side to make its rules and what Parliament can do maybe in terms of statute law. But it seems to me that use of, speaking for myself, the use of the word law includes case law or judge-made law, even The full court on the administrative side cannot overrule that. So this rule, which is supposedly overruled by sections 2 and 3, master of the roster, that is judge-made law. And therefore, even the full court sitting on the administrative side can't do it unless the court revisits that principle on the judicial side.
Imtiaz Saab?
Lord,
Imtiaz Saab, how will we read into this provision 191? It's a constitutional provision. We'll have to read into it that the law only means judgment law. फिर अगर आपका आर्ग्यूमेंट ले लिया जाए तो इस लॉ एक्सप्रेशन से enactment is excluded, but even a usage or a custom override a rule made by all of us.
My Lord, my submission is as follows. Allow me just follow your Lordship's conclusion. My Lord, the Constitution as I read it, and I make submission with respect to your Lordships, the Supreme Court of Pakistan has held that notwithstanding the rules and the rules which are framed under the constitutional scheme, they are on a higher pedestal than ordinary law. Even conventions which have been judicially recognized by the superior courts are constitution by themselves, and the parliament cannot encroach upon them.
This
is
next point.
इम्तियाज साहब पहले इस फंडामेंटल उसको क्लियर कर दें. Do we have to read into the expression law that is it is only confined to the judgments of this court and the precedent?
Your Lordship will appreciate the contours of the word law, which has been used with reference to the Constitution in terms of Article 181 and the scope of that word. And if your Lordships come to the conclusion that this includes the case law rendered by the superior courts have said that even conventions, if they are proven before the court in the constitutional domain, they are the constitution themselves and violation cannot take place.
ये जो लॉ है आपके ख्याल में ये 191 में नहीं आता, ये किस कैटेगरी का लॉ है
ये कैटेगरी सर अनकॉन्स्टिट्यूशनल लॉ है, ये आते ही नहीं है.
In which category you will fall this law, because you
This is
say
act
that
of the
Article
Parliament.
191, the definition of law is something else which you are trying to
This is
argue.
an act of the parliament. It comes out of the scheme of the word law, and there are other sources
How
of
it
law.
is out of the word scheme of law? What is your argument on this point?
My argument is that to isolate the word law with reference to act of parliament alone.
What about Article 140 and 141, where is also the word law has been
Yes,
used?
what I'm saying this is that Article 141 and 142
Article of the Constitution in which the laws are made by the Parliament.
Well,
And
Lord,
under Article 141, the law is mentioned. If it is not the law, then what is the category of this
Well,
law?
Lord,
Because
Article
we are going to
1
develop a new jurisprudence in this case. The
Article-
third category of law.
Article 141 has to be read with the fourth schedule, and it cannot be read in isolation. What it means is that these are the laws which will be enacted through Act of Parliament.
No, if you will read Article 142, if you will read Article 142,
सिद्दीकी
the
साहब अगर
Majlis Shura,
सिद्दीकी साहब अगर कॉम्पिटेंस की बात है ना, कॉम्पिटेंस की अगर बात जो बार बार सवाल हो रहा है, तो एंट्री 55 और 59 को पढ़ लें, तो उसमें तो पावर है ना कि पावर्स पर लॉ आ सकता है.
Sir, law enlargement के लिए, for example,
आगे पढ़े ना, सप्लीमेंट्री पावर्स भी दे सकता है.
सर ये सप्लीमेंटल पावर नहीं
ये
है,
बहस आप
ये
कर सकते हैं.
इंटरनल वर्किंग को इंटरफियर किए जा
हो
रहे हैं.
गया, तो आप ये बहस करें ना कि ये सप्लीमेंटल पावर्स के अंदर है या नहीं है, या एंसिलरी पावर्स के अंदर है कि
Sir,
नहीं. आप तो कह रहे हैं लॉ ही नहीं बना
तो सर मैं बताता रहा हूँ, मैं आपसे कह रहा हूँ कि अगर ये लॉ ये हो कि आपको फॉर एग्जांपल इलेक्शन एक्ट के तहत डायरेक्ट अपील दी जा रही है सुप्रीम कोर्ट में या सर्विस मैटर्स में दी जा रही है, तो वो इनलार्जमेंट ऑफ जुरिसडिक्शन होती है, लेकिन आपकी इंटरनल वर्किंग के अंदर लॉ फ्रेम नहीं हो सकता.
देखिए ना, एक सेकंड, बड़ा सिंपल सा सवाल है, अगर हम फोकस कर लें तो बड़ी जल्दी मामला हल हो सकता है. एक तो ये है कि लॉ इन्विजिज किया 191 ने, तो कानून आइन रिडंडेंट नहीं होता, कुछ चीज़ कानून ऐसा हो सकता है. उसी आइन के अंदर लिखा है कि 55 में सप्लीमेंटल पावर्स दे सकता है, 59 में लिखा है और एंसिलरी मैटर्स भी देख सकता है. अब आपने सिर्फ हमें ये बताना है कि क्या पार्लियामेंट ऐसा कोई بنا سکتی ہے 55, 59 اور بھی شاید ایک آدھ پروویژن انٹری کے تحت جو ریگولیٹ کر لے افیئرز آف دی سپریم کورٹ.
سر
کیونکہ 191 انویزج کرتا ہے کہ ایسا قانون ہو سکتا ہے. تو سن لیجئے, تو وہ قانون ریڈنڈنٹ تو لفظ نہیں ہو سکتا نا 191 میں. ایک قانون ایسا ہو سکتا ہے کوئی جو ریگولیٹ کرے پروسیجر کو, اس کی پاور 55 اور 59 میں دی ہوئی ہے. آپ کا یہ بحث ہو سکتی ہے کہ سر اس میں وہ پاور نہیں نکلتی فیڈرل گورنمنٹ, فیڈرل لیجسلیچر کی, وہ آپ بتا دیں ہمیں بس سیدھا.
سر دس item 55 first makes a prohibition.
وہ ہم نے پڑھ لیا. میں آخری
سر
لائن
مجھے آپ نے پڑھ لی ہے, میں بھی ساری زندگی I've been rubbing shoulders with your lordship. This creates an impediment on the word jurisdiction and power. اس کے اوپر تو full stop ہے.
اس کو پورا پڑھیے نا ملا کے,
سر
بٹس اینڈ پیسز
سر میں دوبارہ پڑھوں گا تو وہ کہیں گے کہ دوبارہ پڑھ رہے ہیں آپ.
نہیں, اس میں آگے جا
Jurisdiction and power of all courts except the Supreme Court. یہ jurisdiction and power پہ نہیں آپ law بنا سکتے.
آگے چلیں.
With respect to any matter in the list and to such extent as is expressly authorized by the Constitution, the enlargement of jurisdiction of the Supreme
یہ
Court.
بنا سکتے ہیں نا.
Enlargement ہو سکتی ہے.
آگے
بس
Enlargement کے لیے بھی there has to be a specific, یہ جو language used ہے, specific authorization.
Yes.
Now where is the specific authorization?
آگے پڑھیں, اگر آپ سے آگے پڑھیں انلارجمنٹ
And the conferring thereon of supplemental powers.
سپلیمنٹل پاورز پارلیمنٹ لگا سکتا ہے, دے سکتا ہے سپریم کورٹ کو.
Supplemental powers یہ ہے کہ آپ کو وہ کہہ سکتا ہے کہ آپ فائنینس سے یہ پیسہ withdraw کر سکتے ہیں, یا آپ یہ لیٹیگنٹ کو کوئی اپیل آئی ہے تو اس پہ یہ ٹکٹ لگا کے پیسہ سپریم کورٹ میں ڈپازٹ ہو سکے. یہ سپلیمنٹل پاورز ہیں. وہ یہ نہیں کہہ سکتے کہ چیف جسٹس صاحب اکیلے فیصلہ نہیں کریں گے, ہم نہیں مانتے اس بات کو.
پاور دے رہے ہیں کہ 4 اور
وہ یہ نہیں کہہ رہے, وہ ریگولیٹ کر رہے ہیں پاور آف دی چیف جسٹس
امتیاز صاحب
ریلیٹنگ ٹو jurisdiction and powers.
دو پیس میں پڑھے نا آپ پلیز. دیکھیے اس کا یہ کانسٹیٹیوشن کا جو اس کا یہ والا انٹرپریٹیشن ہے اس کا, as such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court. ایک اینڈ کے بعد جو ہے نا وہ conferring thereon of supplemental power. اگر اس کو 1 کے ساتھ آپ ملا کے پڑھتے ہیں تو subject to Constitution and law. تو یہ والی جو بات دو حصوں میں ہے, اس کو آپ سپلیمنٹل پاور کو آپ تھوڑی دیر کے لیے الگ بھی کر دیں تو وہ اینڈ ہے, وہ اور نہیں ہے.
یہ کہہ یہ رہا ہے, یہ آرٹیکل 191, اگر آپ آرٹیکل 191 کو along with article 141 اور 142 اور item
I'm just asking article 191 جو مین ایشو ہے article 191 کا آ رہا ہے نا کہ وہ لا یہ وہ نہیں ہے, یہ کوئی اور لا ہے, بٹ subject to constitution and law. Whenever this loves use subject to, what is the interpretation of subject to?
سر سبجیکٹ ٹو کا مطلب ہے کہ
جو لا میں ہے وہ رہے گا, اس کے علاوہ آپ نے کوئی چیز بنانی ہے تو آپ نے رول اور بھی آپ بنا سکتے ہیں.
وہ کہہ یہ رہا ہے کہ اگر یہ کانسٹیٹیوشنل اسکیم کے علاوہ ان آکوپائڈ ڈومین ہے تو پھر آپ اس کے اندر کر سکتے ہیں کوئی فریمنگ آف لا, اور وہ یہ ہے کہ
آپ کی بات کا جواب ہے نا سبجیکٹ ٹو کانسٹیٹیوشن. چلیں کانسٹیٹیوشن میں تو امینڈمنٹ نہیں ہوئی, اینڈ لا, تو جو لا انہوں نے بنایا ہے وٹ ایور اٹ میں بھی جو آپ انڈر چیلنج ہے, اس لا کے مطابق آرٹیکل 191 میں وہ لا بن سکتا ہے یا نہیں بن سکتا ہے؟
سر وہ انلارجمنٹ آف جورسڈکشن کے ریفرنس سے بن سکتا ہے.
انلارجمنٹ آف جورسڈکشن بن سکتا ہے,
بن سکتا ہے.
انہوں نے کیا کیا ہے,
انہوں نے چیف
ایکٹ کے تحت انہوں نے رائٹ آف اپیل دے دیا آپ کو جو نہیں تھی, ریویو کو اسٹرانگ کر دیا, کمیٹی بنا دی. تو اب اس میں فنڈامنٹل رائٹس کی وائلیشن کدھر ہے؟ یہ ہے بنیادی چیز آرٹیکل 184(3) میں جو آپ سے پوچھ رہے ہیں نا. This is not a virus under article 199 of the constitution that can be challenged in the high court, where if you can challenge the virus of the law, but here it is article 184(3). this is the enforcement of fundamental right. Right of appeal is against the fundamental right, then okay.
امتیاز صاحب ایک اور چیز کو غالباً کنفیوز کر رہے ہیں. There is a difference between اختیار of the chief justice and the jurisdiction and power of the Supreme Court. اس پورے لاء نے سپریم کورٹ کے کسی اختیار کو نہیں چھیڑا. It's only the Chief Justice, and the Chief Justice is Supreme Court.
सर इस लॉ ने आर्टिकल रूल 9 को ऑब्लिटरेट कर दिया है और आपने इंडिविजुअल लेवल पे जजमेंट दिए हैं जहाँ पे रूल
एक सेकंड इम्तियाज साहब,
सर आप मुझे एक सेकंड ना दीजिए, मुझे सुनने मेरी बात को
सिर्फ चीफ जस्टिस का इख्तियार डाइल्यूट हुआ है ना।
सर आपने चीफ जस्टिस साहब ने खुद अपनी जजमेंट में कहा है कि रूल 9 जो है उसके तहत रिकॉन्स्टिट्यूट नहीं हो सकती जब तक चीफ जस्टिस ने कॉन्स्टिट्यूट कर दी हैं और ये जजमेंट आने के बाद ये फील्ड अनऑक्युपाइड नहीं रही।
सुप्रीम कोर्ट में चीफ जस्टिस को सेपरेट किया जा सकता है फ्रॉम द अदर जजेस?
नो।
तो फिर कैसे रूल में सुप्रीम कोर्ट को अलग करके इख्तियार दिया गया? ये बताओ।
सर आपने सरेंडर किया है, इख्तियार देना है कलेक्शन। आपने मुख्तार बनाया चीफ जस्टिस को कि हम चीफ जस्टिस की इस बात को हम ऑथराइज करते हैं।
क्या हमने कॉन्स्टिट्यूशन के मुताबिक किया?
सर आपने कॉन्स्टिट्यूशन के मुताबिक किया है, 180 में आप फॉलो करते रहे हैं।
जो जजमेंट
आपने जजमेंट दी है कि चीफ जस्टिस साहब बेंच कॉन्स्टिट्यूट करें।
जजमेंट की बात कर रहा हूँ, जो जजमेंट्स आई थी वो इस एक्ट से पहले थी और वो दैट वाज बेस्ड अपॉन द रूल्स। अब एक्ट ज्यादा बड़ा है और बड़े।
सर आप जजमेंट तो पढ़ लें, तो आपने कहा है कि ये रूल्स जो हैं ये हायर पेडिस्टल पे हैं,
पर वो
ये आपकी जजमेंट है।
जी साहब आप फुल कोर्ट के सामने बहस कर रहे हैं, जजमेंट कितने मेंबर्स की है?
सर
जजमेंट कितने मेंबर्स की है?
10 मेंबर्स। 10
हम कितने हैं?
14।
अच्छा इम्तियाज साहब
ओवररूल करना पड़ेगा सर, रीजन देके।
इम्तियाज साहब
नहीं कर सकते।
कर सकते हैं, क्यों नहीं कर सकते? वो रीजन।
इम्तियाज साहब
ठीक है, not that easy.
इम्तियाज साहब,
Referring to the Binder.
I wish things were as easy as your lordship has put
इम्तियाज
it.
साहब,
It is not.
इम्तियाज
Sir,
साहब,
sir,
अल शमरेज केस के बाद पार्लियामेंट ने एक अमेंडमेंट की एक स्टैट्यूट में। अल शमरेज केस का इफेक्ट खत्म हो गया ना,
जजमेंट को नहीं हाथ लगाया।
ओहो, उसका that law finished to an end and that is the authority of the parliament.
सर आप कोई और बात कर रहे हैं, वो बात कानून ये है सर। allow me to assist your lordship.
You see, if this court interprets the law in a certain way, a law, an ordinary law, and the parliament changes that law, nobody has stopped them from doing that.
With retrospective.
Yes, the distinction here is that here the rules which have been framed in 1980 in exercise of powers under 191, Article 191 of the Constitution, they are not interpreting any ordinary law which can be changed by ordinary legislation.
This is what my submission is, the same issue. That is the...
This power has been exercised under the Constitution, and it says so specifically in exercise of powers under Article 191 of the Constitution of Islamic Republic of Pakistan. The Supreme Court makes the following rules. So it's not that there is one ordinary legislation which is interpreted by the Supreme Court and the Parliament says, well, we want to change the law, they can change the law. Because they had made the law, they can change it. Likewise, if the Supreme Court has made the rules and the Supreme Court decides to change them, so be it. That's
the precise submission I'm really trying to make.
With the doctrine of separation of and trichotomy of powers. It's as simple as that.
My Lord, an event arose when my Lord the Chief Justice the benches were reshuffled. And a judgment...
argue kariye apna case.
And
aap apna case argue kariye.
My case has been, allow me to give your Lordship a judgment on the issue.
Ab kitna waqt aur lenge?
15 मिनट और दे दूंगा अगर क्वेश्चंस ना हो तो। Lord, this is PLD 1998 Supreme Court 161. Alak Asad Ali case.
Yearly?
Alak Asad Ali versus Federation of Pakistan.
This is page?
This is PLD 1998 Supreme Court 161.
Okay, Asad Ali.
However, the question was with reference to the entitlement of the senior most person to be the Chief Justice of Pakistan. And the question was there a convention? And if there was a convention, did it have some binding force? This was the question. The Supreme Court, I take your lordship on page 314, paragraph 95. We are inclined to agree with the conclusion that a constitutional convention once established has the same binding effect as a constitutional convention. I don't want to read the rest of the paragraph. Your lordship has already said.
So, now I have a question.
Yes.
Are you saying that the senior most judge of the High Court must be made, because there's a convention, the Chief Justice upon the don't interrupt till I finish the question, upon retirement of the Chief Justice? Have I understood you correctly?
No, my lord. Your lordship is not. Then your lordship will have to read the judgment. That judgment says that the senior most judge of the Supreme Court has to be appointed as Chief Justice because there's a convention and there's a past practice. And elaborate arguments have been given. And it is...
Convention in the High Court generally is to make senior most Chief Justice.
Well, Lord,
So it becomes constitution.
This judgment doesn't talk about the HighUrt. It talks about the
बात हो रही ना असूल की बात हो रही ना
सर
असूलों की बात हो रही है
असूल वो है जो मेरे लिए जो जजमेंट में है आप खुद बता
ओके आगे
आप बता देंगे जो असूल उसके मुताबिक
आगे
चलेंगे
बताएं
जी सर
आगे बढ़िए
Similarly, your lordship held that these rules of the Supreme Court are on a higher pedestal than the ordinary law. And
the judgment है
my lord 2010, my lord.
And why the rules are at higher pedestal? Why?
Because these rules they have been made by a constitutional body and
subject to law.
This is part of subject to law की बात
citation तो दे देना 2010
इम्तियाज
सर मैं भी दे रहा हूँ
इम्तियाज साहब
सर
दे दे मैं तक पढ़ लेता हूँ आप बता दें
This is a constitutional body and the Parliament Majlis-e-Shura, that is not
2010
which has the exclusive power to make laws.
Yearly 2010 SC 483 विंटर का लगती है
इस जजमेंट में आप क्या बताना चाह रहे हैं हमें
सर इस जजमेंट में कहा है कि सुप्रीम कोर्ट के रूल्स जो हैं
कहाँ किस पेज पे किस पैराग्राफ में
The relevant page is page 535 and it goes on to page
नहीं हमें रेलेवेंट पढ़ दीजिए 535 कहाँ लिखा है ये
It goes on to page 536. The Supreme Court rules. देखना पसंद करेंगे सर किताब The Supreme Court rules.
पेज क्या बता पेज क्या क्या
Page
Supreme Court rules are on high pedestrian promulgated on the basis of mandate given by the Constitution and not by the government. हाँ so how does it say it's higher than a law वो कहाँ लिखा है
The Supreme Court rules on a higher pedestal and promulgated on the basis of mandate by the Constitution and not by the government. Objective thereof is to enhance the power of review as conferred by the Supreme Court rules under Supreme Court under Article 180 of the Constitution.
अच्छा इसमें दो बुनियादी बातें हैं जो आप कह रहे थे उसके बरक्स है और दूसरी बात है whereof was to enhance the power of review.
सर
तो ये तो enhance कर दिया था power of review ने
सर ये क्या ये
लॉ का तो नहीं इसमें जिक्र शायद कहीं और हो मुझे नहीं पता
सर इसी जजमेंट को पढ़ें अगर आप डिटेल में कहने मैं पढ़ना शुरू कर देता हूँ इसमें
नहीं ये काम नहीं होता है वकील का काम होता है निशानदेही करे फलां सफ़े पे इस पैराग्राफ में ये नहीं कि मैं पढ़ना शुरू कर देता हूँ हमें डराए नहीं आप सिर्फ वजाहत कर दें। मैं पढ़ना शुरू कर देता हूँ।
पेज बता दीजिए प्लीज।
सिर्फ पेज बता दें, हम पढ़ लेंगे खुद। वहाँ इस पे ये बात नहीं लिखी है जो आप कह रहे हैं इस पे।
536।
हाँ, ये मैंने पढ़ ली। चलें अगला बताइए केस।
PLD 1997 Supreme Court 426. Check this case, my lord.
PLD?
PLD 1997 Supreme Court 426.
Relevant 5 and 9. 1997 PLD Supreme Court.
जी सफा
5 and 9.
511, page 511, 511. 511, page 511, 511. Perfect. Significantly, by employing the word any law, the intention of the Constitution seems to be that Article A will apply to all laws made by the Majlis-e-Shura Parliament, be it or any law to amend the Constitution. Likewise, no amendment can be made in respect of provision of the Constitution relating to judiciary by which its independence and separation from executive is undermined or compromised. These are built-in limitation in Constitution completely independent from political morality and force of public opinion.
I can agree with the proposition and still dismiss your petition. No, I'm just saying, so I don't know there is anything clincher here in your favor. It says these are inbuilt limitations in the Constitution completely independent from political morality and force of public opinion. इससे पहला बात है कि separation of executive is undermined. यहाँ तो parliamentary बात है ना, legislation.
May look at PLD 1979 Supreme Court 49.
एक सेकंड, दूसरा बता रहे हैं PLD?
PLD 1979 Supreme Court
1979 Supreme Court.
PLD 1973 Supreme Court 49. Rahman's case.
73, 79.
73.
My lord, PLD 1973 Supreme Court 49.
Relevant page?
Relevant page is 68.
68.
Then it is from 68 to 70, my lord.
To 70. ठीक.
And
see proposition पे.
Please lordship. Parliament, no law can be made compromising power of judiciary.
ठीक.
Paragraph page 70 पे मैं जरा पढ़ना चाहूँगा सर, अगर इजाज़त दे.
ठीक.
May I read, bro? May I read?
ये आपने कहा यही proposition है.
Yes, sir.
तो हम पढ़ लेंगे, आप पढ़ना चाहते पढ़ लें.
पढ़ना चाहते हैं तो पढ़ लीजिए प्लीज.
My lord, page 70.
जी.
Exercising paragraph. In exercising the power, the judiciary claims no supremacy over other organs of the government, but acts only as the administrator of public will. Even when it declares a legislative measure unconstitutional void, it does not do so because the judicial power is superior in degree or dignity to the legislative power, but because the Constitution has vested with the power to declare declare what the law is in the cases which comes before it. It is thus merely enforces the Constitution as a paramount law whenever a legislative enactment comes into conflict with it, because it is its duty to see that the Constitution prevails. It is only when the legislature fails to keep within its own constitutional limits, the judiciary steps in to enforce compliance with the Constitution.
होती है.
Yes.
लेकिन कहाँ पे है?
It is an enabling provision. How it is applicable here?
ठीक.
My lord,
और कोई केस?
it says,
और केस?
PLD 1998 Supreme Court 161 में sir, independence judiciary is a fundamental right.
Page क्या बता दे? Supreme Court.
Page 161.
161. 98 Supreme Court.
His Lordship.
Relevant.
Relevant is page 189.
जी.
247.
यही बात है अलग.
Independent judiciary is a fundamental. Independent judiciary is a fundamental right. Advocates to ensure independence of judiciary at page 190. Advocates have locus standi, page 191. Constitutional convention as good as constitution, any deviation amounts to deviation from the constitution. 321, page 331. Certain questions have been asked and I wish to respond to them.
अगर मैं आपके लिए आसान करूं, अगर हम अटॉर्नी जनरल को सुन लें, आपके सवाल हम सुनेंगे वापस, ठीक है? तो वो उनकी तरफ से कुछ एंग्जाइटी थी कि शायद उनको पाकिस्तान को रिप्रेजेंट करना है कहीं, तो वक्त बचाने के लिए आप उनके भी बात को साथ साथ कवर कर लीजिएगा, भी कवर कर लीजिएगा। अगर आप ये माकूल तरीक़ेकार समझते हैं, वो फिर चले जाएंगे। फिर
आपकी एक जजमेंट पढ़ना चाह रहा था।
नहीं, वो आप पढ़ लीजिएगा। अगर अभी क्योंकि
कहा हुआ है कि बेंचेस रिकॉन्स्टिट्यूट नहीं हो सकती।
नहीं, ठीक है,
आपने कहा डिपेंडिंग ऑन
रूल, हो सकता है गलत कहा हो, गलतियां भी हमसे हो जाती हैं, वो बात अलग है। मगर हम जरा अटॉर्नी जनरल को अगर आप लोग अग्री करें शॉर्ट ब्रेक करने के बाद, क्योंकि अटॉर्नी जनरल आपको कहीं जाना है, एक सेकंड, इनके भी हम आपको फिर देंगे हियरिंग, ये नहीं समझें कि आपको हम बंद
सर आई एम डन माय
एक आपको कहीं जाना है?
My lord, there is a hearing scheduled in Vienna on Indus Waters Treaty for 3 days starting tomorrow. So I have to fly out tonight. Tomorrow.
How long will you take?
My lord, today, sir, my submissions will be precise. I have already filed my written brief. It will take 30 minutes. And then whatever questions towards the end my lords may have, I will respond to them and might furnish a response in writing as well. So I have already filed my written brief. I'll take 30 minutes by the clock.
There's वैसे भी right of audiences with the Attorney General. Have you raised any primary legal objections to maintainability or not?
Yes, my lord, I have a.
ठीक है, तो I think we'll take a short break.
My lord.
आप ठीक है, आप अग्री करते हैं? नहीं, ये आप इनकी भी बातें सुन लीजिए।
Do I have a choice? I don't have a choice. No, I don't have a choice.
You have a choice.
You're most kind. If you agree with me, I'll be obliged.
It's a rare.
But we will hear you.
My lord, it's a rare moment during these proceedings that I agree with your lordship.
नहीं, आपने बड़े
Otherwise, from morning I have not been agreeing with your lordship.
तो आप हम अभी will let's say we'll come back at 3 or 10 to 3 कर लेते हैं।
10 to 3.
ठीक है?
Grateful.
चलिए 3 o'clock कर लेते हैं, ठीक है? आप अभी जरा पॉइंट्स भी नोट करते जाएं, सवालों के जवाब। अगर फिर आपको सुनेंगे, ये ना समझेंगे।
I have just one request.
मगर नहीं, तो
your lordship will give him as similar tough time as your lordship has given me.
No, I will try not to interrupt him because देखिए, I'll tell you why. He's representing Pakistan. Interest of the country is paramount. The Indus Water Treaty is a very sensitive thing. So we don't want to create a situation where he can't go. I will request my colleagues and I will also restrain myself. If we have queries, like he said, do you have some additional or someone here?
Mr. Amir Rahman is here.
Amir Rahman is a competent additional Advocate General. So he will make note of the questions and he will either respond himself or the Attorney General can even call him from, I don't know, wherever he is. ठीक है, तो इनको जरा हम फारिग कर दें, फिर हम जरा तसल्ली हो जाएगी, इनको भी तसल्ली हो जाएगी।
I am at you to speak.
शुक्रिया बहुत-बहुत।
Judiciary, that is freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional judiciary, that is freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So, when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
Sir, we will certainly answer your lordship.
Sir, but please, one question also.
Since we have just one section, can we just finish reading it?
Raja Sahib, if I may have a supplemental on
Yes,
what
ma'am.
my learned colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence
working
of
of
the
the
judiciary, that the solution is to put the power in the hands of Parliament? Would that not violate separation of powers?
Yeah,
Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and, for the practice and procedure of the court? There is no end to it. Is if at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar, is this really the solution? That you say, okay, here's a problem internally to the, would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean, where would that lead us?
with due respect, my lord, to my lord.
Raja Sahib, ये एक बात सुनिएगा, एक question.
आप इसको खत्म तो कर लेना सेक्शन को, आप सॉरी टू से
आर्टिकल 8 खत्म कर लो।
आप पढ़ ही नहीं रहे हैं।
मैं पढ़ लेगा, अभी पढ़ लेता हूँ सर। ये सवाल बड़े पर्टिनेंट आ रहे हैं।
आप हर चीज आप नोट कर लेना।
नोट कर भी दिया मैंने सर, करिएगा ना। मैंने शुरू में ये कहा था।
आप शुरू में क्या कह रहे हैं? आप आखिरी सेक्शन पढ़ लें।
मैंने शुरू में ये कहा था, आपने शरीफ साहब और जो ये आप कह रहे हैं, तो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है, उसमें किसी और का दखल नहीं होना चाहिए। ये अगर ये दखल अंदाजी होगी तो फिर ये सुप्रीम कोर्ट नहीं रहेगा।
एक बात और नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है टू द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the council of his own choice. No, when the law is totally ultra virus, then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm out of the country or not well, you do allow in review.
You are declaring right of appeal ultra virus and right of review intra virus.
No, what I'm saying is,
according to your own arguments,
the question is that you cannot provide a right of appeal,
but you can provide the right of review
under 184(3). If 184(3) right of appeal is given in accordance with the constitution, then as far
ख्वाहिर साहब फिर आप अपने लिए आप जरा सुन तो लीजिए ना, आप ये सवाल जो है जरा सुन, आप सुन तो लीजिए ना। ये जो सवाल है इनको इतने इजीली ब्रश असाइड ना कीजिए, जरा सुनिए प्लीज। आप गौर फिक्र से, हम नहीं चाहते हैं कि आप फिलबदी कोई जवाब दे दें जो फिर आपके लिए मुश्किल हो। हम इसीलिए आपको कह रहे हैं हर सवाल नोट कर लीजिए, आराम से जवाब दे दीजिए। आप खुद अपने लिए मुश्किलात खड़ी कर रहे हैं, हर सवाल के जवाब देने लगते हैं। हम तो सिर्फ आपसे सवाल पूछिए, नोट कर लीजिएगा आगे चल करके, ठीक है। हम देखें, हम एक दूसरे से बहस करने नहीं बैठे हैं, हम आपके सुनने का, आपने चैलेंज किया है एक कानून को कि ये गैर आईनी है। ये बहुत फर्क होता है कि एक कहने के लिए कि मुझे ये कानून पसंद नहीं है। ذرا آپ پلیز نہ خاموش رہیے 2 منٹ, ہم بھی آپ کو سن لیتے ہیں خاموشی سے, آپ بھی تھوڑا سا تحمل کا اظہار کر لیں. تو یہ بہت سے قانون ہیں, شاید مجھے بھی نہیں ذاتی طور پہ پسند ہوں, مگر میں نے حلف اٹھایا ہے کہ میں آئین اور قانون پہ عمل کروں گا, تاکہ انلیس کہ میں اس کو اسٹرائک ڈاؤن کر لوں قانون کو, وہ ایک الگ بات ہے کہ یہ الٹرا وائریز دا کانسٹیٹیوشن ہے. تو آپ نے کہا مائی پرسنل اوپینین ڈزنٹ میٹر, تو آپ کی بھی پرسنل اوپینین کی کوئی حیثیت نہیں ہے. آپ کو آئینی جواب ہر دینا ہے کہ یہ اس شک, آپ نے ایک بحث میں ایک آرٹیکل آئین کا آپ نے ریفر نہیں کیا کہ یہ کس آرٹیکل کے تصادم میں ہے. دوسری بات آپ نے جو بالکل نظر انداز کر رکھی ہے, یہ ہم نے سیوموٹو کیس نہیں لیا. اگر ہمارے حقوق پہ اتنا زبردست وار پارلیمنٹ نے کیا ہوتا تو ہم نے بہت سارے کیسز میں, ہم نے خود بھی اٹھا لیے کیسز کو. یہ تو آپ ہمارے طرح سے وہ ڈیفینڈر طور پہ رونما ہوئے ہیں اور کہا یہ جنگ میری ہے, ٹھیک ہے. یہ صرف پروسیجر میٹر ہے, کس میں کسی کی رائٹ غائب نہیں ہو رہی, کسی کی رائٹ, ایک رائٹ کنفر ہو رہی ہے, کسی کی رائٹ چھینی نہیں جا رہی ہے. تو برائے کرم آرٹیکل 184(3) کے دائرے میں رہ کر آپ نے, جس کا آپ نے ایک لفظ نہیں ذکر کیا ہے, وہ کہتا ہے اینی میٹر آف پبلک امپورٹنس. چلیں جی, پبلک امپورٹنس تو ایک وہ ہے ڈیبیٹیبل کویشچن, ہم یہ کہوں گا آپ کہیں گے وہ ہے, مگر فار دا انفورسمنٹ آف فنڈامنٹل رائٹس, ٹھیک ہے, یہ اس کے پریمبل میں انہوں نے فنڈامنٹل رائٹس کا تذکرہ کر دیا ہے, جس کو آپ نے بس نظر انداز کر دیا. ٹھیک ہے, یہ بہت اچھی بات ہے کہ آپ میرے حقوق کے لیے جنگ لڑ رہے ہیں, مگر یہ میرے حقوق اور آپ کے حقوق کی نہیں بات ہے, یہ آئین کی بات ہے اور لوگوں کے حقوق کی بات ہے. یہ آرٹیکل 10(a) کا حوالہ دیتا ہے, آرٹیکل 25 کا دیتا ہے. تو آپ کھڑے ہو اپنی رائے, آپ کالم لکھیے اخبار میں, ہمیں صرف اور صرف آئینی بحث کیجئے کہ یہ 184(3) کا جو ہم جو پاور آج استعمال کر رہے ہیں, یہ ہم اپیلیٹ پاور نہیں استعمال کر رہے ہیں, نہ کوئی ہائی کورٹ نے کوئی فیصلہ کیا ہے جو ہم بیٹھے ہوئے ہیں ایز آف رائٹ اپیل سن رہے ہیں, پٹیشن فار لیو ٹو اپیل سن رہے ہیں. ہم اوریجنل جیورسڈکشن میں بیٹھ گئے, اس کی بہت محدود چیزیں, مجھے بہت سی چیزیں قانون میں شاید ناپسند ہوں, میں یہ نہیں کہہ سکتا ہوں کہ جی اس کو ایسا نہیں کرنا چاہیے تھا. تو آپ برائے کرم آپ نے ایک سیکنگ انفورسمنٹ آف فنڈامنٹل رائٹ سے تو آپ نے کچھ بحث ہی نہیں کی ابھی. ذرا آپ پلیز, اور ہر بات کو آپ نوٹ کیجئے, اگر آپ تو بس آپ ہر چیز کو جواب دینے لگتے ہیں بغیر سوچئے. ہر بات کی بہت اہمیت ہوتی ہے. میرے کولیگز کی جو سوال ہیں وہ بڑے اچھے سوال ہیں, ذرا غور و فکر چاہتے ہیں اور پھر جواب دیتے ہیں. اگر آپ جلدی سے کریں گے پھر آپ کو دوبارہ موقع نہیں دیں گے, پھر کہیں گے اب مجھے اچھا جواب آ گیا. جب آپ پلیز 184(3) کے تقاضے بھی پورے کر لیں.
آپ کے بالکل 184(3) کے تقاضے
میرا ایک سوال بھی نوٹ کیجئے, کے پی آن دا بارڈر پلیز. آپ کیا سوچتے ہیں دس ایکٹ ہیز بین پاسڈ ان دی پبلک انٹرسٹ؟ کیونکہ سیکشن 5 سب سیکشن 2 says on the contrary. It appears that to do away with some of the decisions which were passed in the previous years under Article 184(3) of the Constitution, کیونکہ commencement ان کی کر دی ہے اور اس میں کوئی limitation بھی نہیں ہے, تو یہ پبلک انٹرسٹ میں پاس ہوئے یا پرسنل انٹرسٹ میں ہوئے؟
Yes, your point is noted, sir. I will not answer now. I'll answer it later.
Mr. Khwaja, another question. Please ایک اور note کر لیں. We have two provisions in the Constitution. One is Article 191, which relates to Supreme Court, and the other is 202 of the Constitution, which relates to High Court. Same alfaz ہے, ماں سے وہاں پہ Supreme Court, یہاں پہ High Court. Subject to the Constitution and law. Law تو بناتی ہے پارلیمنٹ. تو آپ کے آرگومنٹ سے ہم یہ سمجھیں کہ پارلیمنٹ کو آپ لا میکنگ میں محدود کرنا چاہتے ہیں کہ آپ یہ تو کر سکتے ہیں, یہ نہیں کر سکتے, یہ رولز میں سپریم کورٹ خود کرے گی, خود کرے گی.
سر میں اس کا آنسر دوں گا, بالکل دوں گا, کہ جب سبجیکٹ ٹو کانسٹیٹیوشن آ جائے گا اور جو لا آئے گا وہ آپ کو کانسٹیٹیوشن کے ساتھ رکھنا پڑے گا.
یہ بھی کہ کیا لا کے تحت کیا کر سکتے ہیں پارلیمنٹ, کیا نہیں کر سکتے,
نہیں کر سکتے, یہ اس کا جواب دیں گے جی آپ کو.
Another question, where a rule has been framed under constitutional power granted to this court.
Yes, sir.
This is with reference to section 6 that you just read. You would notice that Order 26 of the Supreme Court rules does provide for all eventualities in which a review can be filed procedurally. The question is where the Supreme Court, in exercise of constitutional powers granted by the Constitution framed rules, the Parliament can legislate and override those rules or amend those rules. That's the question. Noted. Please answer when you are answering.
Additional through already law or through the point is taken, sir, by already with me, and I will answer that. And I have my own views on this, that the Parliament cannot do this thing by an ordinary.
हजूर आपके व्यूज को छोड़ दीजिए ना, आईनी तकाजे पूरे कर लेना.
Number 7 is application for fixation of urgent matters.
ये तो हो गया.
Application pleading urgency or seeking internal relief.
अच्छा, मैं आपको एक मफरूजा पे छोड़ देता हूँ. आपने दरखास्त दी, बहुत अहम केस है, अर्जेंट केस है, मैं नहीं लगाता हूँ. मेरी मर्जी. सिर्फ जवाब दे दीजिए, मेरी मर्जी. मैं 10 साल उस केस को नहीं लगाऊं. मेरी मर्जी.
मैंने इसमें कुछ नहीं कहा.
मैं आपसे सवाल पूछ रहा हूँ जी. इन्होंने मेरी मर्जी ले ली. शायद मैं खुश नहीं हूँ उस बात से. मेरी मर्जी में ना लगाऊं केस. एक बहुत अहम केस है, इसमें उन्होंने लिख दिया 14 दिन में आप उसका, भाई सिर्फ उसको लगा दें, कोई फैसला तो ना करें. तो मैं कहूँगा मेरी मर्जी. मैं जो ये टैक्स पेयर पैसे दे रहे हैं इस अदालत को, जो हमारा बजट है, मेरी मर्जी पे चलेगा. इस पे सवाल का जवाब दीजिए. मैं नहीं लगाता हूँ. आपका ये केस फाइल किया, ठीक है, मैं नहीं लगाता इसको. आप क्या कर लोगे? कुछ भी नहीं कर सकते हैं. आपके हाथ पैर कटे हुए हैं. इन्होंने हम पे भी, मेरे कोलीग ने एक बात की इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस की. मैं 2 बातों का इजाफा भी करना चाहता हूं, और वो आइन से पहले भी हमारे पास था. वो हमें ऊपर वाले को हिसाब देना है. ठीक है, अकाउंटेबिलिटी एंड ट्रांसपेरेंसी. आप हमें टोटली अनअकाउंटेबल बनाना चाहते हैं चीफ जस्टिस को. मैं तो बहुत खुश हूँगा, क्योंकि ये कानून अगर सस्टेन हो जाता है तो मेरे पार तो कम हो गए बाकी चीज़ों को छोड़ करके. ठीक है, इस कानून को उड़ा दें, मैं ताकतवर बन जाता हूँ. ये भी है, मैं अकाउंटेबल हूँ. ये भी एक सवाल है. आपका आइन जो शुरू होता है वो सुप्रीम कोर्ट की इंडिपेंडेंस से नहीं शुरू होता है, वो अल्लाह ताला के बाबरकत नाम से शुरू होता है. ठीक है, और हम सब everyone to exercise powers as a sacred trust. आइन में आर्टिकल 227 भी दी गई है कि शरई असूलों पे अगर आपके कोई भी कानून तसादुम करे तो वो प्रिवेल करेंगे. तो बराए करम एक इंडिपेंडेंस ऑफ द जुडिशरी से ये मतलब नहीं कि अगर इंडिपेंडेंस ऑफ जुडिशरी से मैं किसी का दरवाज़ा बंद कर रहा हूँ तो वो तो मैं बिल्कुल मुझे इस्तेमाल नहीं करना चाहिए. आप ये पिटिशन लाते, सपोज मैं चीफ जस्टिस होता, मैं इसको लगाते ही नहीं, तो हम ये बेकेस ही नहीं सुनते कभी. 10 साल पड़ा रहता, मैं मजबूत रहता चीफ जस्टिस के तौर पे. आप खुश थे उस बात से. तो बराए करम आप ये जो बार बार बात कहते हैं ना, मेरी मर्जी, मेरी नहीं है जब मैं चीफ जस्टिस हूँ. तो बराए करम हम वकीलों को बहुत ही कदर करते हैं, मगर मेरा का लफ्ज ना इस्तेमाल कीजिए. अंग्रेजी में कहते हैं मी, माई सेल्फ एंड आई आर द 3 मोस्ट यूजलेस वर्ड्स इन द इंग्लिश लैंग्वेज. इसका मैं उर्दू में तर्जुमा नहीं कर सकता हूँ, बेहतर कर सकेंगे. बराए करम आइन का हवाले दे दीजिए किसी चीज के मुतालिक कि ये आइन के तसादुम है, वो आइन से तसादुम रखता है, ये शिक के आइन से तसादुम. अभी तक मैंने आपसे वो एक लफ्ज नहीं सुना है. इस पे शुक्रिया.
मैंने तो 3-4 जगह कह दिया है कि जहाँ पे 184(3) में आप अपील का राइट दे रहे हैं थ्रू दिस ऑर्डिनरी लॉ, ये हो नहीं सकता, बिकॉज दिस कैन ओनली बी डन बाय अ कॉन्स्टिट्यूशनल अमेंडमेंट.
लफ्ज लिखा है अग्रीव्ड पर्सन. ठीक है, अब देखिए, अब एक मफहूम तो ये निकलता है 184(3) का कि आप ऐसे मामलों में ना उलझाएं अपने आप को जो इनफरादी नौयत के हों.
अग्रीड सर.
जरा अग्रीड, आपसे अग्री करें या ना करें, मैं जरा बात कर लूँ. इनफरादी नौयत के, अगर हम इनफरादी नौयत के केसेस फैसला करने लगें तो वो बेचारा कहाँ जाएगा. मैं आपको मिसाल दे देता हूँ. रेकोडिक का केस चला, दोनों केस फैसला हो गए तो मैं इस पर बात कर सकता हूँ. रेकोडिक का आ गया, ठीक है, सुप्रीम कोर्ट ने 184(3) में एग्रीमेंट उड़ा दिया. मुल्क को, सुप्रीम कोर्ट को नहीं, मुल्क को $6.5 बिलियन की डज लगी. हमने कौन सा जुरिस्डिक्शन इस्तेमाल किया? हमने एडवाइजरी जुरिस्डिक्शन इस्तेमाल किया. अगर हमारे पास ये जुरिस्डिक्शन होता, मैं नहीं कह रहा हूँ फैसले अच्छे थे बुरे थे, मैं सिर्फ उस पर तबसरा कर रहा हूँ. ठीक है, अगर हमारे पास जुरिस्डिक्शन होता, हम वो जुरिस्डिक्शन इस्तेमाल कर रहे थे. अब हमने एडवाइजरी जुरिस्डिक्शन से मामलों को ठीक रखने की कोशिश की. ٹھیک ہے آپ کہتے ہیں نہیں ملک کو $6.5 بلین کی ڈز لگ جائے تو لگ جائے, انڈیپینڈنس اور آپ کی چیف جسٹس کی ساخت پہ کمی نہ آئے. جی مجھے ایسے پاورز اپنے لیے تو نہیں چاہیے, میں اب وضاحت کر دوں, اگر آپ مجھے دینا چاہتے ہیں میں پھر بھی نہیں لینا پسند فرماؤں گا. آپ پلیز آئین کے تقاضے پورے کریں.
میں یہ میرا مقصد ہی نہیں ہے. آپ میں یہ آنسر کر دوں گا. یہ بالکل 184(3) کے جو کنڈیشنز ہیں وہ بھی میں آپ کے سامنے پوری کر دوں گا, اور وہ 2 کنڈیشنز ہیں پبلک امپورٹنس اینڈ فنڈامنٹل رائٹس میں رائٹلی سائڈ سے independence of the judiciary is a fundamental right.
Can we go back to my question before you get into the merits of all these arguments? The question is again, if the law is to be sustained, what is the effect of Section 5, which gives a right of appeal, given that a full bench is going to hear the case and decide the matter? Then that full right of appeal is no longer there, it's redundant, it doesn't exist. So what is you have read the law now, اس کے اوپر آپ بتا دیں کہ
اور اس میں اسی کے ساتھ ایک سوال خواجہ صاحب ادھر ہوں جی, ذرا 5 منٹ لگتے ہیں آپ کو مجھے دیکھتے.
نہیں سر آپ
میں آپ سے صرف اسی سوال چلتے ہیں کہ اس 4 میں لکھا ہے کہ 5 یا 5 سے زیادہ ججز کا بینچ بنا سکتے ہیں نا, تو فل کورٹ بھی بنا سکتے ہیں نا 4 میں, تو پھر 4 کو 5 کو اکٹھا پڑھیں تو اگر فل کورٹ بن گیا تو پھر اس کیس میں اپیل نہیں ہوگی. بس آپ اس کا بھی جواب دیجیے.
بلکہ اس میں ایڈ آن کوشچن ہوگا کہ ڈز دیٹ ناٹ مین کہ ہم پھر ونس اگین خود ہی ڈیسائیڈ کر لیں گے جہاں ہم نہیں چاہیں گے کہ اپیل کوئی ہو کسی کیس کا تو فل بینچ بٹھا دیں گے. ڈز دیٹ اگین ناٹ اماؤنٹ ٹو اے پاور being exercised by the court itself? So the control factor that there is a right of appeal, which is a substantive right, how can we just say that that right cannot be exercised? It's a substantive right.
ایک question اور بھی اسی میں ایڈ کر لیتے ہیں اس طرف. فاجی صاحب, to your right. ہم یہ بھی دیکھیں گے through this petition there is an order of this court. The act has been suspended. Whether in presence of that order full court can be constituted or not. یہ بھی ذرا دیکھیں.
Court can be constituted or not. آپ جواب دینا پسند فرمائیں گے یا ہم shall we proceed to the next council, پھر آپ سوچ کر کے آپ جواب دے دیجئے. ٹھیک ہے,
میں نے پروپوزیشن کر دی.
ٹھیک ہے, آپ آئیے. کون آرگیو کرے گا نیکسٹ؟ اچھا, آپ اپنا کس پٹیشن میں ذرا بتا دیں.
تینوں میں خواجہ صاحب کے ساتھ.
جی
تینوں میں خواجہ صاحب کے ساتھ.
To write of 2 counsel is not allowed unless you are separate petitioners.
7 میں 6 ہم بیٹھے ہیں, ایک میں آپ 7 میں میری حاضری ہو گئی.
جی چلیے بتائیے.
Followed the proposition is, the proposition requires to be refocused. There is, the fundamental question is whether the parliament has the jurisdiction and the power to promulgate this act or not.
No, that is not the fundamental question, with utmost respect. The primary question is whether 184(3) can be invoked. First, you overcome that hurdle, then you argue that. So you have filed a petition not in the normal jurisdiction, you have come in original jurisdiction of the Supreme Court, which is not a right. You have to comply with certain provisions of the Constitution.
Well, Lord, there are number of judgments.
I'm not interested in judgments, I'm talking about arguments.
I am making submission, my Lord. The Supreme Court at various point of time has held that any clog on the powers of the Supreme Court or the functioning of the Supreme Court constitutes...
حضور میں پھر آپ کو بات سمجھایا نہیں سکا. For instance, let's take income tax ordinance. ٹھیک ہے, ٹھیک ہے, اس کو آپ بالکل اسٹرائک ڈاؤن کر سکتے ہیں اور اس کو چیلنج بھی کر سکتے ہیں آرٹیکل 199 میں ہائی کورٹ کے پاس. ٹھیک ہے, ہم کیوں جورسڈکشن ایکسرسائز کریں 184(3) کی؟ یہ شاید آپ کے حساب سے یہ قانون دنیا کا بدترین قانون ہو سکتا ہے. ٹھیک, مگر بنیادی سوال 184 کا دروازہ جب آپ کھولیں گے تو اس میں دو چیزیں ہیں، میٹر آف پبلک امپورٹنس، سیکنگ انفورسمنٹ آف فنڈامنٹل رائٹس. بتا دیجئے کہ چلیں پہلے والوں کو ذرا گرے ایریا ہے، دوسرے والے میں تو بتا سکتے ہیں نا فنڈامنٹل رائٹ. پارلیمنٹ اچھا قانون بنائے برا قانون بنائے، یہ ہم پارلیمنٹری ڈبیٹ ادھر نہیں کریں گے. آپ 184(3) میں ہو سکتا ہے کل کو ہائی کورٹ میں آپ یہ پٹیشن لگاتے، وہ الاؤ کر دیتے آپ کی پٹیشن، پھر آپ ہمارے پاس اپیلیٹ جورسڈکشن میں آتے، ہمارے بہت کھلے ہوتے. اب آپ نے بہت نیرو انتخاب کیا ہے، 184(3) کا انتخاب کیا ہے.
My lord, there are number of judgments of the Supreme Court.
ججمنٹس حاوی نہیں ہوتے ہیں آئین پہ. اچھا آپ 189 پڑھ لیں ذرا، یہ آپ لوگوں کے ذرا غلط فہمی کیوں ہے. 189 ایک سیکنڈ 189 پڑھ لیتے ہیں ساتھ میں، ذرا پڑھیے 189. جی.
Any decision of the Supreme Court shall, to the extent that it decides the question of law or is based upon or enunciates a principal law, be binding on all other courts in Pakistan.
لفظ ہے all other courts, not the Supreme Court.
Yes.
تو یہ ہمیں ہمارے اوپر ہمارے پریسیڈنٹس نہ سائٹ کیجئے. اب آپ سے آئینی سوال پوچھا جا رہا ہے on all other courts, which means high courts and
Unless your lordship allows me to make a submission,
other courts
I
کی بات
will
کر
not,
رہا ہوں.
no, I will not be able to.
ٹھیک ہے، آپ کو سوال دے دیا، آپ جواب دیجئے جیسے بھی آپ کرنا چاہیں.
Please, lordship.
If I may ask
Ji.
you,
Sir.
Mr. Siddiqui, if I may ask you a question.
Please,
It
lordship.
seems to me that Article 189 deals with what is called vertical stare decisis. But there is also within the Supreme Court and in each High Court what is called horizontal stare decisis, the law of precedent. That is a judge-made law, that is case law. That is not provided in the Constitution. And surely the rules, are there not rules that regulate horizontal stare decisis? For example, the full court gives a judgment. If there were no horizontal stare decisis, a two-member bench of the Supreme Court would say, well, Article 189 doesn't apply, so we are not bound by the judgment of the full court. Would that be correct? Would that be a correct understanding?
That would be a fallacy, it will not be correct.
So if a three-member bench, a five-member bench gives a judgment, can a three-member bench say, or even a five-member bench say, sorry, we are not bound because Article 189 doesn't apply to us? Surely horizontal stare decisis does apply. It's a well-settled. What would you say to that?
But I would make a humble submission that the judgments of the superior courts, particularly of the Supreme Court, are a binding precedent on the subsequent courts constituted as a benches or a full court. And unless your lordship, in your lordship's wisdom, decide to overrule them, they have a binding value. And it goes to the very system of certainty within the judicial system. And to say that your lordship are not bound by the previous judgment would, with respect.
میرے خیال میں آپ میرا سوال سمجھے نہیں صحیح.
میں آپ کو آ گیا ہوں سر، میں ادھر آ رہا ہوں.
نہیں میرا سوال دوبارہ دہرا دیتا ہوں، شاید آپ سمجھ نہیں پائے. یقیناً 5 ممبر بینچ کا ججمنٹ 3 ممبر بینچ پہ بائنڈنگ ہے، یقیناً. اب ہم آرٹیکل 189 کی بنیادی بات کر رہے ہیں، ادر کورٹس. اگر یہ بات ہے تو یہ اب فل کورٹ، اس سے بڑی تو فل کورٹ نہیں ہو سکتی ہے نا. ہمارے اوپر کوئی پریسیڈنٹ لاگو نہیں ہوگا، آپ سمجھ رہے ہیں. اگر یہی ایشو کسی لارجر بینچ نے فیصلہ کر لیا ہوتا وہ ہم پہ ہوگا، مگر ایز اے رول ادروائز ججز ڈیسینٹ بھی نہیں کر سکیں گے نا، وہ تو بائنڈنگ ہے، ڈیسینٹ بھی نہیں کر سکتے ہیں. تو اب آپ ذرا وضاحت میں یہ کر رہا ہوں، یہ نہیں ہے کہ 4 ممبر بینچ ڈسریگارڈ، 2 ممبر بینچ ڈسریگارڈ کر دے گا 5 ممبر بینچ کے فیصلوں کو. بالکل یہ میری، آپ اس کا مطلب بات سمجھ نہیں پائے. ادر کورٹس، مگر ابھی تو وہ مفروضوں میں ہم نہیں جانا چاہتے ہیں. یہ جو موقع ہے اس پہ پورا کورٹ بیٹھا ہے، تو یہ کوئی پریسیڈنٹ جب آپ سائٹ کرنے لکھ لیں گے تو وہ پرنسپل نہیں اپلائی کرے گا جب تک آپ آرٹیکل 184(3) کا دروازہ نہیں کھول پائیں.
یہ امتیاز صاحب، اس کو میں ذرا سمپلیفائی کر دوں ایز آئی ہیو انڈرسٹوڈ. یہ پورا لا پڑھ لیا گیا ہے، اس میں صرف 2 چیزیں ہیں. ایک، پہلے چیف جسٹس کے پاس کلی اختیار تھا کہ ڈسکریشنری چوائسز کرے، ٹھیک ہے نا. اس کو پارلیمنٹ نے ڈائلیوٹ کر دیا، ریگولیٹ کر دیا. دیٹس آل دیٹ دا پارلیمنٹ ہیز ڈن، کہ انہوں نے 3 ججز کو اکٹھا کر دیا. کوئی باہر کا کوئی بھی نہیں آیا. it's still the Chief Justice and the two senior most judges. इसमें तो किसी का भी फंडामेंटल राइट अफेक्ट नहीं हो रहा, बल्कि जो इंटरनल या इंस्टीट्यूशनल इंडिपेंडेंस है वो मजबूत हो रही है. सेकेंडली, एक राइट ऑफ अपील उसको प्रोवाइड किया जा रहा है जिसके पास पहले कोई राइट नहीं था. नाउ इस दो चीजों के अलावा इस पूरे कानून में कुछ नहीं है, तो कौन सा फंडामेंटल राइट्स आप पिटिशनर का वायलेट हुआ है जिस पे आप 184(3) में आए हैं? ये तो अगर
योर लॉर्डशिप्स हैव हेल्ड,
सुन ले, अगर पार्लियामेंट ने चीफ जस्टिस की अथॉरिटेरियनिज्म को खत्म किया है, ये तो आपको सराहना चाहिए. ये तो आपके बल्कि इंडिपेंडेंस ऑफ जुडिशरी को सिक्योर करेगा. हाउ डज दिस
respond to this? May I respond to
और सिद्दीकी साहब, इसी में मैं ऐड कर दूं. सवाल ये है कि अगर आपके मुताबिक चीफ जस्टिस की अनलिमिटेड पावर्स ही इंडिपेंडेंस ऑफ जुडिशरी है, ये भी बताइएगा, क्योंकि अगर जिस तरह माय लर्नेड कॉलीग इज जस्ट मेंशन्ड कि अगर वो विटल डाउन कर रहे हैं पावर चीफ जस्टिस की, एक की जगह 3 लोग 4 लोग मुशावरत के साथ चलेंगे, तो एकदम इसलिए कि चीफ जस्टिस की पावर कम हो रही है, इंडिपेंडेंस जुडिशरी एट स्टेक हो गई है. ये नहीं देख रहे कि इंडिपेंडेंस ऑफ जुडिशरी तो बढ़ गई है, कि एक कंसेंसस से आगे चलने का इंतज़ाम हो गया है कि आप लोग सोचें कि आगे कैसे चलना है, कोलिजियल तरीके से चलना है. सारी दुनिया में बहरहाल ये हो रहा है. कहीं दुनिया में चीफ जस्टिस नहीं मास्टर ऑफ द रोस्टर है, क्योंकि अब सब जगह कहीं जाएं तो बैलेट होता है साल के शुरू में, कहीं सारी फुल कोर्ट बैठता है तो फिर चलता है. कोई चीफ जस्टिस के बाद मुंजमद नहीं है ये पावर्स चलाने की. तो ये हो रहा है, तो इंडिपेंडेंस तो इससे बढ़ रही है जुडिशरी की. एक चीज़ तो इस चीज़ को ज़रा देखिए कि इंडिपेंडेंस बिल्कुल कनेक्ट मत कीजिए चीफ जस्टिस की ओमनीपोटेंट पावर्स के साथ, कि जैसी चीफ जस्टिस की पावर को हम छेड़ते हैं इंडिपेंडेंस ऑफ जुडिशरी खतरे में पड़ जाती है. ऐसा कोई सिलसिला नहीं है. इसका भी जवाब जरा दीजिए.
Mr. Siddiqui, the fundamental question here is, who can do this? Who can do this? That's what I'm saying. I mean, is it a function of the granted by the Constitution? Is it the function of this, the Supreme Court?
It is a function,
or is it the function of the Parliament? And if the Parliament exercises a function of the Supreme Court, then it is an intrusion in the independence of the judiciary, as I have understood. Is your argument?
I am saying,
सिद्दीकी साहब एक इसमें ज़रा मैं ऐड कर दूँ. 191 आप पढ़ते हैं ना, तो 191 में लिखा है सब्जेक्ट टू लॉ इन द कॉन्स्टिट्यूशन प्रोसीजर बना सकते हैं. तो 191 तो ये इन्विजिज करता है कि कानून हो सकता है जो प्रैक्टिस एंड प्रोसीजर को रेगुलेट करे.
पार्लियामेंट का तो नहीं हो सकता.
सुन लीजिए, नहीं और कहाँ से कानून लाते हैं आप? हम पार्लियामेंट से लाते हैं पाकिस्तान में कानून.
जजमेंट लॉ.
अच्छा, नहीं लॉ, कॉन्स्टिट्यूशन एंड द लॉ
कन्वेंशन.
सुन लीजिए. टू लॉ इन द कॉन्स्टिट्यूशन, कहीं से लॉ एक एग्जिस्ट कर सकता है, आइन मानता है कि ऐसा कानून हो सकता है जो कोर्ट के प्रोसीजर को रेगुलेट करे. अब सवाल आता है वो कॉम्पिटेंस कहाँ से आएगी पार्लियामेंट? तो आप हम एंट्री 55 में चले जाते हैं कि ऐसी पावर वो दे सकता है कि नहीं. अब इसको ज़रा ओवरऑल स्कीम में देखिए कि हमारे पास ये जो सेक्शन 7 पढ़ा जा रहा था ये वगैरह, हमारे पास अर्जेंट लगते हैं, कितने लगते ही नहीं केसेस. ये आम रोज़ाना की एक शिकायत है कि अर्जेंट केस सुप्रीम कोर्ट में लगता ही नहीं है. चीफ जस्टिस साहब नहीं लगाते कोई केस. चीफ जस्टिस अपनी मर्जी का एक बेंच बना के कोई केस कर देते हैं. अच्छा, फुल कोर्ट नहीं बैठता. अवाम के केसेस हैं, अवाम का एक पूरा फोरम है पार्लियामेंट, वो अवाम कह रही है और वो पार्लियामेंट कह रहा है कि भाई अपने सिस्टम को ठीक करें और आपका सिस्टम 14 दिन में एक अर्जेंट लगाए. ये बात गलत हो गई. हमें करना है, हम सो जाएं, हम ना बनाएं केस, हम कोई केस ना लगाएं, हम अपनी मर्जी के बेंचेस बनाएं, ये ठीक है. पार्लियामेंट जो उसी अवाम के जिनके मुकदमे सुनने हम बैठे हैं, वो कहता है कि ये सिस्टम बना दिया है प्रोसीजर, 14 दिन में अर्जेंट केस लगाओ, तो हमारी पावर पे और इंडिपेंडेंस पे कतगन आ गया है. इसलिए कि हम 17 अनइलेक्टेड आदमी जिस तरह मर्जी अवाम के केसेस फैसला करें, लेकिन अवाम जो पार्लियामेंट के थ्रू हमें बताए वो हमारे रास्ते में रास्ता आ गया. 55 एंट्री, सारा सवाल एंट्री 55 का है. एंट्री 55 में सप्लीमेंटल पावर्स दे सकते, उसमें बताइए कि क्या गलती है. सिर्फ इतना सा सवाल है.
If your lordship allow me a breather,
सदीकी साहब एक सवाल.
I will answer all these questions.
बिस्मिल्लाह कीजिए.
सदीकी साहब सांस लेने,
My lord, I would answer all these
सांस
questions.
लेने से पहले एक सवाल और नोट कर लें. देखिए, कॉन्स्टिट्यूशन ने कहा कॉन्स्टिट्यूशन ने कहा है कि इंडिपेंडेंस ऑफ द सुप्रीम कोर्ट nowhere it is mentioned that the supremacy or independence of the chief justice.
I would answer this question.
सर मुझे लगता है सारे मेरे कोलीग मेरे खिलाफ हो गए हैं.
क्वेश्चन पूरा नहीं हुआ. तो कॉन्स्टिट्यूशन सेज इंडिपेंडेंस ऑफ द सुप्रीम कोर्ट, जबकि रूल्स के तहत चीफ जस्टिस को पावर दिया.
चेंज कर दे सर, एक रूल को चेंज कीजिए.
सुन लेना सर, रूल के तहत. अब रूल क्या होंगे? अगर आप 191 पढ़ेंगे, आप वो रूल बनाएंगे जो कॉन्स्टिट्यूशन और कानून के ताबे है. ऐसा नहीं है कि रूल
स्ट्रगल सर ये हो रही है माय लॉर्ड कि कह ये रहे हैं कि हमारा एक्सपीरियंस बहुत बुरा हुआ है पिछले अदवार में.
अच्छा,
I don't want to comment on that. It is not my stature. It is not my function.
इसकी कहीं और ममालिक में बात सुने प्लीज. इसकी कहीं मिसालें मौजूद हैं किसी और मुल्क में? कोई ऐसी मिसालें मौजूद हैं?
मैं उस तरफ आऊंगा अगर आप मुझे दें. What the theme appears to be.
मैं अपने कोलीग से रिक्वेस्ट करता हूं कि आपको इजाजत दे दें और आगाज कीजिए.
The theme appears. I just a sentence.
Just one question. आप सिर्फ इतना बता दीजिए. Why 184(3? Why not 199 before the High Court? कौन सा फंडामेंटल राइट जो है
your lordships in a number of judgment have held.
जजमेंट तो बिल्कुल सही होती है सर. देखिए
आपको बताता रहा हूँ, आपको बता रहा हूँ.
कौन सा फंडामेंटल राइट?
I have a right to be dealt in accordance with the constitution and the law. It is my fundamental right.
Agreed.
And if I find that there is a deviation from the constitutional scheme, it is a question of violation of my fundamental right. And it is.
You tell us which one.
Which?
You can't just say it is. You tell us which one, we'll note it.
ये आप मानते हैं बिकॉज ऑफ जो पीछे पास में 2 डेकेड्स में हुआ है, इस तरह की रिफॉर्म्स आनी चाहिए थी.
100%.
100.
I am a victim of it.
एक सेकंड ना, अब ये अब लेट अस जस्ट इसको छोटा कर देते. अब आप कहते हैं कानून बहुत अच्छा बना है, लेकिन पार्लियामेंट के पास इख्तियार नहीं था. हम अनइलेक्टेड जजेस जो हैं 15, हम बैठ के यही चीज कर ले तो ठीक होगा. तो फिर तो आप सिंपली आर्टिकल 191 के लैंग्वेज पे आ जाएं, सिर्फ उसी की इंटरप्रिटेशन आपको दरकार है. इससे मायने ये हुआ देयर इज नो फंडामेंटल राइट. आप कहते हैं कानून बहुत अच्छा है, आप खुद अफेक्टी हैं, यही चीजें होनी चाहिए थी तो हम खुद कर देते.
सिद्दीकी साहब ये सवाल लिख कर रहे हैं आप?
पता नहीं.
हम तो बोली जा रहे हैं, आप हाँ करी जा रहे हैं.
साथी खड़े ये कोई काम नहीं करेंगे.
मैं सोच रहा हूँ कि आर्टिकल 10 ये आर्टिकल 4
ऐसे नहीं कहिए. पढ़िए, एक पढ़िए और बताइए.
I will first read article 4. I will first read article 4.
For your starter, actually it is for your starter. आप ये whole of the act को ultra vires कहते हैं या there is any exception?
I find the entire act to be ultra vires the constitution because I feel this domain is not available to the parliament and the entire tenure of the section is unlawful. And I will show it to your lordship.
ठीक है चलें.
Mr. Siddiqui.
His lordship, article 4.
Mr. Siddiqui,
article 4. Please, your lordship, I have another question.
Please explain whether any person of a society could lead a respectable life where the courts are not allowed to function independently?
No.
Is it not a violation of fundamental rights?
Yes, and that has been held by your lordships. It is not it is judgments of your lordship of 10 judges, 14 judges. And I just will never.
सवाल तो हमारे सामने ये कि ये जो कानून है ये तो और ट्रांसपेरेंट कर रहा है हमारे सिस्टम को और आम आदमी की जिंदगी आसान.
सर देखिए, मैं एक आपको मैं और वजाहत कर दूं. हम बहुत जजमेंट ओरिएंटेड बन गए. मैंने जो हल्फ उठाया है ना, मैंने ये हल्फ नहीं उठाया. सर सुन तो लीजिए ना प्लीज. कि मैं जजमेंट्स ऑफ द सुप्रीम कोर्ट का पाबंद हूं. आप इससे मुखातिब हो जाए ना.
I'm with you.
कि मैं जजमेंट्स ऑफ द सुप्रीम कोर्ट के ताबे हूं. मैंने हल्फ उठाया मैं आइन और कानून के ताबे हूं. प्लीज मैं अपने हल्फ की वायलेशन नहीं करूंगा कि जी जजमेंट को आइन को तो छोड़ दीजिए. आइन तो हम पढ़ेंगे नहीं, जजमेंट पढ़ेंगे बैठकर.
मैं तो
आप जरा सुन लीजिए ना. इस मुल्क में कई बार मार्शल लॉ भी लगे हैं. میں ان ججمنٹ کے تابع نہیں ہوں. آپ سن لیجئے وضاحت سے, ہو سکتا ہے کوئی اور ہوں, میں نہیں ہوں, ٹھیک ہے. آپ 100 ججمنٹ مجھے پلیس کریں, میں ایک بھی نہیں پڑھوں گا. میں کہوں گا آئین پڑھیے. اگر آئین کے ان اکارڈنس وتھ ہے, یہاں تو یہ چیزیں نہ کریں. ریممبر دی ہسٹری آف پاکستان. ہم لوگ بیٹھ کے ادھر لمبے لمبے آرگیومنٹس کر رہے ہیں. 57,000 کیسز ایکومولیٹ ہو گئے ہیں. تو اگر ایک بہتری پارلیمنٹ سمجھتی ہے, ایک بہتری لائی ہے, آپ فوکس ہی نہیں کر رہے ہیں انفورسمنٹ آف فنڈامنٹل رائٹ پہ. وہ خواجہ صاحب چلے گئے, انہوں نے ایک فنڈامنٹل رائٹ کا تذکرہ نہیں کیا. آپ سے ہم پوچھ رہے ہیں کہ 184(3) پہ آ جائیے, پھر 191 پہ آ جائیے, پھر آرگیومنٹس کریے. بہت برا قانون ہے, مگر اس کے دائرے میں لائیے.
I proceed?
جی پلیز.
Article 4. I read, my lord.
فرمائیے.
To enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person of the time being within Pakistan. In particular, no action detrimental to life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. B. No person shall be prevented from or hindered in doing which is not prohibited by law. And C. No person shall be compelled to do that which the law does not require him to do. Now let us go on to the...
Not go on to do, develop an argument.
Well, allow me.
No, why have you read Article 4?
Your Lordship had asked me to argue the case according to the way that I want to proceed.
Yes, so please
allow me.
What is the violation of Article 4? What is the violation of Article 4?
My lord,
it is mentioned in the preamble of the Act.
I am making a submission to your Lordships.
کیا صاحب ذرا پلیز ایک چیز کلیئر کر دیں. آپ مانتے ہیں کہ یہ بہترین قانون یہی ہونا چاہیے, لیکن آپ کہتے ہیں کہ پارلیمنٹ کا اختیار نہیں تھا 191 میں. یہی پروپوزیشن. اب اس کو جس طرح مائی لارڈ کہہ رہے ہیں ایکسپلین کر دیں. 191 پڑھ لیں, اس میں اگر سبجیکٹ ٹو کانسٹیٹیوشن اینڈ لا ہے اور سپریم کورٹ میں ہے, شیل نہیں ہے. اٹ از ناٹ دا رائٹ آف دا سپریم کورٹ. اب اتنا بتا دیں کہ جو سبجیکٹ لا ہے, کیا وہ رولز, ان کا سٹیٹس اس پارلیمنٹ ریپرزینٹیو باڈی سے ہائر ہے یا لوور ہے. That's the only
Thank you, my lord. I am indebted to my lord. This is the proposition.
ایک آرٹیکل 4 آپ کہہ رہے ہیں, دوسرا کون سا آرٹیکل ہے وہ پڑھ لیجئے نا سارے آرٹیکل کے اوپر آ جائیں نا. پھر آپ
آرٹیکل 10A.
آرٹیکل 10
پڑھیے.
Article 10, sorry, my lord. 9.
ایسے نہیں نمبرز نہ دیں, بتائیں نا.
No person shall be deprived of life or liberty save in accordance with law.
آپ کی کون سی لائف لبرٹی لے لی اس لاء نے؟
سر ہمارے چیف جسٹس کی پاورز کلپ کر رہے ہیں.
وہ میں جانوں, اور یہی آپ کا کیا تعلق ہے؟
No sir, that is my perception. If your lordship may be inclined to, I'm going to persuade your lordship this is not constitutional.
تو بہت ہی نوبل آرگومنٹ ہے.
زبردست بحث کی کہ ہمارے چیف جسٹس کی پاور لے رہے ہیں تو انڈیپینڈنس آف جوڈیشری اور آرٹیکل 9 افیکٹ ہو گیا ہے.
Yes, the deviation is that a procedure other than the rules of the
Supreme Court. میں وضاحت کرنا چاہتا ہوں, میں نے آپ کو اپنا وکیل نہیں کیا تھا. شکریہ. لوگ یہ نہ سمجھ بیٹھے کہ آپ میری وکالت کر رہے ہیں.
I have to assist you the way the law in this country is developed.
چلتے آگے نا.
صدیقی صاحب, ایک چیف جسٹس آپ کے نہیں ہیں, اس قوم کے ہیں اور قوم کے نمائندے پارلیمنٹ میں بیٹھے ہیں. انہوں نے کہا کہ چیف جسٹس کو ایسے ہونا چاہیے, سپریم کورٹ کو ایسے ہونا چاہیے. آپ نے بتایا
آئین کو بھی دیکھ لینا پہلے.
آئین تو
آئین کے دیکھے بغیر,
آئین تو کہتے ہیں سپریم کورٹ کرے گا سب کچھ.
سر دس از واٹ آئی ایم سیئنگ.
تو آپ تو کہتے ہیں چیف جسٹس.
نو نو, آئی سے
آپ ابھی تک یہ ڈفرنس نہیں کلیئر.
نو آئی ایم, مجھے آپ الاؤ کریں گے پروسیڈ کرنے تو کروں.
سب انفورسمنٹ آف رائٹس
کون سی انفورسمنٹ کرنا ہے 9 کے بعد
10
میں کیا ہے
10 میں کون سا ہے؟ نو یہ تو
no person who is arrested shall be detained.
اس بات سے ہماری
سر مجھے آپ پلیز.
نہیں یہ نہیں آپ کہ میں صبح سے 1 سے 260 تک پڑھوں گا. نہیں سوری, یہ جو ہمارا ٹائم ہے نا, اس پبلک منی, ٹھیک ہے. آپ یہ نہیں کہیں گے میں جو مرضی آرگیو کروں, آپ اس کی ہمیں ریلیونس. سوری ایسے نہیں آرگیومنٹس ہوں گے.
صاحب جب آپ مان گئے ہیں کہ یہ بہترین قانون ہے. چیف جسٹس کے اختیار جو کلی تھے وہ نہیں ہونے چاہیے تھے. ان کا استعمال صحیح نہیں ہوا. اب اس کے بیونڈ آپ جائیں, آپ صرف اب یہ کہہ رہے ہیں کہ یہ پارلیمنٹ کا اختیار نہیں تھا. وہ بتا دیجیے گا.
میں نہیں مان رہا کہ یہ بہت اچھا قانون ہے. میں کیا یہ اس کا خیال بہت اچھا ہوگا.
آپ چاہتے ہیں
قانون
آپ چاہتے ہیں کہ چیف جسٹس کے پاس کلی اختیار ہو.
میں نہیں چاہتا. آپ نے دیا رولز کے اندر.
نہیں وہ آپ اس کو چھوڑ دیجئے گا نا. ہم نے
چھوڑ دی سر. آپ نے رولز
کیا آپ کے نزدیک ایک شخص کے پاس انفیٹڈ, انبریڈلڈ, ان اکاؤنٹیبل, انٹریملڈ پاور ہونی چاہیے؟ یہاں پہ the power has been given to the chief justice and to senior most judges.
یہ بہت اچھی بات ہے سر جو آپ کر رہے ہیں, بٹ کانسٹیٹیوشن چیف جسٹس صاحب کو بہت پاور دے رہا ہے. Let us have a look at Article 10. Article 10 تو دیکھ لیجیے سر.
ایک سیکنڈ ذرا اس کا فارمیٹ ٹھیک کر لیتے ہیں بحث کا. صرف ہمیں پہلا سوال ہم پوچھ رہے ہیں کہ 184 میں آنے سے پہلے فنڈامنٹل رائٹس واضح کر دیں کون سا وائلیٹ ہو.
Your Lordship held that when a law is made or election is taken which violates the constitutional scheme, it is a violation of fundamental right.
تو اسکیم میں کون سی پروویژن بتائیں نا
سر. میں آپ مجھے لاہو کریں
گے. آپ دے رہے ہیں اجازت بتائیے.
The law, the constitution requires under the constitution, and I will read the relevant article to some breather by your lordships, that in the context of the trichotomy of powers, the parliament will make its own rules, the executive will make its own rules, the Supreme Court will make its own rules for functioning, and those rules have a constitutional force and they are of a higher pedestal than the ordinary law. This
آپ نے ہم نے جو آپ سے شروع کیا تھا حقوق کی بات, اب وہ آپ نے ترک کر دی.
میں تو آپ جواب دیں.
نہیں جواب نہ دیجئے پلیز, آپ آرگیو کیجئے. ہم آپ کی آسانی پیدا کر رہے ہیں, بعد میں جواب دے دیجئے گا. کیونکہ آپ دیکھیں میں بھی وکیل رہ چکا ہوں, جب 6-7 سوال آتے ہیں بڑا مشکل ہوتا ہے. ٹھیک ہے, اب آپ نے پہلے جواب دے دیا تھا, بالکل قانون صحیح ہے, مگر جب مائی لارڈ نے سوال دوبارہ پوچھا, اب آپ نے ٹھہر جائیے نا, جیسے وٹنس کہتا ہے نا اگین سیز, جس کو ڈسکارڈ کر دیا جاتا ہے. تو ہم آپ کو بچانے کی کوشش کر رہے ہیں کہ آپ سن لیجئے, آرگیو آپ کیجئے, آپ کا کیس ہے, مگر بتائیں بنیادی حقوق کون سا سلب ہو گیا یہ بتا دیں بس.
اگر آپ اگر کو اپلیکیبل کرنے کے لیے پہلے ہمیں بتا دیں کہ کون سے فنڈامنٹل رائٹ کو انفورس کرنا چاہتے ہیں جو انفرنج ہوئے ہیں. پہلے اس پہ آئیے تاکہ وائی ناٹ 199 یہی پاور ہائی کورٹ کے پاس ہے, وہاں کیوں نہیں گئے.
I am asking your lordship to recognize my fundamental right given in Article 9, 10, 10A. سر میں نے پڑھا آپ کے سامنے.
بس یہی آرگومنٹ ہے آپ کا.
سر میں پڑھ رہا ہوں آگے.
نہیں آپ بتا ہی نہیں رہے, کوئی پروپوزیشن ہی نہیں ڈیولپ کر رہے ہیں آپ.
My proposition مجھے آپ my proposition is that the legislature is bound by the scheme of the constitution, and the constitution requires that
جب ہم نے فیصلہ کیا آپ سے سوال نہیں کریں گے.
The constitution requires that the legislature will make its own rules. The constitution requires
petition, یہ آپ نے ابھی بات کی, میں نے نوٹ کر لیا.
3 different organs of the state ہیں. They will function independent of one another. One will not make encroachment on the other.
یہاں تک پہنچنے میں ہم نے بنیادی باتیں تو پتہ ہے نا, آگے بڑھیے نا.
It is my fundamental right to ensure and protect that this constitutional encroachment is not made by the parliament.
سمجھ گئے, اگلا point.
And there are judgments on the issue which says that these are issues of fundamental violation of fundamental right, deviation from the constitution, and if it affects a large community of people, then it is a question of public importance. اور ججمنٹ ہیں آپ نوٹ کر لیں. میں سر ججمنٹ پڑھنے میں نہیں چاہوں گا, this is so fundamental a question. there are numerous judgments.
یہ اس بات کا تعین کرنا جی آپ کے پاس اختیار ہے, جیسے منصور شاہ صاحب نے ذکر کیا یہ اختیار ایکسپریس ہوتا ہے، یا تو ہم ریفرینڈم کرا لیں جہاں ہر مارشل اور ڈکٹیٹر کو 98.6% ووٹ ہمیشہ ملتے ہیں.
اچھا
سن لیجئے نا ذرا پلیز، تسلی رکھ لیں.
جی سر، نہیں سن رہا.
یا ہمیں کیا پتا لوگوں کو کیا چاہیے، اس کی عکاسی ان کے نمائندے، الیکٹڈ نمائندے کرتے ہیں. ٹھیک ہے، جس کو الیکٹ کریں ان کی مرضی ہے، وہ اس کی عکاسی کرتے ہیں. ہم یہاں تو کوئی پول اگر ہم ادھر کھڑ کر میں پوچھ لوں سب سے کاز ان فیور آف دس لا ہے، آپ کو کون حق دیتا ہے یہ کرنے کا؟ آپ کو یہ دیتا ہے کہ انفورسمنٹ آف فنڈامنٹل رائٹس کی بات کریں. آپ وہ بات ہی نہیں کر رہے ہیں. آپ نے بس 8 9 10 بس کوئی آرگیومنٹ ڈیولپ کیجئے. حضور ایسے نہیں ہوا آرگیومنٹ.
یور لارڈشپس
امتیاز صاحب ایک دفعہ پھر ایک چیز کلیئر کر دیں. اگر یہ قانون صرف چیف جسٹس کے اختیار کو ڈائلیوٹ کرتا ہے، آپ سمجھتے ہیں کہ یہ اچھی چیز ہے؟
آبجیکٹو اچھا ہے، پروسیجر انکانسٹیٹیوشنل ہے.
ایک سیکنڈ، اس کا مطلب ہے اس سے آپ کے اور پبلک کے فنڈامنٹل رائٹس انفورس ہو رہے ہیں. سیکنڈلی، اگر رائٹ آف اپیل دیا جا رہا ہے وہ بھی بہت اچھی بات ہے، اس سے وائلیٹ نہیں ہو رہا ہے، اس سے انفورس ہو رہے. تو اب
آئین کو مد نظر رکھیں گے کہ نہیں؟
سن تو لینا. اب آپ کا صرف کوشچن یہ رہ گیا ہے کہ جی یہ بہت اچھی چیزیں ہیں، آپ ان الیکٹڈ ججز کر لیں، لیکن وہ پارلیمنٹ نہیں کر سکتی تھی. بھلے آپ ریفیوز بھی کریں وہ پھر بھی بے بس ہے. چلے ہم آپ کی یہ بھی بات
بے بس نہیں ہے.
ایک سیکنڈ اب آپ بتا دیجئے کانسٹیٹیوشن میں ایگزیکٹلی 191 پڑھ لیجئے گا. اس کا مطلب ہے نو فنڈامنٹل رائٹ.
مجھے ابھی تک آپ نے نہ آرٹیکلز دیے ہیں نہ مجھے سبمیشن کرنے دیے.
بتائیے پلیز بتائیے.
آرٹیکل
4 9 10 10A
فنڈامنٹل رائٹ جو ہے اس کو ہم انفورس کرنا چاہتے ہیں. سر وہ پڑھیے پلیز.
سر میں نے آپ کو کہا ہے کہ when due process is not followed in making a legislation by the parliament, forget about the objective. And if I am able to demonstrate to your lordships that a constitutional deviation has taken place, then the question of fundamental right violation occurs. Whether it occurs in rem or in personam is the next question.
اب سمجھ آئی آپ کی بات. وہ یہ کہ قانون کا آبجیکٹو تو شاید عام آدمی کے لیے اچھا ہے، لیکن پروسیجر جو اڈاپٹ ہوا ہے یہ ہمیں بنانا چاہیے تھا، پارلیمنٹ نے کیوں بنا دیا؟ یہ سوال ہے.
اب آبجیکٹ
is not access to justice fundamental right now recognized as such?
Yes, it is.
Is not independence of judiciary an integral aspect of access to justice?
Indeed it is.
Therefore, is not independence of judiciary itself a fundamental right?
It is.
Is not independence of judiciary a salient feature of the Constitution?
It is.
Held by full court. Do you think every time the full court sits, that allows the Supreme Court, sitting as full court, to reset in the entire constitutional scheme?
It would be unfortunate unless it is done with valid
بات ہی
reasons.
نہیں سن رہے ہیں، سوال ہی نہیں سن رہے ہیں آپ، جواب تو آپ پھر وہی کر رہے ہیں.
In a system based on the common law UK tradition, is it just the black and white language of the Constitution that is constitutional law, or is that embedded in constitutional law as developed by the case law? In relation to the US Constitution, it is said that 9/10 of US constitutional law is not written in the US Constitution. And sitting as a full court, each time a full court is constituted, is that like a tabula rasa, a blank slate, that we can write on it whatever we want and disregard settled law, fundamental law, fundamental rights? Is this within the power even of a full court? If we are to do that as a full court, disregarding previous precedents, then surely we have to have some weighty reasons to declare, for example, today that independence of judiciary is not a salient feature of the Constitution, that independence of judiciary is not a fundamental right. If it is not a fundamental right, out goes access to justice. It's not a question of speaking for myself, but putting it as a question to you of whether it is the Chief Justice or the three-member committee. Who is Parliament to say it's a member committee? Why shouldn't it be a five-member committee? Why shouldn't it be a seven-member committee? If the answer is that the Supreme Court means the Chief Justice and all the courts, then Parliament should have made a law saying this committee shall constitute of the Chief Justice and all the judges of the Supreme Court. That is, they are the ones who will decide whatever is written in Section 2 and whatever is written in Section 3. Can Parliament pick and choose? Can Parliament say no? Judges is okay with us. 5 judges is too much. 1 judge is too little. These are aspects that go to the independence of the judiciary. Today, Parliament says not less than 5 judges to hear interpretation. Section कौन सा है वो आपका? Section 4. Tomorrow, Parliament says जी एक law बना देती है जी. I don't know. Family matters are to be heard by a bench of not less than 7 judges. Is that part of the access to justice?
May I?
Is that part of independence of judiciary?
It is.
Fundamental rights. Fundamental rights. अभी आप देखें अमेरिका में कितना वो बना हुआ है, वो जो है आपका राइट ऑफ अबॉर्शन, वो कहाँ लिखा है कॉन्स्टिट्यूशन में? लिखा है उनकी कॉन्स्टिट्यूशन? नहीं लिखा था. वो राइट दे दिया, पेनम्बरा में आ गया ना. उसके बाद उन्होंने कहा वो ओरिजिनलिज्म पे लोग जा रहे हैं कि जी बस.
May be raised, may graciously be raised once I've concluded my submissions. I'd be grateful. My lords, my first submission, your ladyship, my first submission is on maintainability of these petitions.
The Speaker,
My lord.
the red light is not on.
It is, but it's just, I've just pulled it closer. In paragraph number 6, page 3 of volume 1 of my submissions. Page 3, paragraph number 6.
Page 3, paragraph
6, volume 1. My lord, I've sought rejection of these petitions on the grounds on maintainability for failing to meet the test criteria laid down under clause 3 of Article 184, which is the matter must be of public importance, first. Second, it must relate to enforcement of fundamental rights. My lord, my first submission on whether these petitions raise or they raise any issue or question of public importance. My lord, my learned friends, the counsels for the petitioners, they have largely, their case is rooted in lack of legislative competence, not necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of government in terms of Article 191. And the argument, my lord, is that because the powers and because this honorable court in 1980 had made rules, therefore the field stands occupied and in any event could not legislate. My lord, firstly, insofar as public importance is concerned, my lord would have now gone through the law and my lord would see that this law in fact deals with the concentration of powers, barring one provision, but concentration of powers in one office. What this law endeavors to do is, it democratizes this institution, brings more transparency, and structures the discretion, which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, PLD 1990, Supreme Court 1092.
PLD 1990,
Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3. There was a question that was raised. I'd address it towards the end. and Section 5, which I will address separately. So insofar as public importance is concerned, this law, in fact, deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, my lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. In continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1935, which was the first constitutional order of this country under which federal court rulings in 1950 were made. Under Section 214, subsection 1 of Government of India Act, the federal court could make rules but with the prior approval of the Governor General at that time. And in 1950, the Governor General, of course, was neither part of Parliament, there was no constitution, but under the Government of India Act, Governor General wore several hats and executive authority vested in him and of course part of some legislative authority as well. Under the 1956 Constitution, Article 177 read with third schedule, Part 1, Clause 3, the rules were made with the prior approval of the President. There was not even a mention of any law as far as the 1956 Constitution is concerned. 62. Under 1962 Constitution, Section 60, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
In 56 Constitution, the rule-making power was contained in third schedule.
Yes.
Had to be read with article, I forget
what 177.
That said
subject to law and then...
No, that said subject to law, it said subject to Act of Parliament.
Act of Parliament, but I'll address that, which my Lord has just pointed out. I will address, my Lord, that question. My Lord, as far as... Just bear with me. Sir, by 1 second. I'll just... Article 177, I'd read it out, just for clarity. Until other provisions are made by an Act of Parliament. Third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an Act of Parliament is made with the prior approval of the President.
Rules were made
rules were
made under the 56 Constitution.
56 Constitution, an Act of Parliament was not made. 56 rules came with the prior approval of the President.
Is there any
so as far as...
Is there any difference between Act of Parliament and law?
I'll address that question, my Lord. This is a question that I've noted, I'll address it. Under the 1962 Constitution, Article 65, subject to the Constitution and the laws, Supreme Court could make with the prior approval of the President. And same position, it was same position under the interim Constitution of 1972, Article 193.
I'm sorry, my apologies to interrupt, but the question here is surely when Governor General is referred to and the president is referred to, that's the executive branch. The 73 constitution had the models from going back to 1935 up to 1972. It eschewed the controlling power of the executive branch. So surely the argument there is that the framers of the constitution expressly were trying to strengthen the independence of the judiciary, and at least, if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is reverse of what you are saying.
No, I'm coming to that.
Keep
I'm
it-
coming
keep
to it
that.
in mind. No, I have it in mind. I have it in mind. When I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened under Article 199. The executive action was.
It's a pointer in that of the direction in which constitutional law is traveling.
I'll address that. My lords, under Article 145, Clause 1, it is subject to law and with the prior approval of the president, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had.
In the constitution, these references, when they say subject to approval of the president, is it unilateral discretion of the president, or it is president advised by the chief executive, albeit the prime minister, who that is?
My lord, so if we look at the jurisdictions where we have this position, of course in India, he acts on the advice. And if, for example, under Article 191...
Government has the last say, not parliament.
Yes. It was, no, my lord,
But
without
there's a
yes, prior
distinction.
approval.
The prior approval of the president means effectively prior approval of the
executive
prime minister, not the legislature.
Yes.
You said that in the Indian constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by parliament.
Yes.
So it's not subject to law.
I will come to that
Constitution and the
when
law.
I take you
So there
to
is a
Article
distinction.
191. I'll come to that. I'll come to that when I take you to
I'm
191.
just clarifying जो आपने argument की.
My lord.
वहाँ ये नहीं लिखा हुआ.
जी, when I'll address subject to law, I'll be addressing.
You reproduce.
It's 6 and 7, yes, my lord. Now, in other jurisdictions, in United States, for example, this is 28 U.S. Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest development, or later development, is the Constitution Reform Act of 2005 of the United Kingdom. Now, under Section 45 of that act, the President of the US Supreme Court makes the rules, but is required to consult with the Lord Chancellor and all the bar councils while making the rules of procedure. So this is the progression, or this is how this is the system that we have in place.
2000 UK Act, does that
2005.
2005 UK Act, for example, do the rules have to be placed before the Houses of Parliament, or is there any involvement at all by the legislative branch?
There is none, but
He has to consult.
He has to consult. Now, whether
Other than the Lord Chancellor, who is a dying breed sadly in the UK system, but anyway, Parliament has made the law despite their rule of sovereign legislative supremacy. The Parliament itself has said it's got to be totally independent of us.
Yes, and for that now I take ownership to Article 191. Now this is where I will address what the term law means and what is the scope that this term has, and whether an act of Parliament would be actually covered under the term law or not, or whether we can give it a meaning where an act of Parliament would be excluded from the definition of law and everything else would come under the.
Why? I don't even understand this debate. Why is this? What is I couldn't understand the council. What was he saying really?
My lord, the council was arguing, began by referring to clause 1 of Article 8, where it said that any law or custom or using having force of law, etc., shall not be made, and then clause 2 said that places a limitation, embargo on the state to not make any law which is inconsistent with the provisions of this, with the chapter.
This differentiation between an act of parliament and law, what is the significance here?
My lord,
I missed the point. I tried to.
In my respectful submission, there would be none as far as Article 191
But
is concerned.
you were started by arguing on maintainability. Let's finish your argument. You're now addressing his arguments.
Gee, now what I'm on insofar as maintainability is concerned, my lord, my submissions are that this law actually addresses the public concern. It addresses the issue of public importance by bringing in transparency and by structuring the discretion and by democratizing this institution, by and transparency by conferring powers or by, let's say, devolving powers.
Both sides agree that question of public importance is addressed in this. The only question is now whether a fundamental right has been violated,
Yes.
and if a fundamental right has been violated, which fundamental right?
Correct.
Because question of public importance तो आप भी concede कर रहे हैं या कह रहे हैं कि है इसमें, आप उसको मुख्तलिफ तरीके से point कर रहे हैं जी public importance question है जिसमें हमने address किया. The other side doesn't agree, but the common denominator is there is a question of public importance.
I think my lord is correct. To that extent, you are in agreement. Now, the other limb of the argument, I mean, public importance is, in my opinion, a variable. The other importance is enforcement of fundamental rights. And other than that, I think the general, how the law is developed, a law is sustainable unless otherwise proven. So the burden is on the person who challenges a law to say what has been done. If he's invoked Article 199, his jurisdiction is wider of the high courts. You can attack income tax law, any other law in Pakistan for whatever reason you can, not limited to enforcement of fundamental rights. The attack under 184(3), leaving aside the public importance, and I think you both are probably agreement there, is a narrower attack. So the person has to come within attack on a fundamental right. What is the fundamental right that has been violated? Absolutely. Your arguments, what I could understand from is, rather than violating a fundamental right, this is a beneficial legislation for the litigant, not for me, not for the state. Everyone may benefit by it or none may benefit by it, but there's certainly, you're not taking away anything, that you are stopping a right of appeal, giving a right of appeal. Whether that can be done, that's another argument, constitutional plane, but that could be addressed in 184(3) or under 199, it's an argument. I'm seeing myself sitting in original, otherwise every case will just be filed in the Supreme Court. Don't bother about the high courts at all. If you read the jurisdiction of 184, can we just read it for my own benefit, because we tend to forget certain words of 184(3). We don't have additional powers, we have lesser powers in the high courts.
Clause 3, my lord.
पूरा पढ़ें.
जी.
One तो government वाला है ना.
जी. Should I read 1 and 2 as well? Yeah, 3 पढ़ दूं.
3 पढ़.
Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article.
In other words, which is the said article? 199. So the High Court, you don't have to go for a public importance matter. You don't have to go for enforcement of fundamental rights. You can still go to the High Court. Here, we don't have extra powers. We have the same powers as the High Court, but we have two restrictions: public importance and enforcement of fundamental rights. public importance is variable, let's stick to fundamental rights. So the power here is not a much larger power. So my reading of the Constitution, a much narrower power than the High Court. High Court may strike down this law, arguably. And then we can sit in 184 as an appeal. Then we have more powers. I don't know, am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the vires of this law.
Just to add to that, where a law deals with powers of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment where a specific question was raised, and my submission, respectful submission at that time was that yes, and I maintain that position.
But are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed. My lord.
I know you pressed for time.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So,
public importance with reference to the enforcement. With reference to the enforcement.
Here, fundamental, public importance, fine. Both parties are there. Now, had it been infringement, then you were right that there has to be a right which was infringed. Here, it's more wider. It's enforcement. They are saying that this is a matter which relates to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain? Can you expound on that?
My lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to that extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is on them, while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this law is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by way of this act, powers conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement, but however uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization of my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of public interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances, that public interest.
Attorney General.
And therefore, they fail on that threshold, that count as well. Where
Attorney
they,
General,
my lord.
on my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, क्या जो 184(3) की requirements है, वो fulfill होती है? Because there is no enforcement of fundamental.
Lord, if that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So taking
If we'll let you, I think a lot of questions are coming up. We'll note. I'll try to make a point.
These are, my lord, please.
But अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going. Okay.
Attorney General, if I may ask you a question, is it in the public interest that Parliament, or for that matter a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
I'm not
be
talking of
affected?
fundamental right. I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, if a law
Again, happening, which I must, interject. I would, you have agreed with, now here I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलें, फिर आप note कर लें सवाल.
I just, this part I just
General, if I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore, it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but
Just,
but
is it
any
in the-
law, a law
is
cannot
it
be
in the
struck
public
down on the
interest?
basis of just
Where,
being public.
where the challenge can be is a separate.
My lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law that is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने फिर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
Yes.
Public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
But
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
now let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184.3 on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights granted.
So you say that the word relating to enforcement.
With reference to the enforcement of.
That you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined under 190.
Is it not a right that everyone has under the Constitution
My
that
Lord,
laws are made in a particular way?
Legislative competence, of course, as I understand it, what you have to see in the act is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the Constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue and it is not permissible under 184.
In your opinion, the law is good law, Parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens again? I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it? Does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is it suspended?
I think my illustrious colleague has raised a very valid point, and I was thinking about it during the break. And if we read the right of appeal, first of all, it talks about an aggrieved person. Now, I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is, we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court. So that one can read down the legislation that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment, if at all, it's an irritation to us. Oh, now you have to have the appeal. Oh, now the review jurisdiction has been extended. So, what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think the 184.3, the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 183 can come to their rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain things that have been challenged before the High Court. Could we entertain it on 184.3? After all, it is a legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But It is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is the appellate jurisdiction. So if we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power, you've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, this person wants to waste money on another lawyer, do so. So his power will be lighter. What is it to us?
आगे बढ़े थोड़ा सा. Mr. Attorney General, if I may, take you back to what you were saying about, and I understand your point relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and that is, you say you accept that any law which is ultra is against the public interest, but you say the buckle is missing because it doesn't. It has to. It's not just legislative competence alone, but it has to relate to fundamental rights. So I was just wondering.
If I may rephrase it before my Lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that. So ये मैं ही कह रहा हूँ.
Yes.
But breach of legislative competence is contrary to the public interest. Until it is related to fundamental right, 184(3) cannot be invoked. यही आपकी argument.
जी.
So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your Lordship, so before this court under 184(3), these are the 2 things which are to be examined at the first instance. Now, once this threshold is met, then, and the burden is just discharged.
You Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights. आगे पढ़ें.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. Have your right of appeal been taken away? Your right of cross-examination been taken away? Have your right of a statement under 340 been taken away?
So that's where then it takes me, my Lord,
Mr.
and I'm just addressing your question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because ultra vires, it can't be due process.
So let's, proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is master of the roster or five.
I'll go with it, and let me just make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
they have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made our questions. You can continue. I think we have our own views and opinions. आप चलें आगे.
My Lord. Now,
you have to persuade us, not we have to persuade you.
Just one question I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been pressed under Article 185, another appeal would be available to the litigant for before a larger bench. Would that law stand?
Like, I would rather consider these.
Competence की बात
नहीं, yeah, let's consider what law did. Maybe tomorrow that very matter comes before us.
So the question is.
A second appeal. My Lord's question is whether the second appeal would be provided.
Not at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, be provided by ordinary legislation? The example I gave you was an extreme example.
Right,
the first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any provision in the Constitution preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो enlarge किया, पहले एक अपील थी, अब हमने दूसरी कर दी है, तो इसलिए ये हमारी competence में है. Would that argument stand?
Noted, my lord.
आप बाद में जवाब दे दें, आगे बढ़ते हैं.
ऐड कर रहा हूँ इसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
Noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General, please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can be
proceeded
under Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
How that can be moved before the Supreme High Court under Article 199 of the Constitution?
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act, 2023 Act, is covered under the definition of law, howsoever expansive definition, howsoever expansively the term law is defined. My lord, Article 260 has two definitions. One is of an Act of Parliament and the other is of a federal law. Here we are dealing with the federal law. Article 260 defines a federal law. It says...
You say over here law includes statute law.
Yes. Yes. In my respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of law.
If it's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles. And so you have to, the interpretation has to be given to the word law and not to just say, just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its legislative...
Why did you look at 75.3?
जी 75.3 and 141 and 142 as well.
पढ़ लेते हैं जरा उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the President has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura. So it is
happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is, federal law means a law made by or under the authority of Majlis Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says, the state shall not make any law. Now, the state is not just the parliament, the state is the province, the governments and the assemblies and any authority which has the power or is authorized by law to impose any taxes.
आप फरमा रहे हैं कि law, and you refer to the definition of federal law. It doesn't say federal law, it says...
It does not. What I'm saying is...
I have a question for you. Suppose Provincial Assembly under Article 191 law बना देती है,
Oh, 2000 के अंदर 2000 Supreme Court deals with that question. Yes, they cannot. The answer, because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55, so 191 or 175 too, for that matter.
Respect, I draw your attention to entry 58.
Relates to the federation also. Yes.
Kindly read it.
Matters which under the constitution are within the legislative competence of parliament or relate to the federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with Article 191. The power that is specifically conferred on parliament to make statute law and in terms of Article 191 is relatable to entry 58. Entry 55 has got nothing to do with Article 191. And this connection, first of all, excludes the example that I gave of a provincial assembly making a law over here, right? And secondly, it establishes that here there is a direct grant constituted by a specific article of the Constitution on Parliament, as opposed to the general grant as conferred by Articles 141, 142 and so on. That's a general grant. This is a specific grant. Because precisely it is a specific grant, it relates to a specific entry 58. So I would put it to you as a question that 51 has no relevance for the present issue.
Entry 55.
Has no relevance. This is a matter between, insofar as law is concerned, statute law, Act of Parliament, the connection is 191 and entry 58. I would say to you, entry 55 has got nothing to do with it. What would you say to that?
My
Keep
lord,
it in mind and move on.
Now, my lord, if my lords may kindly turn to Article 141. This is with respect to reference to the use of term law in Article 191.
Should be read with Article 260.
260.
Act of Parliament. So here is the word is law, so you can read together.
And 141 and 142 also is in continuum, my lord. 141. Subject to the Constitution, Parliament may make laws, including laws having extraterritorial operation for the whole or any part of Pakistan, and a provincial assembly may make laws for the province or any part thereof. Now, saying that the term law used in 191 can possibly exclude this act would be contrary to the entire structure of this constitution as I understand it.
Let me take you to the next point, which is, would it be confined only to an act of parliament, or could it also include case law? Because we know that judge-made law in a common law jurisdiction like ours is absolutely law. So, is it your case that law as used in 191, whereas in review jurisdiction it says Act of Parliament, talking about jurisdictions, powers of the Supreme Court. So when they speak of law, use law in 191, are they confining it to statute law, Act of Parliament, or is it both statute law and case law?
And I'll just, it's the same question, but just saying it differently. Your argument is that the word law includes this statute, this act of parliament.
No, sorry. Let me
The exclusion of anything else, we would read the act of parliament in the word law.
Yes.
So my question is,
Only act of parliament.
all right. So my question is, if that was the intent of the framers of the constitution, then why use the word act of parliament in some provisions, in some articles, and use law elsewhere? If the idea was that wherever we want, we could just read it, a law meaning just an act of parliament, and wherever we want, we can read law to mean anything and everything along with an act of parliament, then that would again be left to us to decide where we want to read, how we want to read it. But the constitution has given specific words to mean specific things.
भाई अब एक चीज जो आप देख रहे हैं ना, आप पता नहीं, I don't know. What about an ordinance? Ordinance is a law, but not an act of parliament. As simple as that. A president can promulgate ordinance. It is still a law.
It would be covered under the definition of an act.
So,
see,
267. Learned Attorney General.
Please look at
Learned Attorney General.
जो statute है या जो act of parliament है वो 260 में defined है, ठीक है?
जी.
267(7) देखें, उसमें law क्या है? Ordinance, rules, bylaws, regulations, letters patent constituting a high court.
This is existing laws.
Yes,
We've given continuation.
but law.
Yeah.
And any other legal instrument having the force of law. Now, surely, judge-made law is law.
Yeah, Learned Counsel.
with the greatest of respect, if it's observation coming from the bench, I have severe reservations.
I respond.
Because it's not a question, it's a statement. I want to disassociate myself from this statement.
I know the basis of this question and I will address it.
There is no such thing as judgment.
Learned Attorney General.
Mr. Attorney General, kindly read clause 2 of Article 260.
Learned Attorney General.
पहले जरा वो clause 2 of Article 260 तो पढ़िए. Clause 2 of Article 260.
Ji. Yes.
Clause 2, Article 2.
Ji, an ordinance is included, yes. In the Constitution, Act of Parliament or Federal Law or Act of Provincial Assembly shall include an ordinance promulgated. Yes.
Yeah, that Learned Attorney General, the Parliament and its supremacy is because of its representative character. Now, if there is a law, an act of the Majlis-e-Shura, and that is in conflict with the judgment of even a full court, whether that act of the Parliament will prevail or the judgment of this court.
My lord.
It will be the act of the Parliament.
And if there is a judgment which has been rendered on the basis of, and this is where the principle of legislative overrule flows from, that if there is a judgment expounding a certain provision of a statute or the rules, that judgment cannot be overruled unless the basis or the foundation on which that judgment came about is altered or removed, which is to say, if the law, underlying law is amended, then the effect of that judgment goes. And that is where, even if, for the sake of argument, the term law includes a judgment, if the underlying, if the rules which were expounded by your lordships in that judgment...
First of all, I didn't say judgment, I said case law. Judge-made law is different from judgment.
Case
that
law.
is precedent.
So Learned Counsel...
And also, जो आप जो अभी बात कर रहे हैं, extrapolating from that, is the rule surely कि an interpretation of the constitution or the establishment of a rule of constitutional law by the Supreme Court surely cannot be affected by Act of Parliament. It can only be if the constitution is amended or the court itself changes its view. Classic example, right of abortion. Added to the constitution, Roe versus Wade by the US Supreme Court, taken away as egregiously wrong by in Dobbs versus some other 2022. I think surely that is settled constitutional law.
My lord,
आप जरा please, if you don't mind,
I have to take your lordship to
आप
now
जरा please proceed further. I mean, we will write a judgment whatever we want to write.
Now, my lord, I will. My learned colleague will be recording the questions, noting down the questions, and I'll respond.
One thing, how I understand this. This is not my
Mr.
statement.
Rahman knows shorthand.
This is not my statement. This is my understanding. Act of Parliament can be considered as law as well, but every law cannot be considered as act of the Parliament. जैसे कि आप मिसाल लेते हैं, landlord can be landlord, but owner can be treated as owner as well as landlord. तो इस तरीके से ये जो legislation है, तो Parliament करती है, उसको आप law भी कह सकते हैं, act of Parliament भी कह सकते हैं, लेकिन जो judgment या case laws से आते हैं या customary law होते हैं, उसको आप act of Parliament नहीं कह सकते, तो इसलिए उसको confine किया गया, law किया.
कह भी नहीं सकते, my lord. और दूसरा एक और just let's look at it from another aspect. Now, 1980 is when these rules were made. And when these rules were made, if I draw your attention to Order 11, Order 11 को जरा देखिए.
अगर हम बहुत ही pedantic approach ले लें,
Order 11, my lord.
ये pedantic approach ले लें, ये किसने बनाए? किसने बनाए?
Supreme Court ने.
कब?
1980.
Supreme Court क्या होती है? नहीं, hang on. If you go into that approach, Supreme Court क्या होती है? बताइए.
All the Chief Justice and the judges.
Sitting at home? No, where? No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So it cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death before their appeals came up for hearing?
This is our domestic affair.
No, with great respect, my lord, it is not.
It is.
Absolutely not, my lord, with great respect. This is the right of the citizen, litigants ka right hai.
Learned Attorney General.
My lord, with great respect, it is not.
Resolve this.
It can't possibly.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the Parliament not intervene in the interest of the litigants? That is exactly what has happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say...
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? अपील इज अ राइट. Civil petition for leave to appeal is not a right. For an appeal, the rules provide 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is stay order of reason, I said, nahin, hum chutti pe jaate hain, hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So, The object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते हैं, वो भी इख्तियार चीफ जस्टिस का है। भाई 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000। हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, फिर हम तनख्वाह नहीं लें स्टेट से। हम टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है। तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं।
My lord, I just
ये जो आप पढ़ रहे थे कॉन्स्टिट्यूशन ऑफ बेंचेस का,
जी,
इसको पढ़े ना, ये सेव एज अदरवाइज प्रोवाइडेड बाय लॉ।
जी,
सो तो कोई लॉ था नहीं
जी, उस वक्त नहीं था। रिकग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ,
नहीं, आपसे ये अभी देखिए,
उस वक्त लॉ नहीं था।
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
नहीं, आपसे सिंपल, आर द 1980 रूल्स लॉ, कम विद इन द पर्व्यू ऑफ लॉ? 191
की डेफिनेशन क्या आप
Article 191?
No sir,
no,
these are the rules.
These are the rules. The language says subject to the and the law, the Supreme Court will make rules.
What is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the full court of this court left it open.
Now the law has been promulgated, and this covers under this provision.
Yes, not just this provision, it is covered under 191. This only recognizes what 191 already.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at
the Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to Parliament there was a executive as well. That role was taken away, that role was eliminated, but the role of Parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not
language.
You have not argued on Article 142 because this is the distribution of legislative power.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
with respect
to any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list of item 57, it is also related to
58.
58.
Yeah.
उसके साथ 55, sorry, 55
yes,
jurisdiction and power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50,
sorry,
item
Why
58.
is it not coming under 55? It says enlargement of the jurisdiction of
It
the
does.
Supreme
That's
Court
what I said, sir.
and the conferring up thereon of supplemental powers. So it
what
has
I
given us
submitted, sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the recording judge. 6.5 billion, isn't that a big enough mistake for us to understand?
That's exactly what I've submitted. Section 5 is covered under entry 55.
So you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more? You are not, please don't take questions. You just hear them, write them down, whatever.
Now, my lord, I just stick to the submission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Attorney General.
अब आप देखिए, हम आज से सुबह से कोई 150 केसेस की एडिशन हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want the system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं, पॉइंट्स ले, हम नोट करेंगे, हम आपको सुनने के लिए बैठे हैं, आपने इतने मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now I just quickly rush through my submissions and
my question that in order 11, the use of the word law or the term law, you think it carries the same meaning as in Article 191?
Yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle of the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been.
Call it a sharing of the burden.
Sharing of the burden.
It's a huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far as Section 2 is concerned.
Absolutely.
Absolutely. And because what it does is...
If I don't trust them, that's the only other way. I can't trust them.
It is in this time when
when
we want the justice system to be more efficient. It actually helps. There are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before you under 184.3. It is actually the appellate jurisdiction of this court which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this.
Yes, sure.
My lord, if the pendency is down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
0. But this is what is being sought to be addressed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of Constitution fundamental rights in 184.3. Otherwise, it can be ultra-vires of Constitution 199.
And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that Parliament not have the power to repeal this law?
Of course.
Oh, you see, you are saying this is a law
If
affecting
it
the
repeals it,
Baat
yes.
sunna, bhai, that this is a law affecting having such a salutary effect. It is having this, that, and the other. So someone can say, जी Parliament का तो power ही नहीं है, तो ये law को repeal कर दें. या फर्ज करें अगली Parliament आती है, वो Section 2 को फारिग कर देती है, वो कहती है जी Chief Justice का power है, वो that's good enough.
My Lord,
सकती है. आपसे पूछ रहा हूँ.
जी जी.
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा. मैं कंजूस पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा. ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे. मैं ओपिनियंस कभी नहीं दूंगा. आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे. आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना. हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म. हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा. भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे. बहुत सारी चीजें आप कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत. हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है. मेरी तो मुझे तकलीफ हो रही है. सुबह से 57,000 है. अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़ जाएंगे. आप चला लें एक महीना केस, हमें क्या फर्क पड़ता है. फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब अवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म. ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में. हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे. आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है. मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है. अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें इस कानून को, ये तर्क कर दें. मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे. कोई इख्तलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है. हमें आपको परसुएट करने की कोई जरूरत नहीं. आप हमें परसुएट कर लीजिए और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला.
My lord, my learned friend is questions.
No, sorry. I'm not indulging in conjectures. I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
My lord.
I'm not engaging in theoretical argument.
My lord.
I'm trying to understand the basis on which you are defending the constitutionality of this law. So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, would that is within Parliament's competence?
My lord, if that is so,
Learned
and if it so happens,
Yes,
Learned
not
Attorney
conjecture.
General.
This is to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
Absolutely,
General.
my lord. Absolutely.
Learned
it is
Attorney
in Parliament's competence. And if I may say so, my lord, my lord, I have
provided assistance.
I have as Attorney General. Ji, absolutely. Yes.
Mr. AG, to your right. Section 2 may it provided that the bench, constitution of the bench. Suppose bench is constituted. Who will assign the cases to the benches? Still this power has not been given in this act. Again, there will
My
be...
lord, the committee to determine its procedure and then it, with regards to how the meetings are to be, the committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if 2 members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
what would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how the meetings were to be held and the constitution of benches, etc. But that never happened because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was the first. My lord, this is exactly what under subsection 2 the committee is to do as the first
We will regulate through rules. They will regulate this act through rules. We
My
will
lord,
clarify it in
Ji,
rules.
the committee will determine its procedure, like the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is, an SRO or it's a rule or whatever they call it, but the committee can determine its procedure. It will be a procedure of the committee for the purpose of its functioning. Now, Section 3, my lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to determine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who first determined whether the matter was of public importance and relatable to enforcement of fundamental and then constitute a bench. This is this tension which my lord had also while authoring judgment, rendering judgment.
This doesn't answer the question whether the threshold of 184(3) is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that this doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My question is,
there's a distinction between what is filed under 184 and the suo motu, and that's why, my lord.
My question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response was that
further if providing guarantees, and my only question is, are we not accountable to the litigants?
Absolutely.
The Parliament is the representative of the litigants. If they want to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative. And we are there to serve the litigants.
And if I may, my lord.
Normally, you see, the cases would be marked by the Chief Justice, even if it's a 184(3). So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it, so judicial power is not in any way impeded, because judicial power comes after the bench.
Section 3 talks about invoking of jurisdiction, and that is what I was addressing.
Specifically states that the committee would examine. The word used is examine,
and that's what I was addressing.
For examination, if the committee is of the view that a question of public,
this is exactly
so it's a judicial power.
Yes. So
how can the committee on the administrative side exercise judicial power?
मैं यही आपको कह रहा हूँ कि if you are minded to hold कि ये जो overlap हो गया है कि administrative function और judicial function को control कर रहा है, you would have to inevitably hold that going forward there will never be a suo motu exercise of powers, because that's exactly what the Chief Justice to do. They would first examine it and then constitute a bench, और यही वो tension थी जो आप paragraph 53
Please take one question from this side, AG sir.
Oh, sorry.
The Article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship, says is the Chief Justice and the judges of the Supreme Court.
184 I'm talking about.
तो 184 में जो Supreme Court है, Supreme Court could जो है वो 176 से फ्लो करेगी।
जी जी।
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस। नो सिंगल पर्सन इज द सुप्रीम कोर्ट, इट्स ऑल ऑफ यू हु आर द सुप्रीम कोर्ट। सो व्हाइल एक्सरसाइजिंग ज्यूरिसडिक्शन, अब ये हो सकता है कि आप ये कहें कि नहीं ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, एंड देन
you mean to say that
committee that could be
Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that would be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
In continuation, and what remedy would be available to him, because this is an administrative order, they cannot be challenged in appeal except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss the petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. This is just to look at the
file. Why not? ये जो threshold है administrative side पे day in day out basis पे हमें cross करना पड़ता है litigants on this side. यहाँ पे objection आ जाते हैं registrar के कि जी ये meet नहीं.
What's been happening? Number of 184(3) petitions have come up. The office has put objections. Yes. Not the judge, the office.
Yes.
जी one very low.
बिल्कुल.
ठीक है, उन्होंने objection लगा दी. Not does not come within a parameter.
chamber appeal में जाना पड़ता है.
They've come to me, some of the absolutely ridiculous kind of petitions. They're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office is not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ की अपील है? कुछ भी नहीं है. End of story. ठीक है, तो यहाँ वो भी जुरिडिक्शन बढ़ गया है. वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पास हमें दे दिए हैं, उसके पास होना चाहिए असिस्टेंट रजिस्ट्रार के पास, तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा. जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज़्यादा उसको अहमियत दी जा रही है, रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184(3) का. राइट आपके सारे महफूज हैं, जो आइन देता है, जो कानून देता है. ये नहीं कि आपने 184(3) की पिटिशन डिसमिस कर दी, 99 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं. जो भी चीज़, यहाँ तो लोग अजीब अजीब चीज़ें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी. रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया. इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट. तो आई डोंट नो what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त क्या सिस्टम चल रहा है? 184(3) में सिस्टम क्या चल रहा है?
2 सिस्टम्स हैं. एक है कि जब कोई पिटिशन आती है, जब कोई पिटिशन फाइल होती है तो वो ऑफिस के इससे होके जाती है. रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट. इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि जी ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर. यू फाइल अ चेंबर अपील. सो दैट इज वन राउट. द 184(3) का दूसरा है सो मोटो. नाउ this provision, in fact, cures the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the 3 senior most, Chief Justice and 2 senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee, where the appeal lies.
It is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी. मगर
जी साहब आप ये बता देना कि अगर 2 जजेस या 3 जजेस बेंच चल रहा है, जैसे कि पुराना सिस्टम है, उसमें एक अगर 3 मेंबर समझते हैं कि दिस इज अ केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और चीफ जस्टिस इनकार कर जाता कि तीनों से एग्री नहीं करता. He has all the power, more power. 3 judges sitting in the court. The chief justice alone sitting in a chamber can undo this.
And the suo motu particularly, उसमें तो और ज़्यादा फिर problematic है. Because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं.
इसमें भी 3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe or whatever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide an appeal against
My lords
that
can
order.
suitably amend the rules
You
and
see,
perhaps
again,
provide an appeal.
the question is that since 1980 had not amended our rules, that is why the Parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the Parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती आप कर लेते. But what when we are refusing to do that? And that is exactly what has happened.
Being 43 years.
This act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all this.
You were too polite to say that.
My lord, we have section 4.
I've read that.
जी. Section 5.
अभी तक जवाब नहीं आया.
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी, उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the constitution. So aren't you adding to the constitution or amending the constitution without an amended
Mr.
amendment
Attorney
in the
General, entry
constitution?
55 says that we'll enhance your jurisdiction. तो उन्होंने एक और 84 की अपील बना दी है. तो enhance नहीं होगी
185 की भी फिर एक और अपील बन सकती है?
बना दें.
बन सकती है. सेकंड अपील तो है, हमें वैसे भी बताया हुआ हमने कि
Speaking for myself, Learned Attorney General, Learned Attorney
Why
General,
not a
speaking
third
for
appeal?
myself.
Why not then a third appeal or a fourth appeal or a fifth appeal?
It's the Parliament won't do absurd things, and
No,
of
it's
course,
not a question, no, it's
you
not
know,
a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
it surely does.
Exception, no, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया.
नहीं, infinity नहीं है.
Parliament
Obviously, you know, we're talking about the Parliament here.
देखिए,
We're
Mr.
not
Attorney
talking
General,
about.
आप बात फिर आ जाती है conjecture और theory और ये और वो. बात principle की हो रही है, असूल समझने की है ना. एक दफा एक बात को concede कर दिया जाए, accept कर लिया जाए, in principle then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist.
Lord,
This is the
great
point.
respect. I would
लेकिन ना review
disagree.
jurisdiction भी है ना. Review jurisdiction का क्या concept है कि सुप्रीम कोर्ट में finality हो गई. अब आप maximum में review कर रहे हैं. वो हमने
You know, with great respect, when it comes to even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can you go to the next point?
जी.
I'll only add to this, Learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided.
184.
in 184.3, which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And,
so see how
and in a context where this court becomes the first and the final court in the same proceedings.
That's done? Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions. And I have placed on with my paper book the judgments of in Baz Mohammad Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to...
there was one concern also expressed by Justice Aisha Malik, which was that if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे एंगल देखे होंगे, एड्रेस करना चाहते हैं।
उसमें एक ये बात है, मैंने अपने रिटन सबमिशंस में ये कहा है कि आप इसको टू दैट एक्सटेंट रीड डाउन कर लेंगे।
इस हद तक रीड डाउन करें
जहाँ पे फुल कोर्ट होगी, नेचुरली अपील जो है लिटरेट हो जाएगा, बट आप उसको ये कर सकते हैं। सॉरी सर, just
I'm saying if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My Lord, ये अब 15 बैठे हुए, so मैं जैसे so if it was in original proceedings, it was a bench comprising of 7 lordships on this side. The appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
आप देखिए ना, इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. पर अभी 15 जज हैं, ठीक है ना? फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9 मेंबर बेंच बन जाता है, फुल कोर्ट तो नहीं है।
My Lord would be mindful
बात
of
सुन रहे, ये हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब। फर्ज करें 3 मेंबर कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 मेंबर बेंच बना देते हैं। आप देखिए ना, आप इसको एड्रेस कीजिए ना, ये ऐसी बात नहीं है कि जी द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया।
What I'm submitting is that now it's a ड्यूटी कास्ट हो गई है इस कमेटी के ऊपर।
अपील
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना। नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट, तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना। व्हेनेवर इट वांट्स टू डू समथिंग वो राइट ब्लॉक करना चाहेगी। What you are saying is that substantive right that you have created under the statute is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं। तो फिर आपने ये right दी किस मकसद के लिए?
8 member bench बन जाए, 9 member bench बन जाए, right of appeal खत्म हो गया।
So let me just
I think what we can do is we can logically interpret the legislation. Now, for instance, when this case was first heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So, unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई।
Actually जब वो CMAs थी फुल कोर्ट के लिए, जब आर्ग्यू हो रही थी, तो उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं फुल कोर्ट बनाई जाए, आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए, आपको तो कहना चाहिए this matter should be heard by lesser number. वो CMA की वो हेयरिंग पे नहीं गई, but
But the burden
And
at the end of the day was
question
on us.
Question was in fact put by me.
My Lord,
And so therefore it's not that the question was not there.
My Lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशीट पढ़ने के बाद महसूस हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है। अगर ये इनफील्ड होता तो शायद 8 मेंबर बेंच उस वक्त भी ना बनता। इसका मतलब ये कि हम एक्ट को मान रहे हैं, अगर हम बेंच पे एतराज़ करें इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 मेंबर बन सकते, व्हाई नॉट फुल कोर्ट।
So, मैं इसका brief एक response दूँ and then followed by a detailed response in writing. Briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती।
In cases, in circumstances हो सकता है, जैसे अभी भी है।
प्रकाशंस तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से।
So let me put it differently.
ये
now
फुल कोर्ट कभी बैठ ही नहीं सकती।
नहीं, फुल कोर्ट आप बैठेंगे।
In Article 184 questions which are the most important question that can ever be raised before the court.
In exceptional circumstances, it might be so. But does that is that to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to have the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. There is no, I mean, doesn't really, it can be easily
It can be reconciled. My Lord, Section 6, right to appoint.
Section 5 can be read down.
My Lord, to that extent, my Lords can hold that in exceptional cases and when a situation this sort arises, that be so, my Lord.
Right of appeal पे substantive right नहीं है, जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not. And all of that has happened under 184.3. With great respect. And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How those were full court judgments?
My Lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना।
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है।
साहब यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things, दूसरी तरफ कह रहे हैं चलो full court बन जाए तो बन जाए।
full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी
नहीं, there might be issues in time.
Applications of your submission तो kindly
उसको ये इस तरह से आपको कर देता हूँ कि आप ये balance आप रख लेंगे।
Attorney General साहब, we are all grown ups, right?
Attorney General साहब,
can I just the problem arose. I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say there has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are about full courts only. What about the three-member bench judgment? It was a three-member bench judgment which did recodic. It was not a full court or even a large bench. A three-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy. We don't understand the repercussion of things. Fine. I'm not saying that judges who decided that they did what they thought time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review, unanimous, because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज़्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस legislation की भी ज़रूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियाँ कर ली. हमें देखिए हमारा problem ये हो गया ना, अनबड़ी बन गई है और तकब्बुर. हमसे गलतियाँ हुई हैं, मुझसे गलतियाँ हुई हैं. मान लें गलतियां हुई हैं, ठीक है, हमने ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है, ठीक है, अदरवाइज आइन की कोई हैसियत नहीं है. अगर जज मेड लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. द मिनट आई से दैट प्लीज फाइल अ against me that I'm violating my oath of office if I say even this, कि I will endorse these subsequent acts. तो हमें मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है, उनको हमारा फिगर पढ़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 petitions आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं. वो कहते हैं हमारा केस चला के. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. But what are we doing? What are we taking away from him? Focus on that.
Nothing, my lord. And section 6, my lord.
इसमें Attorney General साहब, Attorney General साहब, Law Reforms Ordinance के तहत there's a right of appeal. लेकिन कई cases में, depending on the issues, the high courts constitute larger benches, and therefore that right of appeal is not availed. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है, 184.3 is discretionary. Now, यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज है, वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में, जब ऐसी सिचुएशन आ जाए तो अ जज फ्रॉम द हाई कोर्ट कैन बी आस्क्ड टू एक्ट टेम्परेरी जज ऑफ द सुप्रीम कोर्ट. तो वो आपका एक्ट कहता है कि लार्जर बेंच विल हियर द अपील. सो एड वन जज, this is larger bench, appeal is there. No problem. I think problem is solved by the constitution.
The remaining judges would be the same.
Yes, of course.
फैसला तो वही आएगा.
This was just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under section
provision
7.
of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have to see
देखिए हम सारी बात ठीक है मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? वी द होल विल बी गटेड.
How many cases would there be, my lord?
And no limitation period is here.
ये तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been
ख्याल रखा करें ना, आप रखिए, आप लाएं
what the parliament has,
चलो ठीक
my
है.
lord, what the parliament has tried to address here is
So you see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185 73 से शुरू हो जाएंगे.
My lord, 1947 तो नहीं, 75 में पहला हुआ था.
एक बात है, अब आप इसमें clearly open-ended ना,
and then
you have fixed a limitation of 30 days for filing appeal prior to commencement of this act, means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होगी because the law was
सस्पेंडेड. ओके
couldn't have taken effect.
फिर एक और छूट जाएगा ना.
ये बताइए कितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है? Can the people of this country file appeals and have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do
my
we
lord,
fear
just
if
to-
it's...
Otherwise,
history,
we'll
I
be brushing
think-
things under the mat.
1975 Manzoor Alai was the first case under 183, and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps
But where
पिछले
do you
15
draw
साल
the
में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be.
Let it
Why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because he's dead or whatever, long past. Go on.
My lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail
ये एक section 6 पे भी बता दीजिए, Learned Attorney General,
My
ये
lord.
जो आपका
Right to counsel.
Yes, because it
Now-
is already covered under Article 188 of the Constitution.
उसमें order 26 है.
Power of the review.
जी, order
So you
26.
have said that the party shall have the right to counsel of its own choice.
पहले जरा
Counsel.
my lord का 188 पढ़ लें जो refer कर रहे हैं my lord.
188 is the Supreme Court shall
पढ़ लें जरा.
have power subject to the provisions of any act of parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review.
Council का
Change of
provision rules
counsel.
में डाला गया है ना.
The order 26, rule 6. The order 26 deals with the review, the Supreme Court rules. And rule 6 is the rule where the court.
No, I am only asking about the change of counsel, why this provision has been created, because the new counsel will come and he will argue the whole case as an appeal, because you know the scope of the review. Normally, the counsel who appeared originally, he came in review and we hear him. New counsel will come with new fees and with new motivation and new energy. Then he will try to argue the whole case again as an appellate jurisdiction.
And actually, the wisdom.
एक second, I think my lord has made a very valid point. If I was to sit in a court, first question I would say, yes, where did you take this point in your pleadings?
Yes.
And if he hasn't, he hasn't.
Hasn't.
I mean, my
And if-
answer
if
to
there are
him
no
would
written
be, he
submissions
can't,
filed,
arguing is like arguing, but we will go by the written, you didn't take this point, खत्म जाओ भाई,
Yes.
वो review में वो appeal का power नहीं हो जाएगा उसके पास.
Review नहीं
तो
grounds.
उसकी विजडम यही थी ना कि काउंसिल The same bench, same counsel.
Same
They would know what
settings,
transpired last time in the hearing, what questions he had agitated.
अपनी भी wisdom.
My lord, ab jaise, for example, I am assuming that the proceedings of this courtroom are transcribed and they are, we have the transcripts desired or required. Technology can be used, but that said, if there are submissions and obviously people file their concise statements or they bring their petitions, file their responses or make written submissions, nobody can go beyond that. Now, if a council, the new council comes before your lordships and make a point which is beyond the pleadings before your lordship or any written
What is the
submission
purpose
filed,
of introducing this section? Why new council? We totally
Lawyers demand. मेरे ख्याल में lawyers demand थी.
वो वाली बात है जो मैं
अभी वही सवाल आएगा कि what is the fundamental right which is
Lawyers का demand था या किसका litigants का demand था?
philosophy क्या है इसके पीछे नए वकील को लाने की?
My lord, न्यूयॉर्क बार का जो इम्तिहान होता है तो उसमें कोई 35% हर साल में 2 दफा होता है तो फेल हो जाते हैं. जो हमारा यहाँ पे जो सिस्टम चला आ रहा है उसमें there is lot of issues, so मैं मजीद नहीं कहता. बता दिया आपको.
Mr. AG, AG sir, towards right. 188 says subject to Act of Majlis Shura. Whether any act has been promulgated to regulate this article prior to this act. Is there any act?
My lord, there was an act, review of judgments in order to not, this particular provision actually was also included in that act and a 3-member bench struck that law.
It was subsequent to this law. It was not prior to this act.
Subsequent to this, but it came decided before.
There was no act. There was no act.
No.
So the things were going on unconstitutionally.
Under Order 26.
Unconstitutionally because the Constitution says to
act and the rules. And the rules.
Both,
so there was Order 26.
There is no or, there is and.
And.
So both must be there, act and the rules. So where is the act?
My lord, here you would read it interchangeably perhaps, but in order to protect Order 26 and the Supreme Court rules, and it was being regulated.
So one question I have of a general importance. When I'm sitting in a court of law, am I bound by the Supreme Court rules? Or rules are an aid of administration of justice, and rules bind the counsel and the litigants but does not bind the court? What is your position on that? Am I bound to follow the rules of 1980? I mean, like for instance, Order 33 says I can condone delay, I can do various things. So it is there to be followed by litigants and counsel, but there may be cases of extreme injustice. We may overlook, for instance, in criminal matters, we rarely even ever dismiss things on grounds of limitation, though it is provided that it has to be filed within a certain period of time, because the liberties of the subject, we haven't given a decision on it. So, but I think rules are really to show us, guide us, not really to bind us.
Actually, rules acknowledge this. Order 33, Rule 6 actually says so.
That, overall
it says that rules shall, nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the court.
At the end of the day, it's not so important, significant document.
My lord. It is practice and procedure. These are all.
और वो भी हमने Order 47 को connect कर दिया in civil proceedings, civil procedures court के साथ. So these are not, I mean, these are not like ironclad things, but we cannot. We'll see where the justice of the cause lies, and of course, it doesn't mean they're totally irrelevant. So we will see when it's appropriate. It may be case, it may be bad case. I don't know. So, आपका you conclude या कुछ और रह गया?
My lord, I have concluded.
Attorney General, if I
in
may
writing.
ask a question, if I may ask a question.
Well,
if you are not bound by the Supreme Court rules in terms of whatever the Supreme Court rules say, but we are bound by Act of Parliament in regard to our own practice and procedure, do you think that is a constitutionally viable position?
My lord,
then if the rules are made by the full court on the administrative side, and any particular bench can say, well, goodbye to the rules, why shouldn't that bench have the right to say goodbye to the act?
My lord, my response to that would be that both the preamble, from which we draw those salient features.
I think the thing is
the independence
that when the Supreme Court is sitting as a court of law, what is it bound by? If it's not even bound by its own rules, Why should it be bound by act of parliament?
My lord, the
We can
rules,
say then
the
maybe,
rules, the
then
rules
maybe
say.
that particular bench can say, well, we don't recognize section, what is it, section 6. And another bench can say, well, we recognize section 6.
My lord,
I mean, why should not your, this law that you're defending,
I think the
not
rule,
that be put in the same category vis-a-vis our own rules? If we are not bound by one, why should we be bound by the other?
As I view it, I think priority number 1 is constitution. Number 2 in scale of importance is law. Number 3 is rules. Then come regulations, then come notifications, then come whatever you want to, instructions. So this is, in my mind, I go by that approach. I may be wrong.
My lord, the rules, actually, Rule 6 of Order 33 itself acknowledges that.
I think the constitution actually
abuse of process नहीं होगी, ends of justice को meet करने के लिए you're not.
Attorney General, the rules actually come out of the Constitution, and Constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we bound by them. And they might be in the trajectory starting with the Constitution, law, and the rules, but all of them are binding, and that's how the system works.
And my lords would also acknowledge that this is not a case where Article 199 per se has been challenged on it being violative of salient features for that matter. Of course, even if that was so, both 191 and the preamble from which the salient features flow were enacted at the same time. It is not a subsequent amendment where relying upon Kesavananda Bharti or DBA Rawalpindi matter could have proceeded. So when the preamble, when the constitution was being made, 199 has not undergone any amendment ever since. So therefore, my lord, my respectful submission would be that this act, my lord, be declared constitutional and the petitions be rejected to that effect. And nothing in this act in any way undermines the independence of judiciary nor has any externality been introduced where any other organ of the state or branch of government has been given any role whatsoever.
Hopefully these are your final words. Hopefully.
I'm going to have it answered.
Attorney General sir.
My lord.
आपने कंक्लूड तो कर लिया, बस एक क्वेश्चन पूछना था कि अगर फर्ज करिए कभी इसको हम अल्ट्रावायलेंस डिक्लेयर कर देते तो बात ख़त्म हो, लेकिन अगर इसको हम कहते हैं कि वैलिड लॉ है, वैलिड लॉ हो जाएगा वहाँ जब ये बना था, इन बिटवीन जो फैसले हुए हैं, व्हाट इज द फेट ऑफ दोज डिसीजंस?
My lord,
अगर वैलिड करते हैं तो फ्रॉम दैट डेट होगा, तो फिर क्या होगा? इसके बारे में आप बता दें.
They become past and closed transactions in several instances in the past where a similar situation or a situation arisen where a legal position had changed, but cases were decided or transactions had happened. The courts protected those under past and closed transactions. So that would be the effective matter which stood decide. Which
can the committee not retrospectively, suppose if the law is sustained, can the committee not retrospectively grant permission? The bench was constituted, assumed as if by consent. Let's put it like that. I don't know if that's possible or not.
Stand decided.
As if by consent. Let's put it like that. I don't know if that's possible or not.
Cases which stand decided, they stand decided.
अगर हम ये भी कर लें कि अगर कोई बहुत ही ऐसा unusual case आ जाए, I don't know.
My lord, I don't know where the line would be drawn, but in so far as
I think
जी मैं इसको भी एड्रेस कर दूंगा.
ड्यूरिंग द पीरियड की बात हो रही है ना,
जो केसेस
इस दौरान जो हुए फैसले हो गए, उनका क्या बनेगा?
So जो केसेस लिस्ट अब पेंडिंग ही नहीं है और वो डिसाइड हो गए हैं केसेस
during this period.
जी पीरियड, उसको अब आपको देखना होगा कि उसको आप पास्ट एंड क्लोज में प्रोटेक्ट करते हैं जो फैसले हो गए.
इतना पास्ट नहीं हुआ, अभी कई बात है
वो. I think that is something that my lord would have to see if my lord wish to protect them.
Thinks of all the angles. This is possibility, that is possibility. So this is a possibility. We're just airing it. We don't know the answer.
उसमें दो चीजें हो सकती हैं. एक तो डिफेक्टो डॉक्ट्राइन को हम देख सकते हैं, दूसरा राइट ऑफ अपील हो जाएगी So they can, जिनके
as far as 184.3 is concerned, उसकी होगी, जिनकी नहीं थी 184.3 वो तो सिर्फ बेंचेस की कॉन्स्टिट्यूशन तक रह जाएगी बात, उसमें आप देख सकते हैं कि वो तो
It won't be a classic, देखिए दो किस्म के होते हैं, एक होता है classic quorum non-judice, ठीक है, this won't fall in that category. It will be simply a procedural lapse, whether a procedural lapse will affect the outcome.
The cases which stand
I don't know, I mean,
if I may
क्योंकि एक होता है ना सब्सटेंटिव राइट किसी की गई, बोले आपका क्या राइट किया,
वो डिसाइड हो गए केसेस, वो पास्ट एंड क्लोज
नहीं पास्ट एंड क्लोज का लफ्ज क्या अगर हम कहें, देखिए एक होती है यू सब्सटेंटिव राइट हैज बीन टेकन अवे, भाई ओके दीस थ्री डिडंट हियर इट, दोस थ्री हर्ड इट, आपको क्या फर्क पड़ रहा है इससे, are you with me? So I'm just thinking aloud.
Understood. So it does not, let's say, there's no, it's substantially कोई offend नहीं किया किसी right को, कोई, it was a matter of procedure.
और अगर कोई जैसे कहा कि कोई बहुत ही चीज हो गई ऐसे, वो रिव्यू तो पड़ा हुआ है फिर भी, और या अपील पड़ी हुई है 184 में, तो
And in any event, I mean, it was a bench comprising of your lordship.
No, we don't want to kind of create a situation where things don't function. So भाई वो उसको क्या पड़ेगा, चलो आपने मेरा अदालत में सुन लिया या सरदार साहब की अदालत में सुन लिया, कोर्ट तो थी ना, वो तो गलत quorum non-judice होता है ना, गलत अदालत अब चलेगा, इख्तियार ही नहीं था to begin with, हमारे पास इख्तियार तो था, बस सिर्फ वो एक practical procedural matter that would be really for us, not for the litigant, उसको क्या पढ़ना है?
No, I would say, my lord, and that I think to that extent,
I don't think that it will affect the decided cases. It has become past and close.
I think that's the only fair conclusion that we can arrive at insofar as...
We're just going to take a short break. Let Khwaja Saab and others, and any other from the petitioner side, I see Mr. Bhandari. You are for the petitioner or the...
Your lordships had put various political
parties... No, who are you for?
I am for PTI.
Which side of the divide?
I am supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the Parliament.
I would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, अगर why are you depriving us the pleasure of hearing you? Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं. तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं. And we'll just come after. Short, I think prayer time is also there. Short break, huh?
And if I may be granted leave, I have to.
As long as you leave somebody here who will know all the things, and then, if required, submit the. If you think, if you don't want to, we can't force you to submit a reply. But it may be in your interest to do so.
Mr. Attorney General, best wishes from all of us on the assignment that is on. It's in the national interest, and it's very important for Pakistan. So our best wishes.
My lord,
I hope you are well prepared.
22 questions मुझसे पूछे हैं जी. You asked me.
आते हैं वापस आते हैं.
नहीं, 22 questions में you like me to ask you answer now, or you want me to give me some time to.
नहीं, हम जरा वापस आ जाते हैं, फिर आपको कुछ सुनते हैं. अगर कोई बहुत ही पेचीदा सवाल हुआ, फिर हम देखते हैं.
पेचीदा सवाल तो सारे ही हैं.
But देखिए, petitioner always comes prepared of all the questions कि ये सारे आ सकते हैं. तो वो देखें, other side can say that, but you are the petitioner.
May I say something?
जी. देखिए, ख्वाजा साहब जरा बात समझने की कोशिश करें ना. The functioning of the Supreme Court has ground stand still. I don't want that to continue.
मुझे आप इजाजत दीजिए.
ठीक है.
मैं ये 22 सवाल जो हैं, मैं इनका जवाब लिख के आपको दे देता हूँ.
चलिए, आप हम वापस तो आते हैं, इनको तो सुनेंगे ना भंडारी साहब को. शायद आप मुतमईन हैं, ये ऐसी जबरदस्त बात करें आप.
भंडारी साहब को जो है मेरे पास आ चुका है जी. मुझे आप इतनी दीजिए.
देते हैं, वापस आके देते हैं. देखते हैं, सुने तो कुछ थोड़ी बात.
देखना तो ये है ना कि पार्टीज क्या कहती हैं, वो पार्लियामेंट की सुपरमेसी चाहती हैं या नहीं चाहती.
सुनकर मौके पे हमने नहीं सुना अभी तक. अच्छा, थैंक यू. यू कैन गो देन लीव समवन हियर कॉम्पिटेंट. हाँ, थैंक यू.
ओके, थैंक यू.
15-20 मिनट.
15 मिनट.
What did you decide against us?